So chapter 4, fair housing. We're going to get started on right now. In this chapter, we're going to talk about the protections of the federal fair housing laws, including enforcement. We're going to talk about protections of the New Jersey law against discrimination, including state regulations on rentals, and the implications of the fair housing laws for us as brokers and salespeople. Now, federal, state, and local laws about human rights and fair housing affects rentals and the sales at every phase of the real estate transaction from listing to close. And failure to comply with those fair housing practices are not only grounds for loss of your license, but also is an unlawful act. So here's a basic rule of thumb to follow. Anytime two laws cover the same topic, the more restrictive rule will always prevail. So we always follow the more restrictive rule. So why do we have fair housing laws? Well, basically, so everyone can have equal rights of an opportunity to have a place to live, own, or rent. That doesn't mean that everybody has the same guarantee to the same outcome, just as equal rights to the same opportunity. For instance, that doesn't mean that I can live in a mansion. Well, I mean, I can if I get a job that I make enough money that I can afford it, just like anybody else. But if I can't afford it, then I can't live there. So we don't have the same rights to outcome, but we do have the same opportunity, rights to the opportunity to have a place to live or rent, own or rent wherever we want, and be able to own personal property like the clothes on your back. And any violation of these laws is considered a criminal act. So let's start with the Civil Rights Act of 1866, the oldest one. What happened way back in the 1800s pertaining to civil rights? Anyone recall?
No.
In our country, in the 1800s, there was a major thing. Had to do with slavery. Remember the President Lincoln was the president at the time, and he was the president that.
Abolish.
What's that?
Freedom.
Yeah.
Yeah, abolish slavery.
Yep. He the Emancipation Proclamation and all that. He freed the slaves and said that all humans have the right to be free and have a place to live and own property, including the clothes on your back. Right. So that was the Civil Rights Act of 1866. So this law was an outgrowth of the 14th Amendment of the United States Constitution that prohibits any type of discrimination based on race and color. It says that all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. All right, so what did we highlight so far? Civil Rights Act of 1866 prohibits any type of discrimination based on race and color, and this law covers real and personal property. There are only two types of property on this planet. Real means real estate, or personal property. I'm sorry, do you have a question?
Yeah, well, is this the first page of chapter 4?
No, you could turn to page 68. This is on page 68.
All right.
The second page of chapter 4.
Thank you.
So because of the reference to white citizens, this law has been widely interpreted to prohibit discrimination based on race and color. Now, in 1968, there was a Supreme Court decision versus Jones versus the Alfred H. Mayer Company. Jones was an African American, and he was trying to buy a property or rent a property. I forget the details of it. They removed it from this version of the book. and they just mainly make a reference to this Supreme Court decision, where Alfred H. Mayer Company says that, well, there are some exceptions in the law, or he tried to discriminate against Jones, who was an African American, based on his color, his race. So he didn't want to sell him a property or lease him a property. And the Supreme Court decision in 1968, because Alfred H. Mayer Company said, well, there are some exceptions to the law for the Civil Rights Act of 1966. 66 or 68. So it all went all the way to the Supreme Court, and the Supreme Court said, yeah, although the 60, what's it? Let me take a look. Is that 66? 68, I'm sorry. Brain fart. Although the 1968 law has some exceptions to it, the 1866 law does not, when it pertains to race. So when it comes to race and color, there are no exceptions to the law. So just because the 1968 Civil Rights Act has some exceptions to it, that doesn't mean that you could discriminate against this person because of their race and color. So once again, that just solidifies the rule that when two laws cover the same topic, the more restrictive rule will prevail. You always follow the more restrictive rule. And you can always fall back on the Civil Rights Act of 1866, even though it's an old law. That old law has protections in there. So there's no exceptions when it comes to race or color. Okay, everybody got these highlights? So we should know that the Civil Rights Act of 1866, that oldest one from the 1800s, you don't have to study the exact year, but the Civil Rights Act, the oldest civil rights law, the one from 1866, it prohibits discrimination based on race and color, and it covers both real as well as personal property. Real is real estate, and that covers residential, commercial, raw land, etc. Personal properties like your car or your clothes on your back or your tools or any gadgets that you own, So there's only two types of property on this planet, and that is real and personal property. And that all type of property is covered under this law. All right, so that case, Jones versus Mayer, said there's no exceptions for race or color. When two laws cover the same topic, the more restrictive rule will always prevail. So that 1866 law is part of the 14th Amendment, and it grants equal rights to all citizens for ownership of both real and personal property. That's all property. So when it comes to race, there's no exceptions to this federal law. So it covers real estate, both residential and commercial, including unimproved land, and personal property like the clothes on your back and your personal belongings. Protected classes, race and color. But in 1987, they also added to that 1866 law. In 1987, they also added ethnicity and religious groups to that law as well. Enforcement, when it comes to the real estate aspect of this law, it's enforced by HUD, the Department of Housing and Urban Development. Violations under the Civil Rights Act of 1866 must be heard in federal court, and the statute of limitations is determined by each state's law. In the federal court, has no monetary caps on its awards and settlements. Fast forward to the Federal Fair Housing Act of 1968. Let's just look at the title. Just stop for a second. Just look at the title. What kind of property do you think is covered under this law? The Federal Fair Housing Act of 1968. You think it's residential or commercial or both?
Home ownership. Residential.
Residential.
Residential is housing, right? Houses. So there's a little clue there if you ever get lost on exam, and they're asking questions. Right there in the law itself, it tells you Federal Fair Housing Act. That's residential real estate. So the Federal Fair Housing Act of 1968. So because it's housing, it only covers residential real estate. It has nothing to do with personal property like the Civil Rights Act of 1866, has nothing to do with the clothes on your back, has nothing to do with commercial property. It's specifically for housing. So residential property that includes land that's meant to have residential buildings built on it. So the Federal Fair Housing Act of 1968 is contained in Title 8 of the Civil Rights Act of 1968. And it prohibits discrimination on the basis of race. There's more protected classes here. It's race, color, religion, and national origin or sex when selling or leasing residential property. So there's more protected classes under this law, the 1968 law. However, it only covers residential properties. All right. So the law impacts direct providers of housing, including landlords and real estate companies, as well as municipalities, lending institutions, and homeowners insurance companies. Everybody good there with the highlights?
Yes.
Yes. Yes.
So the Federal Fair Housing Act of 1968 is basically a part, it has a section within it. I'm sorry. The Civil Rights Act of 1968 has a section in it. That section is Title 8 that pertains specifically to real estate and housing. It's dubbed the Fair Housing Act of 1968. So Title 8 is often referred to as the Federal Fair Housing Act of 1968. Okay, because remember, in 1968, there was a whole civil rights movement that went on. It covered all things like having separate bathrooms and segregated classrooms in school, where people of different color had to sit on the back of the bus or the front of the bus or what have you. Different water fountains for people based on their race and all that stuff. Said segregation is bad, which is kind of ironic because these days now you're getting people that are pushing for segregation again. This time they're like, we need our safe spaces. We need to be free from people who make us nervous or whatever for whatever reason. It's like, wait a minute. There was a whole civil rights movement in this country to make sure that people are not segregated, that everybody has a right to be wherever they want. And now you're saying we need a safe space so that we could be away from you? It's kind of ironic, isn't it? So the Civil Rights Act of 1968, once again, there's a section within it that deals only with housing, with real estate, and that's called Title 8. And so they gave Title 8 a name. They call it the Federal Fair Housing Act of 1968, so that you can better understand the whole hoopla of these laws here. Okay, so it's the same thing. So the type of property covered under the Federal Fair Housing Act of 1968 is residential property only, whether it's for sale or lease, including vacant land for residential purposes. It has a lot more protected classes than the federal law, which is just race and color. And later on, they added religion and ethnicity. This one covers race, color, religion, national origin, sex, people with disabilities. That includes those with AIDS or COVID-19 and all that other stuff. Also familial status. Familial status means you have children under the age of 18. So you have children. Whether you're pregnant and the child was not born yet, you cannot be discriminated against. or if you have adopted children or foster children, you're also covered under the familial status. Alcoholics and persons in drug treatment programs are also considered a protected class. But current drug abusers and people who pose a threat to the health and safety of others are not considered a protected class. See, this is kind of interesting though, because as we progress in this chapter, we're going to kind of learn that just in the last couple of years, a lot of weird stuff is going on in this country by a lot of strange people that are being brought up, and I don't know if it's indoctrination or if they're just ignorant or what the deal is, but we're passing a lot of laws that are basically making current drug abusers a protected class and criminals a protected class. Now, it doesn't say it straight out that criminals are a protected class, but by the way they step around the words and the way they craft the law, it basically says, well, you know, the legal system and all is racist. So if you're using background checks on people, then you're racist. And so therefore you can't use background checks. So basically they're making criminals a protected class by claiming that if you try to do a background check on somebody, it's a racist thing to do, which is the dumbest thing. I get people of all races in this class, and I ask them if they were going to rent a room in their house or rent an apartment or whatnot, if they would like to be able to do a background check on the people they're going to rent it to, and they're like, "Yeah, I want to know if there's a criminal or a sex offender or somebody who's been in prison for having meth labs and all kinds of stuff like that. If these people pose some sort of danger or have a history of it, I would like to know about that and be able to make that decision if I'm going to rent my place out to them, right? And that's people of all races. You know, so it's kind of nonsense by saying that, well, if you did a background check like that, you're racist. You know, what does race have to do with it? You know, people of color care about their families and their safety as well. Yeah, it's the oddest thing. So we're allowing a small segment of whack job people be able to craft our laws now. So current drug abusers and people who pose a threat to the health and safety of others is not considered a protected class, although we're going to see that's getting kind of turned on its head. Now, the enforcement, who enforces this Civil Rights Act of 1968? It's also enforced by HUD, the Department of Housing and Urban Development, which has its own investigators. And you have 1 year to file a complaint to have it heard in front of an administrative judge within HUD. That's all they listen to are cases of discrimination. Or you have 2 years if you want to take it to federal court and make a federal case out of it. And then there's no monetary caps for awards or settlements if it's to be heard in federal court. So you have a twice as long to file that complaint, and there's no monetary caps on the awards or settlements to have it heard in federal court instead of an administrative judge within HUD who listens to these cases all day long, and so they specialize in that. So let's do these highlights now under the Federal Fair Housing Act. And then we're going to move on to the next slide, which I kind of tweaked these definitions just a little bit, making them a little clearer. So write all these notes here and do all the highlights. So you're just basically going to highlight this: race, color, religion, national origin, disability, and familial status. Those are the 7 protected classes under the federal law. Then you're going to write at the end of this 1, 2, 3, 4, 5, this 5th bullet point, you're going to write blockbusting / panic peddling. And then the next bullet point after the end of it, you're going to write the word redlining. That's what that says, redlining. And let me know when you guys got that. And I'm going to move on to the next slide, which will go over each one of these bullet points, but my tweaked versions of them.
Got it.
1 second, 1 second. You said that's panic peddling?
Yeah, panic peddling. Panic peddling, and then down here is redlining. So blockbusting / panic peddling and redlining.
Okay.
All right, everybody got that?
Yes.
Wait, one more second.
Sure.
Okay.
All right, so this is basically that same bulleted list there that you see on page 68. So the Civil Rights Act covers dwellings and apartments as well as vacant land acquired for the construction of residential buildings, and it prohibits the following discriminatory acts. I'm just going to read through them really quick, and you could see my tweaked versions. You could do by comparison by reading the ones in the book and see how I've adjusted them just to make it a little bit clearer to study from. Refusing to sell, rent, or negotiate with any person or otherwise making a dwelling unavailable to any person as a means of discrimination. Changing terms, conditions, or services for different individuals as a means of discrimination. Practicing discrimination through any statement or advertisement that restricts the sale or rental of residential property. Representing to any person as a means of discrimination that a dwelling is not available for sale or rent when in fact it is. Or making a profit by inducing owners of housing to sell or rent because of the prospective entry into the neighborhood, a person of a protected class. Those protected classes are race, color, religion, national origin, sex, disability, or familial status. And this is referred to as blockbusting or panic peddling, because you're trying to play on somebody's fears of a protected class to try to get them to sell their house and bust up the block. That's why they call it blockbusting. You're trying to get them to move by busting up the block and selling their house. You're trying to play on their fears. So you're trying to tell them a story to induce panic in them. So you're selling panic to them, some kind of scary story. That's why they call it panic peddling. Okay, so blockbusting or panic peddling is trying to scare somebody into selling their house because these people, fill in the blank, are moving into the neighborhood and they're going to do something very scary, or they'll drive down your property values, you know, make up a story and fill in the blanks. And that's basically what blockbusting and panic peddling is. Now, altering terms or conditions for a home loan or insurance policy to any person who wishes to purchase or repair a dwelling, or otherwise deny such a loan as a means of discrimination, even though they could afford it. So home loans or homeowners insurance, which you need to get in order to complete a purchase of a house. So this has to deal with the money for a loan or the money for the insurance. Even though somebody can afford it, you don't give it to them as a means of discrimination. They call that redlining. I guess you could think of it this way to try to remember that. Think of accounting. And when you think of accounting, blue ink and black ink are a good thing, but red ink, that you don't want to be in the red, right? So red is negative. So think of redlining in that regard, and maybe that'll help out. Although that's not where they get the term redlining from. I'll show you a little video that shows you where the actual term redlining comes from, where they had these redlining maps of towns and sections of towns where they show you where it's okay to give loans and insurance, or the other areas are more riskier. Denying people membership or limiting their participation in any multiple listing service, real estate brokerage organization, or other facility related to the sale or rental of a dwelling as a means of discrimination. All right, remember I said that I'm a white male. I could join the Women's Council, the African American Association of Realtors, the Hispanic Association, the Asian Association, and I can't be denied. If I were, that would be discrimination under this federal law, the Federal Fair Housing Act of 1968. So let's go over some of the exceptions to the law. Let's just highlight some exemptions to the Federal Fair Housing Act of 1968 include the following, but never on the basis of race or color. Because you got to remember, when it comes to race and color, there are no exceptions because the Civil Rights Act of 1866 made that perfectly clear, right?
Yeah.
So we're going to go over these. Let me see, do I have it on another slide? No, we'll go over them right here. So the sale or rental of a single family home is exempt when the home is owned by an individual who does not own more than 3 such homes at one time, and a broker, salesperson, or agent is not used, because under no circumstances are we ever allowed to discriminate, and B, discriminatory advertisements were not used. If the owner is not living in the dwelling at the time of the transaction or was not the most recent occupant, only one such sale by an individual is exempt from the law within a 24-month period. The rental of rooms or units is exempt in an owner-occupied 1 to 4 family dwelling. Dwelling units owned by religious organizations can be restricted to the people of the same religion if membership in that organization is not restricted on any of the protected classes. And a private club that does not own, that's not open to the public, may restrict the rental of its occupancy or lodgings that it owns to its members. Once again, as long as those lodgings are not operated commercially. So the 1968 Act has been amended several times over the years, adding additional protected classes. In 1988, people with mental and physical disabilities was added to the law. That includes people who have AIDS, because AIDS epidemic was broke out in the 80s there. Then we have the familial status, that's having family members under the age of 18. That includes foster children, adopted children, pregnant women as well. Yes, I said pregnant women. Deal with it. Only women can get pregnant. I know some people, they change their genders out of whim and all that, but underneath it, they were born a certain way. You know, men can't have them. All right, so Housing for Older Persons Act of 1995, HOPA, also contains a limited exception from the familial status prohibitions for housing for older persons. So basically that's 55 plus communities and senior housing, which we're going to go over. So in 1995, Housing for Older Persons Act contains a limited exception from the familial status requirement. You're not considered discriminating against the familial status for people that have family members under the age of 18 when we're talking about housing that is strictly meant to be for housing for older persons. You don't want little kids running up and down the hall screaming and having toys all over the place, you know, in a senior facility. You guys get the drift where this is going. All right.
Yep.
And in 1974, back in 1974, there was ECOA, the Equal Credit Opportunity Act. This law basically states that anytime somebody is denied because of their credit, you have to inform them why they were turned down for credit. Within a certain time frame, the creditor has to send them a letter formally telling them that they've been denied for credit and why, and then provide them with a free copy of their credit report, not their credit score, but their credit report. So ECOA made it illegal for creditors to discriminate against applicants because of their protected classes, or the fact that the applicant receives income from public assistance programs, or exercised any right under the Consumer Credit Protection Act. Women thus access to more housing opportunities, had more access to housing opportunities. Because this was, you know, if you look really far back too, you know, women were discriminated a lot, did not have equal rights, didn't have rights to vote, didn't have rights to go get a job on their own and work on their own. Nobody would hire a woman, you know, all that nonsense. Well, so these things also are protections for women in that regard. And then highlight alcoholics and persons in treatment programs are considered to be a protected class under the disability. Because, you know, face it, if you're a drunk or if you're a drug addict, but you're in recovery, you know, that is a disability. It can be very crippling. But current users of illegal controlled substances are not considered to be a protected class under the disability. You're willfully just still doing drugs. Although there have been some changes, like I said, and you know, you'll see them in a little while. They'll be coming up. We'll go over it when we go over New Jersey's laws. Nor are those who pose a threat to the health or safety of others. And other persons who are not considered disabled include persons convicted for illegal manufacture or distribution of a controlled substance, sex offenders, and juvenile offenders. Well, because juvenile offenders, you can't hold things against them that they did when they were a kid. Yeah, even if they killed somebody, you know, because they didn't know any better because they were children. Although we're seeing it happening all the time, and these people just grow up to be criminals as well. But you can't have that view because, you know, sometimes kids do stupid things when they're juveniles. But these days, it seems like when they're doing things that are as juveniles, you know, they join gangs and they tend to stick with it for a lot of their life, even as they grow up to become adults. And unfortunately, that we use it as an excuse to get them off the hook. My precious little angel, you know, they couldn't help the fact that they killed somebody. You know, sex offenders and controlled substances and whatnot. Okay, you can get more information here about that CRT stuff. All right, now.
Can you go back, please?
Sure.
68.
Hold on one sec. There you go.
And so,
This is all in the. This is all on page 68, or I'm sorry, 69. It's like in the middle of the page. Just let me know when you got it.
okay. Okay.
Okay. So let's take a look at the exceptions to the familial status requirement. We just read over them, but we're going to go over here in a little more detail. So familial status, what does that mean? It means you cannot discriminate against those with families, adopted or foster children, particularly those with children under the age of 18, including pregnant women. There are some exceptions to the familial status protected class in housing meant for older persons that would not be considered as discrimination. So if you were to deny somebody because they have children under the age of 18, it is not considered discrimination if it's in a senior housing facility meant for only for people who are 62 and older. But senior housing, to be considered a senior housing community, it has to be occupied by people 62 and older and posts by its entrances that it complies with HUD's rules for housing meant strictly for older persons, 62 and older, or for a 55 plus community. So what's a 55 plus community? If 80% of the units are occupied by at least one person that's 55 years of age or older, and the community or facility posts that it adheres to policies that demonstrate its intent to be housing strictly for persons 55 and older. All right. Now, can you be under 55 and purchase a unit in a 55 plus community?
No?
You know, I always thought that as well. But
Okay.
I recently found out that it depends on the town. So it depends on the town that that you live in, what your local ordinances are. Because recently, what's it, last year, I think it was in New Jersey, I think it was in Matawan, they passed, I heard it on, if you guys listen to New Jersey 1015 at all, that's a radio station. I used to always listen to that on my way driving into work and coming home, you know. Haven't listened to it in a while because we're working from home now. But you learn about a lot of issues that are going on within our state. And they brought up this one thing. I heard that Matawan was voting on changing their rules in their town so that only people 55 and older can purchase in a 55 plus community, because you were getting a lot of these younger people that are investors. They go buy up a bunch of units and then they rent out to people who are 55 and older at a marked up price. And that kind of defeats the purpose of having a 55 plus community. The whole purpose of it is to have a more affordable place for the seniors to live in, right? And for the 55 plus people to live in. So they were changing their rules on that. Okay, so like you, up until not too long ago, thought that, yeah, you got to be 55 and older in order to buy in a 55 plus community. It's age restricted. I mean, the MLS always said it's age restricted, but it really depends on the town, which is odd. So can you, okay, so now we just learned about that. I should have probably brought that up last, but how about this? Let's just say that you're in a town that does not allow you to buy in a 55 plus community unless you are 55 and older. Can you own a unit in a 55 plus community if you're under 55?
So you can, if you can buy it, you can own it, right?
Well, we're not talking about buying it now. We're talking about, can you own a unit in a 55 plus community and be less than 55 years old?
So
I would assume so.
no.
If you can live in it, depending on the community.
Yeah, if you can live in it, depending on the community. Look, it says if 80% of the units, 80% of the units are occupied by at least one person that's 55 and older. So let's just say you had a married couple. One was 55 and older and the other one was younger. And the person who was 55 or older dies. Can't they leave it to their spouse?
Yeah.
Or maybe they're
Honestly.
living with their child, their adult child, right? Yeah, they could leave it to them and they could live there, as long as not more than 20% of the units that are there don't have at least one person that's 55 and older. It'll still be considered a 55 plus community and they will be allowed to live there. But you really got to read the community's guidelines and rules on how that works. It really depends on the community, like you said. Because yeah, you could have a spouse that's younger than you, right? Or you could have a child, an adult child that's living with you and you're 55 and older and live in a 55 plus community. And then you benefit from that cheaper place to live, that nice place but it's cheaper to live in because it's meant for people 55 and older. But as long as at least one person is living there that's 55 and older in at least 80% of the units. That means that all the units don't need to be occupied by at least one person 55 and older. So I'll say one person dies and they leave it to someone else who's under 55, they could continue living there. As long as it doesn't get out of hand and the occupancy doesn't become more than 80% of the people like that, or more than 20% of the people like that. Okay, just so we have an understanding how that works, okay? So, but generally, 55 plus and senior housing, you can't buy in those communities unless you are 55 and older or 62 and older. But it really depends on the town's ordinances. Most towns don't allow it. but obviously some do, because I just read that, like I was telling you, I heard, not read, I heard recently, what was it, a year or two ago in Matawan, they did that. They changed the rule. So in the book here, that's in housing intended to be solely occupied by people 62 and older. That's senior housing. Just write senior housing next to that. And those intended to be occupied by people who are 55 plus, that's a 55 plus community. Okay, but then they go over the rules here. 80% of the units must be occupied by at least one person 55 and older. The owner management must adhere to policies that indicate it's intended for those 55 and older. And the facility must verify its occupancy with reliable surveys and affidavits by its residents periodically, because they need to maintain that 80% rule. Okay. If you as a real estate agent are getting a listing for a unit in a 55 plus community or a senior housing, you got to use this form or a form similar to this that your MLS will have. This one is from the Garden State MLS. Anytime you're getting a listing in a housing for older persons community, you have to check off which one it is and then have them sign off on it that it is housing for older persons. Because if you do not have this form filled out and you just submit the listing to the MLS, and then you have all kinds of wording in it, or you check off the option where it's age restricted, does not allow children under the age of 18 to be there, that's discriminatory under the familial status requirement. Your MLS will fine you and they'll remove the listing. It must be accompanied by this form. All right, now let's talk about service animals. Let me catch up in my book here. This is page 70. Just write service animals are not pets there. On the side, this is all talking about service animals. Service animals are not pets. So service animals in the Fair Housing Act. They have an abbreviation here, FHA, for Fair Housing Act. Most of us may be familiar with FHA, the Federal Housing Association, where they're Federal Fair Housing Administration, that it's a type of loan that you can get as a government insured loan. Well, this is talking about a different FHA. This is the Fair Housing Act. And it makes it unlawful for a housing provider to refuse to make reasonable accommodations for a person with a disability that may need to have equal opportunity to enjoy and use the dwelling. They have assistance animals that are not considered pets. They do work. They perform tasks. They assist and or provide therapeutic or emotional support for individuals with disabilities. So there's two types of assistance animals. You have service animals. Now, service animals can only be dogs, and in some cases, miniature horses. But service animals are usually always just dogs or a miniature horse. Okay, there's an exception for a miniature horse. Now, you could also have emotional support animals. Now, there's two classes of emotional support animals. You have the ESAs, the emotional support animal, and a service animal under the classification of an ESA, which does some sort of a task for you as well. That gets kind of confusing because they both have the term service animal in them. So the ESAs provide therapeutical emotional support for individuals with mental health or emotional disorders, such as depression, anxiety, and phobias. The landlord may not inquire about the nature of the person's need, only the right to verify that the letter from the therapist is in fact real and that the therapist is licensed and confirms that the tenant has a need for an emotional support animal. You know, because there's a lot of these fake emotional support animal websites out there where you could get your animal, your pet registered as a emotional support animal, and you could take them anywhere on a plane, in a restaurant, in a hotel, blah, 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 blah. That's just simply not true. So a valid letter is written on the mental health professional's letterhead, along with their contact information, phone number, email address, and practice address so that they can be reached to confirm that it is in fact legitimate. Now, the landlord can deny animals that pose a danger to other tenants or may be disruptive or cause undue financial burden to the landlord. So look at that. Even if you have emotional support animal or a service animal for that matter, if they're not in your control and they're aggressive and pose a danger to others, the landlord can have them legally removed. Additionally, neither service animal or ESAs are permitted to roam off of their leash throughout the property. They must be in their handler's control at all times. See, politicians write these rules, and sometimes the way they put their wordings, they still can be manipulated by people who want to take advantage of this stuff. Like I recently saw a video, one of these clickbait videos on YouTube or Facebook or one of those things, where you had somebody who had their emotional support animal and they went into a store with them and they said, you can't tell me I don't need them or that I can't have them here. And then they were like, you can't tell me that that they can't be in here. And they're like, yes, you need to keep them on a leash at all time. And they're like, look, he's on a leash. So they had, the girl had her dog on a leash, but she wasn't holding the leash. Like the dog was just running around the store wearing a leash, but she wasn't holding the leash. You know, so she's like, see, he's got a leash on. And then it says they must be in the handler's control at all times. And she was like, see, he listens to me. See, I can't hold the leash because if I have an episode, I forget if she was epileptic or what it is, you know, but she's like, if I have an episode, then I lose control of my hands, so I can't hold the leash. Like trying to make excuses why she doesn't have to hold the leash. Okay. That's really walking the fine line over there of warping the intent of this law and the wording in it. But you see, where there's a will, there's a way. You'll always find somebody who's going to try to take advantage of this. So much so that these emotional support animals, they used to be allowed to be on planes and in restaurants and every place with you. But since then, this has been so widely abused that the law changed. Only service animals have to be allowed on planes, because you got all these people who have these fake emotional support animals because they went to a website and paid a fee to get their animal registered, their pet registered as an emotional support animal. Now they think they got this ESA and they could taunt the store owners or the people on the airlines or whatever and say, you have to allow me to have my pet on the plane. That they had to make some serious changes to the law. And so now in restaurants and planes and all that, emotional support animals do not have to be let on. Only service animals do. Okay, so let's get into that a little bit more. I have a little write-up here about this, a little write-up. It's a couple slides. So the Federal Fair Housing Act prevents discrimination against tenants in their homes. A landlord would be guilty of discrimination if they violate the tenant's rights to provide what we call a reasonable accommodation for that service or assistance animal when a tenant has provided a medical professional's prescription for one on that letterhead. Under the FHA, which by the way needs to be renewed every year, that prescription, the need for that service animal or emotional support animal. Under the FHA, a disability is defined as a physical or mental impairment which significantly limits a person's major life activities. Even if a lease says no pets or restricted pets, landlords are required to make what's called a reasonable accommodation to allow pets who serve as assistance animals, which include animals who provide emotional support. Assistance animals are in a totally different legal classification than pets who are not assistance animals, which is why pet restrictions and fees are waived for them. So these are animals that work, assist, or perform tasks and services for the benefit of the person with the disability, or they provide emotional support that improves their symptoms of that disability. There's no official certification or training for assistance animals, contrary to popular belief, and they can assist in a wide variety of ways. Breed and weight restrictions do not apply. So yeah, people have pit bulls as assistance animals to assist or service animals. Yes, even a pit bull can be an assistance animal. Service animals can only be dogs and categorized as animals trained to do a specific task for their owner. I said they could only be dogs, but there is an exception for miniature horses as well. But there's rules pertaining to that. The most common example is a guide dog. Service animals are allowed in public accommodations because of the owner's obvious need for that animal at all times, because they're blind, perhaps. An assistance animal can be a cat, a dog, or other type of companion animal. Assistance animals do not need to be allowed on planes or in public services. These assistance animals can also be trained to perform tasks that can be for emotional support. The emotional or physical benefits of simply having that animal living in the home are what qualify it as an assistance animal, because it calms you down. A letter from a medical doctor or therapist is all that's needed to classify it as an assistance animal. The fact the term service animal is often used by landlords and public housing authorities to refer to both service dogs and assistance animals is what causes the confusion. So service animals, that's like the seeing eye dogs. They have to be let everywhere. Assistance animals do not. See, assistance animal could be that emotional support, or they could be an animal that's actually trained to do something, but they're there to assist. They're not an official service animal. So assistance animals can be like a cat or a dog that could detect or alert their companion to an oncoming seizure. Well, that would also probably be a service animal. Why don't you just get them, if you needed that need, you could have had them as a service animal. Or a cat or dog who alleviates a person's depression or anxiety. That would be an assistance animal, right? Or a cat or dog who reduces, or emotional support. Or a cat or dog that reduces a person's stress-induced pain. Or maybe a bird that alerts their hard of hearing companion when somebody's come to the door because they start whistling and, making those high-pitched noises. Animals are amazing creatures. Check out this little video I have of a service animal notifying its owner of a medical emergency. She recorded it. So basically, he was trained to check. I'm not sure what she was checking there, if that was her blood sugar or what level. The dog detected that she needs to either I don't know, take her medicine or take sugar. I'm not sure what that dog was alerting there for some kind of medical emergency. But you see how he was trying to get her attention. This is why service animals are usually larger dogs. This dog is, he was poking her with his snoot. You have larger dogs that assist people who are in danger of having seizures. You'll notice the way that they are trained to help is they start leaning their weight into their keeper by leaning their weight into them, trying to hold them up and let them know that, hey, you're gonna have a seizure. A seizure is coming on, and they can detect that. These animals are amazing. So you should provide your landlord with a letter from your doctor or therapist stating that you have a disability and explaining that your pet is needed to help you cope with this disability or improves its symptoms. Attach a brief statement explaining to the landlord you're asking for what's known as a reasonable accommodation to keep your pet who functions as an assistance or support animal. If your landlord refuses to accommodate, well, then they're guilty of discrimination. So then you could go file a complaint against them for that illegal discrimination. You could file it either with HUD, the Department of Housing and Urban Development, or the New Jersey State Attorney General's office. Now, the housing that's covered by the FHA, Federal Fair Housing Act, has some exceptions to it. So all type of housing, including public housing, are covered by it, except for rental dwellings with 4 units or less if the owner occupies one of the units. Okay. So basically, this law really only applies to units, buildings with 3 units or more that are not owner occupied, or 4 units or more if the owner occupies it. So any building that has more than 3 rental units available. Single-family homes are rented by the owner without the use of a broker, or housing owned by a private club or religious organization that restrict the occupancy of its housing to its members. Pet fees, service animals and assistance animals are technically not pets, so the landlord cannot charge you additional rent or a additional security deposit for having a pet as a pet security. They could charge regular security, just don't call it pet security. In New Jersey, the maximum allowable security that a landlord can charge by law is 1.5 times the monthly rental figure. If you have a pet, can your landlord charge you pet security on top of that?
No.
No, because the total security allowed by law is 1.5 times the monthly rental figure. You could call it pet security, but it's still security. It doesn't matter what you label it as, it's still security. And the maximum that the law allows is 1.5 times. So the owner can still seek money from the tenant if there's damage caused by that animal to the home. And if the nuisance issue, if there's a nuisance issue, the landlord does have the right to have that animal removed through legal proceedings. So let's ask a question here. John's been diagnosed with a severe depression and is disabled as defined by the Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. John asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but then tells John that he needs a $250 pet deposit and must provide proof that the animal's trained. Did John's landlord correctly handle John's request under the Federal Fair Housing Act? And what if John wanted a cat or a ferret instead? Shoot.
I'm trying to think.
Isn't the cat or the ferret not considered a service animal?
Wait, why are they calling it pet deposit? Isn't it supposed to be called something else other than like the pet security?
Well, it doesn't matter what you call it.
Oh, it doesn't? Okay.
So let's read this again. John's been diagnosed with a severe depression and is disabled as defined under the Federal Fair Housing Act. His doctor prescribes John a dog to help alleviate some of his symptoms. Then John asks his landlord if he could have a dog as a reasonable accommodation for his disability. His landlord says yes, but then tells him that he needs to pay a $250 pet deposit and must provide proof that the animal's trained. So we're not talking, we never used the word service animal or anything like that. They just asked for a reasonable accommodation because he got a prescription from his doctor. So did John's landlord handle John's request correctly under the Fair Housing Act? And what if he wanted a cat or ferret instead? But the answer is no. John's landlord did not handle the request correctly. The landlord, first of all, cannot charge John a pet deposit for his animal because it's not a pet, but rather a service or companion animal required for his disability. Further, the landlord cannot ask for proof that the animal's trained. The reason being is that would be discriminatory against poor people who maybe can train the animal themselves, and they don't need to go get that formal training. You don't need to carry around an ID that you have a service animal. The animal doesn't need to be wearing any kind of a vest or insignia either, contrary to popular belief. You don't have to carry around a service animal license with you. There's no such thing, you know. Lastly, the companion assistance animal, or ESA, emotional support animal, does not have to be just dog. They could be other animals such as cats, ferrets, or birds. Check out this video. Now, this was a couple of years ago, and since this, the law changed a little bit, but this just shows you how when they first passed these laws about service animals and emotional, which also included emotional support animals, that you get your pet registered as an emotional support animal, you could take them anywhere with you, even on a plane. People started going to these fake websites that are popping up all over the place. They seem legit, but hey, you could just pay a fee and you could have your animal registered as an emotional support animal with us. We'll give you a letter that says that it is, and we'll even add you to our database on our website. And anybody who questions it, you could point them to our website and they could search our database to confirm that your animal is a service or emotional support animal. Well, first of all, right off the top, you should have a clue that that's BS nonsense, because we have HIPAA laws in this country. You guys know what that is, right? HIPAA laws, the medical privacy laws.
Yeah.
Yep.
You know, there's not going to be any searchable database where anybody from the public can go and search and see that you have a medical need for something. That's nonsense. Right off the bat, that should be your first clue that it's a scam. All right, but check this out.
The airline that cracked down on the so-called emotional support animals in said song. The policy change was prompted in part by a passenger who tried to board a United flight with a large peacock on Sunday. Delta announced similar restrictions just last month. CBS News travel editor Peter Greenberg is at United's hub at Newark Liberty International Airport, and that's where that peacock is grounded. Peter, good morning. Most people don't think of peacocks as emotional support animals.
No, but they are. In fact, more and more airlines are reporting that the number as well as the types of emotional support animals is reaching crisis proportions. Now, we're not just talking, as you can imagine, dogs and cats. In fact, the interior cabins of some flights are beginning to resemble Noah's Ark.
I'm not kidding. This woman is wrangling her peacock into the airport.
United Airlines says it warned the peacocks over 3 times that Dexter would not be allowed to board.
Dexter.
The bird lives with an artist in Brooklyn, who claimed Dexter is her emotional support animal. In this 2016 interview, she described how she found him.
Now, just listen to how she describes how she found them. And you tell me that this is really, that she really had a need for an emotional support animal, and this wasn't just some sort of a convenience that she wanted to have her be fashionable and have her newfound pet buddy with her all the time.
I got him originally for an art project, and but then this.
Did you hear that? I originally got him for an art project.
How she found him.
I got him originally for an art project, and but then this happened, and I was like, "What is the peacock really in my neck?" Yeah. Yes, I do.
Airlines already prohibits non-household birds, hedgehogs, ferrets, spiders, sugar gliders, and other exotic animals. Its new policy requires owners to give 48 hours advance notice when flying with a support animal, provide a letter from a mental health professional, and documents from a veterinarian showing the animal is vaccinated and not a threat to the public.
We've had roosters and ducks and pigs and monkeys.
Sarah Nelson is the president of the Association of Flight Attendants and says she applauds the new policy changes.
But what we really need is for the Department of Transportation to act with guidelines for the entire industry.
United saw a 75% spike in comfort animals from 43,000 in 2016 to 76,000 last year. But critters sometimes relieve themselves in damaged planes. In June, an emotional support dog hit a Delta passenger. When pigs fly, in 2015, we showed how easy it was to get one on a flight. A Colorado counseling center provided CBS this morning with a letter prescribing the pig as the primary treatment for a psychological disability. Tom Panic, CEO of Guiding Eyes for the Blind, says people are passing off their untrained pets as service animals.
As a person who is blind, my access rights are being infringed upon when somebody passes off a fake service dog.
Now, the new policies for United and Delta kick in on March 1st, and American Airlines is expected to follow suit. But we should note that the new policies only apply to emotional support animals, not the trained, specially dedicated animals that fly for and with people with disabilities. John? Here, thanks.
Yeah, people take their pets very seriously, we get it, but you see a lot of people taking advantage of that policy. So I think it's good that they're trying to figure out a way to crack down and make sure that the legit animals go.
And ultimately, what happened, you had a bunch of people that were taking advantage of it, and now no emotional support animals are required to be allowed on planes. Only service animals, like those for blind people and so here is a little chart that shows you about that. You know, service animals are only dogs, or in some cases, miniature horses. But look, they have to be allowed public access rights. Emotional support or assistance animals do not. This is the latest rules, guys. Air travel rights, yes, for service animals, not for emotional or assistance animals. Housing rights for both of them. So basically, if it's for your house to live, they have to allow both service or emotional and assistance animals. Do they need to be trained? Well, over here they say service animals do, but there's no rule that you need official training. The person with the disability can train their own service animal. So there is no official training that is needed. So that should have like a little asterisk next to this one. So emotional or support assistance animals don't need special training, because simply petting them and having them on your lap calms people with PTSD and stuff like that. And just having them there doesn't require any training. And do they need to be registered or certified? Neither one does. Okay, so trained here means task trained for a specific disability, which goes well above and beyond the basic socialization and obedience training. It doesn't mean you need to get some kind of a special official training by an official training provider and have the animal certified, trained, you know, because what's to stop somebody from training their own animal, other than the fact that most people don't know how to do it. All right, so let's continue on. Let's do these highlights here. The Federal Fair Housing Act of 1968 instituted the use of an equal housing opportunity poster. Failure to display that poster is evidence of discrimination. When HUD investigates a broker for discriminatory practices, it considers failure to display that poster evidence of discrimination. So anybody who offers housing or housing services, if they fail to display the HUD's equal housing opportunity poster, if HUD goes out and they're called out because they say, hey, this person discriminated against me, and HUD goes out there to investigate, first thing they do is they come to your office and they look to see if they see that equal housing poster. If they can't find it anywhere, they stop their investigation and boom, you're guilty. That's their evidence that you engage in discriminatory practices. You see, so the threshold to be found guilty of discrimination is not too high. All you got to do is not have a poster displayed and boom, that's the evidence that you do discriminate. Not a very high threshold, is it, to be met? So check this out. This is something from page 84. Later on in the chapter, towards the end. It says the complainant does not have to prove guilty knowledge or specific intent, only the fact that a discriminatory act had occurred in order for you to be found guilty of discrimination. So even if you did something that was discriminatory, but it wasn't your intent to discriminate against someone, that's irrelevant. They don't care about your intent. As long as somebody can prove a discriminatory act had occurred, boom, you're guilty of discrimination. That's why I remember I was telling you guys to use that the exclusive buyer's agency agreement to try to, if somebody wanted to have properties filtered out based on the amount of commission that they were paying so that the buyer didn't have to pay commission out of their pocket, and they could say, oh, just don't show me properties that are like that. Because if they could paint on a map that those properties are only from a certain area and you never had that discussion with them, they could paint a picture that you're steering them away from those properties and keeping them out of that area then. Now, even though that's not your intent, because your intent is over the money, the commission, not any discriminatory factor at all. But somebody just needs to prove that a discriminatory act had occurred, and steering is discriminatory under the Federal Fair Housing Act of 1968. And boom, so right away you'd be found guilty of discrimination. That's why I said you should use that exclusive buyer's agency agreement, even though many agents do not. Because, I mean, the likelihood of you being that instance occurring is very low, but it could still happen. And if you follow these rules, I'm protecting you from that undoubtedly horrible situation where you'd be accused of discrimination, and that was the furthest thing from your mind. Okay, everybody got these highlights?
Yes.
Yeah.
No, the one on 84, not yet. Was it the complaint?
That's all right. You could get that one later if you don't got it yet.
Okay.
We're going to go there still again. All right. So here's what the equal housing opportunity poster looks like. It has the house with the equal sign in it. You guys may be familiar with that logo, right? But this is what the poster looks like. And this logo, you can see this on business cards and advertisements and all over the place. It basically shows that we offer equal housing opportunities to everybody, that we don't discriminate. Now, blockbusting and steering on page 72. Let's do all these highlights, and then we're going to move to the next slide that'll go over each one of these with a little better explanation than what the book has. Before, I told you blockbusting was also known as panic peddling.
Wait, what
72.
72? All right, thank you.
You're welcome. Everybody got those highlights?
Yes.
So the Federal Fair Housing Act of 1968 makes these practices illegal, although they're not mentioned by name in the law. Blockbusting, which is also sometimes called panic peddling. You need to, first of all, you need to know that. That in itself can be an exam question. Blockbusting is sometimes known as panic peddling, or panic peddling is also known as blockbusting. And who is blockbusting or panic peddling discriminating against? It's discriminating against the homeowner. because it's using discrimination as the tool to play on their fears of a protected class by telling them a scary story about these people, trying to scare them, and then get them to sell their home. So it's using discrimination as a tool to play on a homeowner's fear of a protected class, trying to stir up some kind of a division in them, to get them to scare them into moving, because these people or those people are moving in and they're going to do something horrible and drive down your values and all that. In the past, we always heard these stories in the 60s that, oh, yeah, that was, scaring people, telling them, oh, black people are moving to the neighborhood. They're going to run down your neighborhood and drive your property values down. You got to move out. You got to sell now, and I could get you out now. All right. We're not really seeing that these days anymore, but blockbusting and panic peddling, the instances that you do see are probably more along the lines of, hey, did you hear? It's still the same storyline. It's just they just changed up the protected classes that you're seeing this more with now. Nowadays, you're probably seeing it more along the lines of maybe with disabilities or things along that nature. Like, hey, did you hear what they're doing with the house next door? They're going to turn that into a halfway house for all them recovering drug addicts. Wait a minute, isn't that a protected class? Under the medical disability, that's the disability one. Oh yeah, you're gonna have needles and crack vials all over the place, but you gotta sell your house because they're gonna run down the neighborhood, So you could fill in whatever protected class and make up a story about it, and try to scare the homeowner into selling. It doesn't just have to be about a person's race or color or country of origin. It could be about their religion, it could be about various things, and we're seeing a lot of anti-Semitism going around right now too. So who knows what kind of next trend of discrimination we're going to see, okay? So steering now is limiting someone's options of where they can live by not showing them all the properties that meet the criteria in the areas that they're looking. By channeling those home seekers to or away from certain areas, simply not making them aware that homes are available in those areas that meet their criteria. So when the agent's the one who decides where the buyer or renter should live, this could be deemed a discriminatory act because you're making that decision and not that buyer or renter. So you got to be very careful about that. Once again, that's why I said, if you use that exclusive buyer's agency agreement to get people to tell you, don't show me these homes because of the commission amount, if that's what the deal is about the commissions and maybe showing of properties that are not offering a high enough commission because the buyer or renter doesn't want to pay it, well, then get it to put it in writing. Because if you just take it upon yourself now to start filtering out those properties, or you don't protect yourself by putting it in writing, that person can later on say, oh, we never had that conversation. You're just not showing me properties in those areas and they meet my criteria. That's discrimination. You're steering. So who is steering discriminating against? It's buyers and renters. It's buyers and renters. Just think, who do you drive around in the car to show them properties? I think you like it better in this neighborhood, or I think you like it better in that neighborhood. See, you're the one behind the wheel steering them in one direction or another. So try to get the link there. Like when you hear steering, just think about driving in a car. You could steer somebody over here, or you could steer them over there, okay? So when you're the one that's making that decision of where somebody should live by steering them in one direction or another, which is discriminatory, that's discriminatory. Now, redlining is refusing to give somebody, it has to deal with the money, refusing to give somebody a mortgage loan to buy a house or the insurance policy to insure it. Plus, you can't get the loan unless you insure the house as a means of discrimination. Think about that red ink through the application, right? Red is not good when it comes to money. You don't want to be in the red. Anybody taking pictures or anything of this? Can I change the slide?
I'm good.
I'm good.
Now, this is the true meaning of where the term redlining comes from. I got this from a documentary. This is a NPR documentary. This was a pretty good documentary in most respects. In some aspects to it, they go off the rails and they go kind of extreme because once again, you do have people that are making up a lot of documentaries. You got to take these things with a grain of salt. Some people can distort history a bit based on their explanations of stuff. You do your own research. Like I like to tell people, don't trust anything I ever say. Always verify it on your own. I mean, I'm telling you guys the truth, but I'm giving you my explanations. But don't trust me. Go do your own research. Just like if you ever see documentaries, some documentaries, they look very legitimate, but then they get a spin to them a bit, But here, this is talking about redlining and where that term redlining comes from.
In the 1930s, in the wake of the Great Depression, the U.S. president invested in economic relief to millions of Americans through a collection of federal programs and projects called the New Deal. One part of that New Deal was the National Housing Act of 1934, which introduced ideas like the 30-year mortgage and low fixed interest rates.
Wow, look at that. Model home, $4,800. $960 cash and $27.62 a month mortgage. You wish, right? Yeah. It used to be that you could buy you guys remember Sears? Or is anybody here too young to remember Sears now?
Yeah.
I remember.
I saw that you can build a Sears house. You just they send you all the materials and stuff, and you can build a Sears house.
Yeah, Sears used to sell homes out of the Sears catalog. You could buy a house out of the Sears catalog for real cheap. Well, it's considered real cheap by today's standards, but back then it could still be pricey because how much money were people making then too? Remember, everything in perspective.
So now you have all these lower income people who can afford homes, but how do you make sure they don't default on their new mortgages? Enter the Homeowners Loan Corporation. The HOLC created residential security maps, and these maps, they're where the term redlining comes from. Green meant best area, best people, aka businessmen. Blue meant good people like white collar families. Yellow meant a declining area with working class families, and red meant detrimental influences, hazardous, like foreign-born people, low-class whites, and most significantly, Negroes. Again and again on these HOLC maps, one of the most consistent criteria for redline neighborhoods is the presence of Black and brown people.
Now, let me just point something out as well. Often and by far, this is not to diminish it at all. We always hear about discrimination. The first thing that you usually think about when you think about discrimination is a person's race or color. But it's not just about race and color. Look, even back then, it was, you have the race or color here, but you also have whether they were a foreigner. So if you got people that are from foreign countries and certain countries, they were considered lower class than others, and they were considered detrimental to the neighborhoods as well. So just keep in mind that, it's when people are discriminated against, it's not always or only about somebody's race or color, okay? But by far, that is usually what it was. So once again, not to diminish that at all, I just wanted to point that out, okay?
Studies show that people who lived in redlined areas were not necessarily more likely to default on their mortgages, but redlining made it difficult, if not impossible, to buy or refinance. So landlords abandoned their property.
Okay, so that's where redlining, the term redlining came from. Let's move on. Now we have something new that we've been hearing about for some time now. But this is getting really distorted in recent years. It's known as disparate impact or disparate treatment. Now, the beginning of this, what I'm about to read to you, this is in your book on page 72. the beginning of this, they start painting you a picture and a story and giving examples that you could be totally in line with and totally agreeing with because it's obvious. And then they start kind of distorting it and kind of like really stretching. They're taking a bit of a leap, a stretch to try to make a point or prove a fact or something here. So disparate impact, sometimes referenced as disparate treatment or adverse impact, is a policy or practice that seems to be neutral, but in fact may disproportionately impact a certain group of people. And the results, this results in discriminatory practices, resulting in unequal treatment and hindering equal access. For example, a lender or property management company may require full-time employment. On the surface, this requirement seems fair enough. However, it discriminates against someone who's receiving public assistance or disability payments. No, it doesn't, because there's laws that you cannot discriminate against somebody based on their source of lawful income. So right off the bat, you could tell they're trying to build a story based on some falsities right there at the beginning. Now, the Department of Housing and Urban Development enforces the Fair Housing Act of 1968, and they published guidance explaining that the use of criminal history to exclude people from housing may violate the prohibitions in certain circumstances. Wait a minute. Let's stop right there for a second and try to evaluate this, take this bit by bit so we can understand what they're saying. So they said the Department of Housing and Urban Development, HUD, enforces the Fair Housing Act of 1968. Got it. Next point. HUD established guidelines pertaining to the use of criminal history. They did not do this in 1968. The way they led this sentence on makes it sound like it's been around forever. And it has not. Actually, during the first year of President Obama's administration, he appointed somebody who was working in HUD. And that person within HUD, they took it upon themselves to look at statistics of prisoners that are in prison. How many people are in jail, basically? All right, so we write down on a piece of paper how many people are in prison. Now, let's take it a step further. Let's segregate them by their skin color. And only based on the fact of their skin color, not whether the people actually committed any crimes or not. Let's just now look at the skin color of the people and the number of prisoners in jail based on their skin color. And let's take a leap that if it's not an exact equal number of people of each race in prison by equal numbers of people by their race there, then there must be something wrong with the criminal justice system, that it has to be biased and racist in some way, shape, or form. That's what this report actually said. And that's what this report was actually based on. And it's actually a flawed way of looking at it. There's another way there's other ways that you can do these research and come up with these statistics and reports, but that's all that this one report did. And ever since then, you had local, state, and federal politicians pushing all kinds of legislation about discrimination or anti-discrimination. They started using terms like systemic racism. Our system is systemically racist. Based on what? Well, we don't have an equal number of people in prison based on their skin color. Well, huh? You know, it doesn't really make sense if you're taking it from an objective standpoint look, okay? So that's what a lot of these studies are based on. So it's been published, these guidelines, and you'll see it too, because later on, when we read the actual, we're going to be reading an actual disclosure from New Jersey Civil Rights Division. They actually reference which document that was. And that's one from this one guy. He was actually a pretty young guy too. Just came up with this idea by let's look at the number of people in prison. We'll segregate them by their race, and then we'll just make the conclusion that if it's not an equal number of people, then it's racist. But if you, it's actually a very flawed way of thinking. And if you want to argue with me on the facts, let's argue the facts of it, because we can look at it another way, because this is a way they're just trying to say, well, there's more black people in prison than there are white people, so therefore the system is rigged against the black people. Okay, well, hold on. Let's stop. Let's go with that same line of thinking. There's more white people in prison than there are Asian people. Does that mean the system is rigged against white people then? You see, it doesn't make sense. If you want to make an argument, let's base an argument. It has to be the argument has to stand its ground and across any angle that you take at it, and it just doesn't. But this is the argument that they're using to pass all these laws now, which affect people of all colors, and not in a positive way either. You'll see what I mean in a moment. So. This published guideline explains the use of criminal history to exclude people from housing that may violate the prohibitions in certain circumstances. Housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. Applying a criminal record based restriction against protected classes differently then they apply them to a non-protected class. Okay, yeah, that's not fair, that's not equal, and that would be discriminatory. What does that mean that they just said? Well, in other words, you can't do criminal background checks on a black person, but not on a white person. Yeah, that's racist. That's absolutely 100% discriminatory. 100% agree with that. If you're going to do background checks, you do them on everybody, right?
Yeah.
Now, for example, a management company with the intent of keeping all tenants safe might reject an applicant based on a criminal history. This ignores groups who are incarcerated at higher rates. Once again, let's segregate people just by their race, and the general population, and they may not result in a safer environment. Yet another example, now this one is taking a real leap here. Another example of this is a zero tolerance for violence, without recognizing that perhaps up to 25% of women have experienced domestic assaults. So with this policy, it could negatively impact them. You notice they don't get too deep into the explanation of that, but that one has taken a huge leap. They're basically saying that, well, if a woman has been been a victim of domestic violence, they've been beaten by their spouse or what have you, simply not renting to them because they're involved in zero violence, because you have a zero tolerance for violence, discriminates against them, and they're really the victim. Well, how come they didn't just say that here, that you're discriminating against the victim? Because it's not true. It's trying to make a huge leap here. That woman would not have a record against her. It would be the guy who would have been in jail for doing the violence against her, you know. So this zero tolerance, that may be something you see in a school where they put kids in a corner because they were both involved in a fight, but not in jail. So the New Jersey Fair Chance in Housing Act. This is a recent law that went into effect beginning January 1st, 2022. And this thing is nuts. I don't care what race or color you are. When we start getting into it, you'll see what I'm talking about. It's called the FCHA. The New Jersey Fair Chance in Housing Act prohibits landlords from generally asking about criminal history on housing applications. In most cases, landlords are prohibited from running a criminal background check on an applicant until a conditional offer of housing has been made. So you have to first agree to rent to somebody and then afterwards tell them, well, that agreeing to rent to you is going to be based now on a criminal background check that I have to do still. So you can't tell anybody in advance, hey, anybody who rents from me, you fill out the rental application, but it's also going to be based on a criminal background check. You can't do that, because if you say that in advance, it could scare away people who have criminal histories. That's the line of thinking here. So the best we could do with contradictory guidance like this is to be a good person, treat everyone equally, fair, and just. Hopefully you're not going to get sued in the process. Politicians, in the name of fair housing and something that they call equity in recent years, are justifying a systemic racism claim by absolving individuals of their personal responsibility and accountability for their actions, instead judging individuals based on their racial groups they fall into as a reason to excuse them. Law-abiding citizens wanting to safeguard their family, property, and tenants have a responsibility to do so, and under the law. But they could be found guilty of discrimination for denying renters who have criminal history. So check this out. If you're a landlord, I don't care what your race or color is, if you're a landlord, you have a duty and obligation to keep your other tenants safe. How are you supposed to do that if you can't do a background check on anybody? See, they say that you're going to be violating the law, you're being racist, doesn't matter what your color is, if you're doing a background check on somebody. But if you end up renting to somebody who then does cause harm to others there, then you could be held responsible for that because you didn't protect the other tenants. They're tying one hand behind your back here and saying you need to protect them. Sounds crazy, but that's now the law in New Jersey. And see, this is my explanation of it. So ignore it for now. Pretend my personal opinion is biased, okay? Let's go with let's just look at the rules. But I'm just telling you, these are how I'm interpreting this law. And remember, I told you, don't go by anything that somebody interprets. Figure it out for yourself, okay? Don't trust me. Look at the facts yourself. Be a critical thinker. You know, unfortunately, schools aren't teaching people how to be critical thinkers and being able to teach for themselves anymore. So let's look some of these the windows to the law. Here we're going to have a NAR attorney that's going to explain it to you.
What did you have at the top of that last slide? It was F. It was written in. What was it? FH. What F?
FCHA.
F.
Yeah, FCHA, the Fair Chance at Housing Act.
Okay, Housing Act.
Yeah.
Okay.
We're actually going to see that on the New Jersey Attorney General's memorandum. It's been updated with the FCHA in it, and I have a copy of that on the shared Google Drive as well. But I'm going to pull it up on screen and show it to you in this slideshow. It's actually in this slideshow. But let's look at this video here that a NAR attorney is explaining to you these rules and how some extremely blue states like New Jersey there's like 3 states out there that have gone extreme with these laws, and New Jersey is one of them. New Jersey, Illinois, and was the other one, Michigan, I think, how they're instituting these laws about disparate impact and impact treatments. And if you actually listen to the words that she's going to say in this presentation that's coming up, listen to her talk about doing criminal background checks on people and about them being on their face, they seem very neutral. You know, where you're doing if you do an equal, fair background check on everybody, because it would be discriminatory if you only did a background check on a person of color, but not a white person, right? That's obviously racist. That's actually discriminatory. But she says that even if you do a criminal background check based on everybody, it could still be discriminatory. And why? Well, because the whole system is systemically racist. Why? Because it's based on that HUD report from the Obama administration, that one guy. Now they're not spelling out all the details and linking it, all for you, but I am. Let's listen to her and see what she has to say about this.
Welcome to Window to the Law. I am Mahmoud Yamicha, staff attorney at the National Association of Realtors. In this episode, I will discuss why it is important to give your criminal background screening practices a second look in order to avoid a fair housing violation. In fact, several housing providers have found themselves faced with lawsuits alleging the misuse of criminal history in violation of fair housing laws. In New York, a housing provider recently settled a case for over $1 million, and the plaintiff alleged that the housing provider maintained an overly broad ban on renting to people with criminal records.
Now, keep in mind, a lot of these lawsuits that she keeps talking about, or judgments and payouts that were made, nobody was ever found guilty in any of these. These were just settlements where somebody just agreed to pay it out and let the problem go away, like in this case.
In Florida, as many as 48 Florida housing providers were also sued for the alleged improper criminal background screening of prospective tenants. The use of criminal histories to make housing decisions has long been on the fair housing advocates' radar. In 2016, HUD issued guidance urging housing providers to exercise caution when implementing criminal history policies and practices to make housing decisions. In the guidance, HUD reported that African Americans and Hispanics are arrested, convicted, and incarcerated at disproportionate rates compared to the general population, resulting in criminal history-based barriers to housing and creating a disproportionate impact on minorities.
Now, it didn't say if these people actually committed the crimes or not. They just said, well, there's a disproportionate number of these people versus those people, so therefore, whatever you say about criminal backgrounds, you can't use because it's not equal. Okay.
While persons with criminal records are not a protected class under the Fair Housing Act.
Wait. What did she say? Let's repeat that one more time. It's worth repeating.
While persons with criminal records are not a protected class under the Fair Housing Act, race, color, and national origin are.
Okay.
And improper use of criminal history to make housing decisions may have a disparate impact on those protected classes. Under a disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
Say what? You guys are listening to this, right? If that's not a cause for concern, I don't know what the hell is.
She was a little muffled, so.
Okay, let's play it back again. Is it too loud and that's why it's muffling? Should I lower the volume?
It's just, I don't know if
No.
it's just me, but it's like a little choppy. I'm like, it's just
a little
hard
choppy,
to.
but it's just muffled.
Yeah, if
Yeah,
it's
it's kind of
if
muffled.
it's choppy, if it's choppy, yeah, let me know about that because sometimes that could be an internet connection either on my part or your part. I don't know, or with the video. Sometimes it would get choppy like that. But yeah, hopefully
It's a
not.
mixture of like all of it, to be honest. Sorry for cutting you off.
Yeah, no. That's fine. I'm trying to figure out what the heck the problems are because I never had these problems before, but recently.
Can you try playing it from the YouTube link?
No, this is not on YouTube. It's on NAR's website, and then you got to worry about streaming and all that stuff, and then that's another problem altogether. I found that it's best when it's like this. In the past, I used to be able to do this all the time, never had a problem, but you know, the Zoom sometimes updates their software and stuff they break it. Stuff don't work right anymore. And then I also had, I think, my antivirus installed a VPN. And I got rid of the VPN because the VPN was making it totally so that you couldn't even watch a video because it was so choppy or listen to anything. So I uninstalled it and got rid of that because it slows down the streaming capability. I mean, I have a gigahertz FiOS connection. This should be streaming perfectly, you know. I'll play it again, and either way, we'll be able to get it on the recording that I'm doing. It should come through clear, I hope. But I'm gonna play this again. I relocated one of the speakers. Hopefully that'll You know, I got these external speakers. Hopefully it'll be so that you can hear it a little bit better now. If not, I'll repeat what she said.
A disparate impact analysis, a housing provider may be held liable for discriminating against a protected class absent any evidence of intent or motivation to discriminate.
So they said a housing provider can be found guilty of discrimination absent of any evidence or intent to discriminate. That should be kind of scary to you. You could be found guilty of discrimination with absolutely zero evidence of discrimination or intent to discriminate. Damn.
How? How did
Let's continue.
how?
But listen.
How am I guilty?
Yeah, it's kind of insane, isn't it?
Yeah,
That's the point I want to make with that.
it's right, wrong.
That's why I keep replaying it. I'm like, if we actually listen to, if we focus in and listen to the words that some of these people are saying, like, don't shoot the messenger. She's just explaining, you know, what's going on right now. You know, it's not her fault. She's just trying to explain and rationalize what's going on, which is not always rational the way some of these rules are being passed right now.
Meaning, liability may arise when a facially neutral policy or practice has or predictably would result in a disproportionately negative impact on a protected class under the Fair Housing Act. Some states and localities, such as Illinois, New Jersey, and the District of Columbia, have even enacted laws restricting a housing provider's use of criminal records. Consider these.
New Jersey was on that list. Restricts your use of criminal records to rent to someone.
Best practices when using criminal history to make housing decisions. Have a written criminal history policy. Apply criminal record policies consistently.
Check.
Do not ask or consider arrests without convictions.
Check.
Avoid blanket bans on applicants with a criminal conviction.
See, all of these ones, I don't think there's anything wrong with this. Have a written criminal history policy. Okay, check. Apply criminal record policies consistently to everybody. Check. Don't ask about or consider arrests without convictions. Check, because you're innocent until proven guilty, right? Avoid blanket bans on applicants with a criminal conviction. I guess you could take it on a case-by-case basis, but, you know, why shouldn't you be able to if you wanted to? After all, it is your house. You should be able to decide if you want to rent to somebody who is convicted of a certain crime that you may have an issue with, right?
Be sure to exclude only those with convictions that present a demonstrable risk to resident safety or property.
Let's stop there. How would you demonstrate that? Exclude individuals with convictions that present a demonstrable risk to resident safety or property. Short of looking at people's history, their criminal history, that's all we could really do. We can't predict. There's no like pre-crime technology out there that could predict if you're going to do it again. You know, all we could do is look at a pattern of somebody's criminal history and then do our best to try to determine if they're going to be a risk. Right? Now, I understand criminals, when they let out of prison, they may have a tough time finding a place to live because people don't want to rent to ex-convicts, right? I understand that, but you know what? These are some of the consequences of your actions that you got to live with. You know, that's why we also take away things like your right to vote if you're convicted of doing certain crimes, felonies and such. Okay, be a good, productive member of society and don't commit crimes, and this was not going to be an issue for you. But what they're doing is they're trying to put all these rules in place to try to protect the ex-convicts. Okay. Now, I understand there's plenty of places where they could move and live to. You could find people, although you may come across those that don't want to rent to you. But hey, you know, actions have consequences. If you're going to commit crimes, you know, you got to deal with that. Try to be a better person. Try to explain to the landlord that you've changed. And then maybe they'll see the light and they'll give you a second chance because of that. But you shouldn't be forced to rent to somebody.
Document housing decisions. And become familiar with local and state laws that apply to a housing provider's use of criminal history.
Okay, so document housing decisions. Why do they want to do that? Well, they want you to be to write down how you're making your decision based on renting. Because if it is in violation of any of this new nonsensical laws, they want you to write down what they're going to use as evidence against you. Be familiar with local and state laws that apply to housing providers' use of criminal histories. And in New Jersey, you may need a law degree to figure them out. You're going to see what I mean, because I'm going to post them up here for you and ask for your opinion. What do you think?
For more information on use of criminal.
Okay, so that's that. All right, now, before we get into all the New Jersey ones and me pointing out the laws and getting into the New Jersey law against discrimination, let's look at this example. This is an actual news story I got from Columbia, South Carolina, where a real estate agent was engaging in discrimination and discriminatory practices. It was reported to HUD, an investigation started. So you're going to see here from the beginning to the end what the resolution is. So basically, this reporter that did the story was shopping himself for a house for him and his fiance. So he's a white guy. He was marrying a black woman, and or was already married, or was marrying. It was his fiance, and they started shopping, and he felt like that they were discriminated against. So he started a little sting operation by sending different people from the studio, his college roommate buddy, he sent in there to go in, and started sending in people from different races and colors and couples and such to see how this, with undercover cameras, to see how this realtor would react to the different people. And he built a story on it, doing like an undercover sting on it. And then he presented it to HUD. So you're going to see from the beginning all the way to the end what the resolution is, what the outcome was at the end of the day. So that's why I show this, because I like showing the example. Under the federal laws, it'll show you how HUD handles it, how the court systems handled it, and all that. Let me know if this comes across choppy for you too, though.
High rise in Columbia, no African Americans living there. Is there a reason? Good evening, and thanks for being with us. I'm J.R.
And I'm Darcy Strickland. The reason could lie with one real estate agent. A News 19 investigation uncovered what appears to be active discrimination inside a prominent Columbia high-rise.
News 19's Johnny Chappell has been working on this story for months now, and he joins us with the details.
Obviously, it's a lot of work into this story, and we hope that we can bring some possible good out of it, J.R. and Darcy. Who has the right to tell you where you can live? In January, I started looking to buy a new home. The very first place I visited, a realtor told me that for 25 years, the building had remained exclusively white. Her comment sparked our investigation, and our investigation has the federal government working to take action. Looking up from anywhere between 5 Points and downtown, it's hard to miss. 1829 Senate Street, a 30-year-old high-rise, 19 stories of high-end housing. In all, 96 luxury condos. The Heritage, all white on the outside, and there's a woman who may be trying to keep it all white on the inside. And Bryant is a long-time Heritage resident. She's also a realtor, and she shows just about every property that comes up for sale in the building. After my experience, we sent a team to investigate. A News 19 employee, her sister told Bryant they wanted to see what was available. Bryant showed them 2 occupied condos before going inside a condo for sale on the 12th floor. At the time, the residence was not on the market. Bryant said she thought it would list for around $170,000.
It's choppy.
Now, let me ask you a question. If you have yeah, I know it's the audio for the undercover is a little bit muffled. That's why they got the what do you call it? The subtitles there. let me ask you a question. She says here, when I have a listing anymore, I mean, I may not even put it in the computer because she sells it just like that. Wait a minute. When you get a listing, how soon are you supposed to put it in the MLS?
Yes.
24 hours.
24 hours? Or
48 hours.
48.
Oh, 48 hours.
Remember, all written offers have to be presented or forwarded within 24 hours. All listings have to be put into the MLS.
Say that
within
again.
48.
You broke up on me.
Yeah,
Say that again.
all written offers have to be forwarded.
You broke up on me. You said all listings.
Yeah, all listings have to be forwarded within 24 hours, and all
Written.
I'm sorry, all written offers have to be forwarded to within 24 hours, and all listings entered into the MLS within 48 hours. Is me talking breaking up on you?
Yes. For me. I don't know about everybody else.
Just my talking is.
For me, you're fine.
Okay.
Yeah, you're for.
Pause for me.
Because I was about to say, if my
I
talking
can hear you.
if my talking alone is breaking up on you, then this video is going to be useless to you. All right, but I'm recording it so you can take a look at it again later too. But let me know for the majority of the people here if this is this video is getting all broken up and you can't really understand it at all. If that's the case, I'll just skip through it and you guys can watch the video watch this video on the slideshow itself on your own when you get a chance. This is just a demonstration, me showing you what's actually happening here, and then based on what we've already learned, what the procedures are for HUD and bringing a case to the federal court versus HUD.
It was just, they go like that. And she said that all prospective clients and their realtors raised their her. People to show Bryant went on to indicate that race determines whether she allows a person to sue or inquire about purchasing property. She makes those differences appear black and white. Bryant referring to possible discrimination. She said to me
I don't understand any of that.
We have to take to Devin Gregory, who's from the U.S. Department of Housing.
Were you able to read the subtitles on that? Because what she was saying is muffled anyway, but
but when
were you able to read the subtitles on that? Or is the video
they
broken?
took the subtitles away, I don't know what they were talking about.
Well, it's just the reporter saying that he took that that video and brought it over to some guy, his last name is Dudley, from the Department of Housing and Urban Development.
In urban development,
That conversation is enough to give me pause and that I would want to look further.
Gregory.
So he says that he wants to, based on that conversation that's recorded, is enough for him to want to look into it a little bit further.
He said Bryant's behavior very likely violates the federal law. Under the Fair Housing Act, a realtor cannot discriminate in 7 protected areas, including race.
The issue is, how many people have been to that place that are minorities that have been denied even come through the door?
Local realtor Shelby King says those licensed in her field must complete class time every 2 years to keep up to date on the Fair Housing Act.
Well, for us, it's every 3 years now. We have to complete training, which is our Realtors Code of Ethics training class. But now we also have for your every 2 years pertaining to your licensing, you also need to complete your continuing education, which includes ethics and fair housing as well, that training. And that's what she's talking about right here, or she's about to talk about here. She's going to explain, when people call up, sometimes they ask questions, well, who lives in the neighborhood, and how she can't address that question because it could be deemed discriminatory, because you're not selling the neighborhood per se, you're selling or selling who's living in the neighborhood. You're selling maybe the looks of the neighborhood and the house and its features.
Reminded about fair housing constantly.
Seems like standard clauses in buyers and sellers agreements that deal with the law. She says there are certain things a realtor cannot discuss when showing a property, and that sometimes she's had to steer clear of her client's questions.
I mean, when use of reference to say that we're not prejudiced by. What's the next of the neighborhood? And how can I address that?
See, so I get questions like that, or I have gotten questions like that in the past. Not so much as I'm not prejudiced, but what's the mix of the neighborhood? I've never had anybody ask me like that. I have had people ask me about a condo I had for sale, and then they would ask me, well, who lives there? And I'm like, well, there's a lady living there still, but she'll be delivering it vacant. She'll be gone. And they're like, no. Who lives there in the complex, in the neighborhood? And my response to that would be, they're people. I'm sure they're very nice people, but I can't really talk about it. I know what you're getting at. I can't really talk about the makeup or the composition of the neighborhood. That could be deemed discriminatory, and I could lose my license and get fined for that. So sometimes you get people that even give a response. Oh, no, you got me all wrong. I remember this one lady, she gave a response like this. Oh, you got me all wrong. Me and my husband, we're New Yorkers. We're from New York. We want a more diverse neighborhood. So who lives there? Ma'am, it does not matter your reasoning behind asking the question, whether even if you pose it in the light that you're looking for non-discriminatory reasons. I cannot answer those questions. If you're interested in the unit, come down. I'll show it to you. You can walk the neighborhood, talk to the neighbors, and see if it's a place that interests you. Okay, that's the way that you should talk to people. Okay, don't just blow them off. Try to get them in for an appointment, but tell them that you can't talk about it because it could be deemed discriminatory and you can't talk about such things. But they could come down, check out the house, walk the neighborhood, talk to the neighbors, and see if it's a place they want to be. Okay, and just leave it at that. You should try to avoid any kinds of conversations leading on to who lives in the neighborhood. Okay.
I would Ann Bryant, who's required by her profession to adhere to a federal law, risk losing her license. She agreed to meet us at the Heritage for an interview. You said you showed most of the properties here. To the best of your knowledge, have you ever discriminated based on a person's race as to whether or not they can live there?
Everybody can live at the Heritage. We have no discrimination of any kind in the building.
She denied ever talking about race with potential buyers, even after I told her about our investigation.
We've had several people come to us and say that you say that this is not a mixed community, that it's only white people allowed to live there.
No, I've never made that statement to anyone. I would certainly lose my license if I do a thing like that.
For anybody who could not
That's so
hear that,
crazy.
for anybody who couldn't hear that, they caught her on tape saying we don't have a mixed neighborhood in here. You see that screenshot right there? And he was asking her straight out, well, we got reports from several people that you said that this is exclusively white. And she's like, oh, no, I certainly would not make a statement like that. I'd certainly lose my license, in her Southern drawl accent there.
But I've never made a statement like that.
So here's what's happened as a result of our investigation. Today, Ann Bryant submitted this letter to her employer. She's retiring from real estate effective immediately. To remind her agents and their agents of the importance of this issue.
So she's just going to retire. She submits a letter of resignation and retires as a result of
Effective immediately.
Yeah, effective immediately.
Effective immediately.
But let me ask you a question about this, though. If she so basically she's just okay, I won't work no more until the problem blows over. Right? That's the view that I'm saying. I'm like, wait a minute. You can't just let it go at
More
that.
like they were like, you gotta go. You can't work no more.
Yeah, but still, nothing's going to happen to her. They're just going to let her retire like that, just bow out and nothing happen. Hold your horses, guys.
I mean, if you,
Well, watch. There's more to this story.
Okay.
It's not just left at that.
Agent to sign a second ethics policy. Also, I've spoken with the president of the Heritage Homeowners Association. His comments: we don't discriminate in any way at all on the issue of why Bryant has been on hand almost every time a prospective buyer looks at a condo for sale in the building. The president said, quote, she is not authorized by the board to show property. After viewing our tape, HUD opened its own investigation. HUD officials have told us their attorneys will be able to make a decision based on the possible violation of federal law very soon. And of course, Joe and I will keep you posted.
Well, Johnny,
So HUD opened its own investigation, and now they're about to ask a question. Have there been any accusations of discrimination against her in the past? And then they're going to go into, well, yeah, there have been.
has this realtor had any past incidents?
We found out today, yes, he has. In 1997, a couple filed a claim against Bryant's former employer, naming her and her realtor as accusing her of stealing. That's a practice referred to right here in the Fair Housing Act. Protected class, what type of housing or location would or not be appropriate for them, steering them in that direction. Her employer settled that claim, and Bryant had to pay a fine for that offense. There's certainly a lot coming out of this story still to come, and we're going to continue to follow it in the next couple of days.
All right, Johnny, thank you.
Well, we also contacted the State Realtors Association after our investigation of the Heritage, and this is how they responded to what we uncovered. Realtors adhere to a high standard of integrity and a code of ethics that requires equal access to fair and affordable housing for all, regardless of race, color, religion, sex, handicap, or national origin. They go on to say, as realtors, we deplore and will actively pursue action against any member whose actions run contrary to the federal or state fair housing laws or the Realtor Code of Ethics.
Well, we would like to get your feedback on our investigation of the realtors. There are two ways you
Okay, let's fast forward this now because that's the end of that, except for let's find out what actually happened. In 2005, HUD launched an investigation and reached a settlement with her broker, Century 21 Bob Capes Realtors, and Bryant had to give up her real estate license. And then she died shortly thereafter. But that's not the end of the story. But that's not the end of the story. Jared Glover, a Black public relations specialist for the city of Columbia, South Carolina, was Chappell's roommate. That's that reporter's roommate. At the time Bryant made her comments. Remember, he was sending all people in there, friends and roommates and people that he knows to go in there, part of the sting, you know. Well, he ended up filing a complaint against the broker too for discrimination. And what happened? His broker ended up awarding him $90,000.
Wow.
Keep in mind, she's already dead. So and this guy really wasn't shopping for housing. He was just pretending to shop for housing to try to get her in a sting here. And so he ended up making $90,000 off of that little ruse that they pulled on that in that reporting sting. See, even a broker can be held liable if they had guilty knowledge. Or even if they didn't have guilty knowledge, should they have known about her activities? So this lady, she's already dead, and the broker is still being held responsible for her actions and had to pay out $90,000 in this payout. And let me see, is that any more to this? And then as part of that, they all have to take fair housing training and stuff and whatnot. Okay, so that's that. That's what happened from the beginning to the end of this situation. That's why I like to share that story right there, because you see right from the beginning, somebody who's actually doing discrimination, and then they get reported on it. And then it takes a little while, but HUD started their own investigation. And then even after she died, they kept investigating and people were held accountable. Her company was. All right. So,
But
And-
from a broker, sorry
Yeah.
for cutting you off, but from a
No.
broker standpoint, wouldn't it be hard to know if your agent is doing something like this?
yeah, it's not easy being a broker. You could be held liable for things that your agents do. I used to have a joke, you know why they call them brokers? Because they're always broke, you know, but yeah, you could be held liable for things that your agents do. So don't be shocked or surprised when your broker's riding your butt all in your business, wanting to know what you're up to, even if you're not showing up to the office. They're following up, trying to see, hey, what have you been up to? Have you been doing anything with the business? Because they want to be aware of your activities, because you just simply hanging your license with that brokerage and they don't see you around, you're a possible liability for that broker if you're doing something, if you're up to something, So yeah, the broker's got to be interested in your business. They got to be looking at your files, your advertising, maybe having conversations, finding out what have you been up to? You work for me. What have you been up to? Even though you're an independent contractor, I could still be held liable for what you do. So don't think that this is the Wild West. You're self-employed. You could do whatever the hell you want. You're still under my supervision and I'm liable for the things that you do. So I'm going to be probing and asking questions to find out what you're up to, because if you're up to no good, I could get in trouble.
Yeah.
Me personally, as a broker, I've fired several people before because they would not update me on things. So I just got rid of them. They're too much of a risk. And then I got rid of one guy, I remember. I got rid of this one agent because he was up to some shady stuff. Now, how do we word this here? He was used to things and how they were done in his country. And he was very thick-headed, He's now living in the United States. I don't know if he was a citizen or not. And he was up to some really shady stuff, and he would explain to me some of the things he was doing. And I was like, no, you cannot do this. You cannot do this. But yet he kept ignoring me and doing whatever the hell he wanted. So I fired him. I got rid of him, because he's going to get me in trouble, So I got fired. I fired him and I got rid of him because he was like, well, in my country, this is like, we do this stuff all the time. I was like, well, this is not your country. If, your country is now the United States. You're living in the United States. This is the way we do business here. You're not in your country anymore. This is the way that it's done here. You need to follow the laws here. This is the way that's done here. And he had this attitude, well, stupid America and Americans, And I'm like, listen, buddy, this isn't a corrupt country that you could do whatever the hell you want. There's certain rules. You got to treat people fairly, honestly. Didn't you take a real estate class? And see, you can lead a horse to water. I could train you how to do stuff, but at the end of the day, when you get out there and you're on your own, you're going to do whatever the hell you want. And if you do things wrong, you do things illegally, there's consequences for that if you get caught, for you as well as for your broker, so keep that in mind, so as a broker, I'm telling you, I had to fire people before. I got rid of people just because they didn't report back to me or they refused to communicate, and I'm liable for what they're doing. So I got rid of them. I told them, go hang your license somewhere else. I had an agent, like I said, that he was blatantly telling me stuff that he was doing wrong. And I was like, you got to stop this, give that money back. You can't do this. You can't do that. He still did the same thing. So I was like, you're fired. You're fired. That's right. I just fired you.
Wow.
Be lucky that I didn't report you to the real estate commission. You're fired. Get out of here. People get stuck in their ways or what have you, I'm
I feel like that's a little bit harsh on you because like it falls back on you, and I feel like that's just a little bit crazy because
it's very disrespectful. Very disrespectful. But the thing is, he was trying to screw over clients, and that's not the kind of reputation I want, you know, and I certainly don't want an agent that's acting like that. And, you know, I tried to have a conversation with him because my first reaction isn't just, you know, you're fired. You know, I want to get your line of thinking. What's going on here? Maybe you're just not understanding something, you know. The guy had a little bit of a language barrier, or at least he had a very strong accent anyway, but his English was pretty good. But I just wanted to make sure he understood, because you don't know what's going on in people's heads, you know. So I want to make sure he understood the rules and how things had to be done. He understood, he just didn't give a crap. You know, so bye. All right, let's talk about the enforcement of the federal anti-discriminatory laws before we move on to the New Jersey one, which is on the same slide. So who enforces the federal laws? You know, the Civil Rights Act of 1866 and the Federal Fair Housing Act of 1968. Well, pertaining to real estate part of it, HUD does. HUD enforces those federal anti-discriminatory laws pertaining to real estate. And you have 1 year to file a complaint and have it heard in front of an administrative judge within HUD, or 2 years if you want to make a federal case out of it and have it heard in federal court. Even though the older one, the Civil Rights Act of 1866, there's no option. It must be heard in federal court. But charges brought under the Federal Fair Housing Act of 1968, they can go before HUD or federal court. Now, this term called an injunction, I'm bringing this up right now because for some reason, state exam likes to use this word, likes to put, you may get an exam question just on this word, knowing what an injunction is. Let me see, where is that? 73. Okay. On 73, under enforcement, we'll see it. I'll have a place, I'll show you a screenshot. But an injunction, what is an injunction? It's when a judge orders somebody to do something or to not do something, to refrain from doing something. So it's when a judge orders somebody to take action or not take action. For example, if a landlord turns down a tenant, they deny a tenant for discriminatory reasons, and the tenant prospect takes them to court, a judge can order a landlord to rent to somebody that they previously turned down. So when a judge orders somebody to do something, that's called an injunction. Okay, that's what an injunction is. It's easy to understand, but for some reason I don't know why that's a question on exam, but it is. Well, we'll be highlighting these things, don't worry, because in the coming slide, like I'll show you in a sec, you know, I'll just show you right now. Just do these highlights on the next page. It's page 73.
So I have a question.
Yeah.
Would you advise people to be brokers, or would you just tell them to?
Yeah, absolutely. But it's not an easy job. I'm not gonna pretend it is. You know, it's a lot of responsibility. It's a lot of responsibility to be a broker.
Don't leave no money on the table.
Well, the thing is, it's also supervision. You know, you got to supervise a lot of adults. Some of them act like children. Some of them are worse than kids. You know, and especially once they become adults, you know, they got it stuck in their head that they know things a certain way, and this is the way I know them. This is the way I brought up. This is the way it is. You know, this, you ain't changing me now. I'm too old. You can't teach an old dog new tricks and all that. You know, that could be a problem especially if you're not doing things right. You know, come on, even an old dog can be taught new tricks. You know, I could prove that to you. My mother was very resistant about learning about using a cell phone and technology. She's like, "Oh, I'm not good with technology. Don't buy me any phones or anything." And I was like, "Ma, you got to drive a distance." This was a couple of years ago. I was like, "Ma, you got to drive a long distance to go to work." I'm like, in case you get a flat tire or something on the turnpike, you know, let me get you a cell phone. You could reach out to me in case of emergencies and such, you know. oh, I don't know how to use technology. I bought it for her anyway, and I got her a smartphone, and she's like, oh, I'm not going to learn how to do these things. I don't know how to do these things. I'm like, what? You don't know how to use a phone? You use buttons. You just got to press this button on the side. The light goes on. You press this button, and then you get a keypad, and it works just like a regular phone. It's like not difficult. And next thing you know, I teach her how to do a search on Google for something or to get directions.
Now she's texting.
And now she's texting, she's using Facebook, she plays games on her phone, trivia games, like you can't peel her away from the thing. We watch a movie and she's doing research on the actors and the history and their families and stuff. And I'm like, Ma, give it a break. I don't care about the actors. I care about the movie. I'm just here to be entertained by the movie. I could care less about the actors and their real lives, And like she's like a guru with the stuff now. So yeah, you can teach an old dog new tricks. That's nonsense for anybody who says you can't, So, okay, everybody got these highlights? I want to move back to that previous slide so we can finish going over it.
I got it.
Okay, now before I do go over it, for the federal violations of the federal anti-discriminatory laws, I do not have this on the previous slide because you do not need to study it. There are fines for violating the federal law. You do not need to study or memorize them, and I don't know how the hell you would remember them. The fines range for a first offense of any of the federal anti-discriminatory laws up to $21,663. I don't know where they get the obscure number from. Don't ask. To $54,157 for a second violation, and up to $108,315 for further violation. I don't know where they get those weird numbers from. I don't know where they were made up. I don't know. You don't need to study them or memorize them. You will need to study and memorize the fines for the New Jersey laws because they're even numbers. Easier to remember. So the New Jersey.
You said the fines for what?
For the violations of the federal anti-discriminatory laws, the Civil Rights Act of 1866 and the Federal Fair Housing Act. These are the fines. These are the statutory fines, which are obscure numbers, right? You don't need to memorize them. But for the New Jersey law against discrimination for violating them, you need to know these fines. They're even numbers. We'll get into that in a moment. Let's first talk about it. The New Jersey law against discrimination, or LAD for short. I'm not sure how they'll refer to it on your exam. It could be referred to as the LAD or the law against discrimination. It covers all real estate. What kind of property does it cover? It covers all real estate, residential and commercial. Let me ask you a couple questions about the federal laws. What is the Civil Rights Act of 1866? What kind of property is covered under that law?
You said what kind of property?
Yeah, what kind of property is covered under the Civil Rights Act of 1866?
Residential.
Think for a second. What happened?
Or land. Is it land?
Oh, hold on a second. Let's think for a second. This is the way to remember it. This is a perfect opportunity for me to tell you a good way to remember this. What significant thing happened in the 1800s pertaining to civil rights?
I don't know, war.
Segregation.
Oh, freedom.
Lincoln freed the slaves, and he said that all people have a right to free and to have a place to live, to own.
So it's real and personal property.
Real property and personal property. So yes, for real and personal property, all real estate, whether it's residential or commercial use, all real estate and all personal property. So the Civil Rights Act of 1866 covers all kinds of property, all property. Now, what about the Federal Fair Housing Act of 1968? What kind of property is covered under that law?
Residential.
Yeah, you got the keyword in there, housing, that's residential real estate. And the
Oh,
New,
that would make sense.
yeah, but see, I'm trying to get you to get it to click.
So,
It, like, if
sorry.
you don't remember it, you could just read the title and try to think, well, what happened back in 1866? Well, Lincoln freed the slaves and then said they have a right to own all kinds of property.
Yeah, well, it would make sense 1860,
Yeah.
real and personal. Okay.
Yep. And then with the Federal Fair Housing Act, well, housing, you live in a house, that's residential real estate. So it only covers residential real estate, not commercial. Okay. And then we have the LAD, the New Jersey Law Against Discrimination, covers all real estate. It doesn't cover personal property at all, but it does cover all kinds of real estate, both residential and commercial. And complaints are enforced by and investigated by the Attorney General's office, the state Attorney General, or the federal Attorney General for that matter. So the state Attorney General is the highest law enforcement officer in the state.
Right.
Who investigates violations of the federal anti-discriminatory laws? HUD. HUD has their own investigators. They're the federal investigators. New Jersey has the state Attorney General. That's the highest law enforcement office in the state. And how long do you have to file a claim under federal law? 1 year, unless you want to make a federal case and have it heard in federal court, and then it's 2. The LAD, under the New Jersey Law Against Discrimination, you have 6 months, 180 days to file the complaint. So those who interfere with the investigation could be subject to up to a $500 fine and 1 year in prison. And the Attorney General's memorandum is a document that needs to be given to property owners at the time they list the property for sale. So the Attorney General is the highest law enforcement officer in the state. A memorandum is a fancy word for a notice. So this is a notice coming from the highest law enforcement officer in the state, the Attorney General. Who do we give it to? We give it to property owners. What's it about? It's about discrimination, the state and federal anti-discriminatory laws. So when do we give it to property owners? At time of listing. So the LAD and federal laws must be given to property owners at the time of listing. You know what? That's a little misleading. It talks about the federal laws. The Attorney General's memorandum needs to be given, which talks about the federal laws and the state laws. And that needs to be given to the owners at time of listing. So you don't give the owner the law, you give them the document coming from the Attorney General, which talks about the law. So do you give them the LAD, which is the law, or do you give them the Attorney General's document, which talks about it? You give them the Attorney General's memorandum.
Or
you don't give people the law.
Okay.
You give them the Attorney General's memorandum, which talks about the law. Okay, so the Attorney General's memorandum is that notice that has to be given to property owners at the time you get a listing from them that tells them, hey, property owner, whether you use me as your real estate agent or not, you need to follow the law. You can't discriminate. And here's all these instances of discrimination in the protected classes. Okay. So we're going to be going over that Attorney General's memorandum and the updated 2021 one, which also includes that new FCHA law, which went into effect just last year, 2022. We're going to be going over that actual document in a moment. But before we do, we just want to learn the basics. The LAD is the law. That's New Jersey's laws against discrimination. It covers all real estate. We have to give any person who feels like they were discriminated under the New Jersey law has how long to file a complaint? 180 days or 6 months. And what document needs to be given to property owners at the time they get a listing? The Attorney General's memorandum.
The Attorney General memorandum.
And what should a licensee do if an owner tells you that they plan on discriminating? Refuse the listing. Licensees must refuse listings when a property owner indicates they have an intent to discriminate. So if somebody even if they're joking around with you, you know, it's hard to tell if somebody's joking or not. You know, you gotta tell them, well, I'm turning down the listing. See, on the Attorney General's memorandum, it even says on there that the licensee has to turn down the listing if you tell them you have an intent to discriminate. I had one guy ever actually read this document that I actually gave to him. And he's reading the Attorney General's memorandum, and he saw that line that the licensee must refuse a listing if the owner indicates an intent to discriminate. And so the guy started screwing me. He's like, hey, so basically what are you telling me? If I say I don't want to rent or if I don't want to sell to these people or these people, he's like, you're not going to take my listing? I said, yeah, I can't. And he's like, get the hell out of here. He's like, you're going to take the business. I'm like, are you telling me that you're going to discriminate? He's like, well, what if I am? Are you going to walk out the door? I was like, yeah, I'm sorry, I can't take the listing. Here, give me that back, you know. and he, you know, he thought I was screwing around with him. Yeah, and then he's like, no, I'm just messing around with you, but you know, because it says it here, you know. But really, how many agents actually will? I was like, oh, it's the law. We can't take the listing if you tell us that you plan on discriminating, because that's just going to be a problem down the road for us. And he's like, oh no, I'm just messing around with you. You know, I was like, okay, but you know, this is the law. Okay. So fines for violating the LAD, the New Jersey Law Against Discrimination, are up to $10,000 for a first offense, up to. It's not $10,000 for the first violation. It is up to $10,000 for a first offense, up to $25,000 for a second offense, and up to $50,000 for further violations. Okay, so you need to know. For first, second, and third offense under the New Jersey Law Against Discrimination, what are the possible fines? Up to 10, 25, 50,000. You need to know that. Then they give you a scenario and say, how much can somebody be fined if this happens and there's X amount of violations? Well, if there's 3 violations, how much can somebody be fined up to?
50,000.
50,000.
If there's
Well, wait, is it the first?
there's 3
first, second, and third?
violations, how much can somebody be fined? For the first one, it's 10,000.
Oh, okay, up to 50,000.
That's another 25, so that's 35,000.
So 85.
Up to $85,000, correct. Okay. Hopefully,
Okay, so you edit. All right.
hopefully you like my notes to study
Well-
from. The book, we're highlighting this line here, that line there, that line there. I try to put everything together neatly. These are kind of like notes for you to study from a little bit better, you know? Some of these slides, like this one, where I put together the fines, what kind of property is covered, what you can do. See, in the book, this is spread out over a couple of pages that you're highlighting stuff that's all disjointed all over the place. Same thing with the federal anti-discriminatory laws. You know, let me back it up a bit. You guys did not. You know, the blockbusting, also known as panic peddling, steering, and redlining, what it is. This is a good slide to study.
The 180 days for the complaint under the New Jersey LAD, is that something that we need to memorize as well?
Yeah. You need to know the time frame, what kind of property is covered under what law, what the time frame is that somebody can file a complaint, what kind of property is covered, and what the fines are. And who the protected classes are for that matter. Okay, so we started
Property is
with
covered
this.
is real estate, right?
Yeah, so if you want, snap
Say it
a picture
again.
of this slide again. I backed it up. So it was at the beginning of the slideshow. The Civil Rights Act of 1866 covers this. And then we have the Federal Fair Housing Act of 1968. And then the exceptions to it. Okay, but we don't need to study those. Okay,
It's the other page that I was highlighting. What was it?
Yeah. Hold on a second. I'm getting back to it.
19,
The enforcement on page 77 is where I was highlighting.
Okay, so here was the current slide that we just did for the LAD. And then we did these highlights on page 73. And this is also on page 73, nothing to highlight here about it though, but just in case you didn't know, you can't use threats or acts of violence to get somebody to sell or list their property or lease it or what have you. And if you come across anybody that does threaten you or your clients, you know, report it to the local police or the FBI. So under the New Jersey law, there's a lot more protected classes than under the federal law, which only had 7 protected classes. The New Jersey law against discrimination, New Jersey has a lot more protected classes. We have race, color, national origin, ancestry, nationality, creed. What is creed? Creed is your doctrine of religious beliefs. Sex, gender identity or expression, affectional or sexual orientation, marital status, civil union status, or domestic partner status, which I don't know why you would need these ones anymore, civil union status or domestic partner status, because gay marriage is now legal in New Jersey. Governor Christie signed that into law just before he left office. Familial status, pregnancy or breastfeeding, actual or perceived mental or physical disability. So even if you don't have a disability, if somebody thinks you have a disability, you just became a protected class. Actual or perceived. So that includes things like AIDS, HIV, COVID-19, or any other future diseases or sicknesses or illnesses that come about. Source of lawful income used for mortgage or rental payments. That includes Section 8 housing choice vouchers, state rental assistance programs, or the temporary rental assistance that we get from Catholic charities, Catholic and Jewish charities in New Jersey. That's a pretty popular one, TRA. And then we also have liability for services in the armed forces in the United States. How sick is that? You know, that we have to make the people who serve our country in the military to protect us. We have to make them a protected class because our society is getting so screwed up that people are spitting on our soldiers again. You know, it's also illegal to place any advertisements or make any advertisements or utterances that express directly or indirectly any limitation to offer housing or real estate based on any of these characteristics. And technically under the FCHA, ex-convicts are now referred to as system-involved people to try to soften how it sounds. That's actually true. I'll show it to you where they actually use that wording. You know, people who served in prison, when you're in prison, you're a convicted felon, you know, and now when you're out of prison, you're referred to as an ex-convict because you're no longer a convict, you are an ex-convict. Well, to soften it, to make it sound a lot nicer and you're not that bad, we'll call you a system-involved people. System-involved people. That's like calling the garbage man sanitation engineer. Not to belittle that position at all, but you know, it is what it is. You're a garbage man. You're picking up garbage. You're a sanitation engineer. Come on. And are considered a protected class in New Jersey. Yep, you'll see what I mean. Okay, here's a little guide. We don't need to go studying this guide though. I mean, I guess you can see what the protected classes are for the different laws. Now, the LAD prohibited activities and exceptions. So refusing to sell, rent, lease, assign, or sublet as a means of discrimination. For licensees, that's us, refusing to offer property or negotiate transactions with people as a means of discrimination, or lying about the availability of property. Changing the terms of a real estate transaction or offering special facilities or services to any person as a means of discrimination, or being involved with any expression, either direct or indirectly, any limitation based on discrimination, including statements, advertisements, publications, signs, rental applications, purchase offers, and records or inquiries. Some exceptions to this, the only exception is to the New Jersey LAD, applies to rentals. It allows rooms, apartments, or flats in certain types of housing to be restricted to members of one sex, provided that in advance it was clearly stated the intent of this building is meant to be for one sex, like a dormitory for college kids, right? You have the women's. This is a women's dorm or sorority or whatever, or a men's one. Now, keep in mind though, there's been a lot of distortions to this lately because we've been getting the gender identity or expression. According to New Jersey law, it's however you self-identify, and there's no rule or law on New Jersey's book that it has to be how you identify on your license or any documentation like that, because gender is fluid in some people's minds. You see me right now? I am a white male. You see me right now? I'm a female. You know, it's like that in New Jersey. So however you self-identify, the person can't discriminate against you. So if I'm a guy and I go in to rent from you and you say, oh, no, this is only, we're only renting for women here. This is women's housing. Okay, well, I'm a girl now. If you discriminate against me and I just self-identified and told you I'm a girl, you're discriminating against me. Is that a little insane? Whatever. We'll just leave it at that. Yeah, everybody got their views on that one, but I think it's kind of the other side, the far side, or what were those? We're living in an alternate universe right now. Now, religious-based organizations to discriminate based on religion, and owner-occupants to discriminate except for race in the rental of a duplex. A duplex is side by side, two family, two units side by side. That's a duplex, or an over under. That's where one apartment's above another, two family house. Now, note that these exemptions are similar to those under the federal fair housing law. New Jersey law, however, does not contain the federal exception for homeowners selling their own homes, whether a broker is involved or not. There is never an exception for race, whether or not a broker is involved. Okay, so if somebody ever wants to discriminate based on race, it doesn't matter if a real estate broker is involved or not. Whether under state law or federal law, there are no exceptions pertaining to race. It goes back to the 1866, right? You can never discriminate based on race and color or religion. They added in 1988 or something like that. The religion or nationality or country of origin or something along those lines. All right. So I put together this little guide for you that basically shows you what kind of property is covered by each law. This way you get it at a glance. Okay, so Civil Rights Act of 1866 covers all properties covered by that law. Federal Fair Housing Act of 1968, known as Title VIII of the Civil Rights Act of 1968, does not cover personal property. It does not cover commercial property. It only covers residential real estate. And the LAD, the New Jersey law against discrimination, only covers real estate, but it covers all real estate. So it doesn't cover personal property. It only covers residential and commercial. See, isn't that a handy little guide? This, you may want to snap a picture of this one. It's a handy little guide. You could see it at a glance, what kind of property is covered by what law. Good.
Got it.
Okie dokie. Now, blockbusting and record keeping. What is blockbusting? You're trying to play on the fears of somebody. You're trying to build up and then play on the fears of a protected class. You're trying to sell that panic peddling, trying to get a homeowner to sell their property. So let's highlight the commission requires any brokerage soliciting from, now technically this wording is wrong. It's when you get 3 or more listings on one street, or I forget if it's one street or one block to be exact, but it's when you get 3 or more listings for one block or one street. You have to keep records of how you got those listings, just to make sure in case any accusations come up later that you were engaging in blockbusting, we can look back and see, well, what method did you use to solicit those listings? Okay, so the way that it's worded here in this book, I think, is incorrect. It says the commission requires the brokerage soliciting listings from more than 3 homeowners in a block, or maybe it's just the way that they word it, because sometimes they word things wacky. When you get 3 or more listings on one block, you got to keep records of how you got those listings, how you solicited them, to make sure that we have a record that you did not engage in illegal blockbusting. During any single month, or whether by mail, telephone, or door-to-door canvassing, to keep permanent records of that activity for at least 1 year, in case somebody files a complaint. And then New Jersey also has its own equal housing poster, or fair housing poster, and failure to display the poster, it does not mean you're automatically guilty of discrimination like the federal law. However, there is a fine, and that fine is $100 or more. Let me know when you got those highlights on 75.
Got it.
Good.
And if we turn to page 76, we could see the equal housing opportunity poster. It looks like a New Jersey's equal housing poster, which seems to
Can you
change.
go back
every
to
year.
slide real quick? There's just one more I need to talk about.
Is this what you wanted?
Yeah, I'm good now.
Okay. So this is New Jersey's fair housing poster. Seems to change every year. There's many different looks of it. I don't know where to actually get the printout of these posters. I looked on New Jersey's websites and I couldn't find it, but went to the civilrights.gov. It's not there. I don't know where to get this, but it's there in the book. You know what? Let me take a look and see that QR code. Maybe perhaps if we scan it, it'll take us there. Or does that take us? Maybe, or does it just take us to the civil rights page? Yeah, that's all it does. You know, it's an interesting thing. I just pulled it up and it took me to the civil rights page and I'm scrolling down on it looking for the poster. And let me bring something up right now. You see that? It says Me Too. You guys remember that whole Me Too movement?
Yeah.
You know, what was that about? You guys recall what that was about, Me Too?
I don't know what it is.
Sexual assault, sexual victims.
Yeah, it was about sexual assault victims. So basically, that's why you even had in some states, they were like, up until a certain date, we're going to give 1 year where past sexual assault victims, doesn't matter how long ago it was, it could have been 50 years ago, you could claim sexual assault against somebody, which I don't know how you'd prove that, but you don't have to prove it because you have to trust her because she said that she was sexually assaulted, right? And remember, they were canceling people who dare say that, how could, dare question that person's accusation of being sexually assaulted because you have to trust her, right? You guys remember that whole thing? Well, what about right now, what's going on? Right here in New Jersey. I mean, it's going on all around the country right now, but what about right here in New Jersey? We're seeing a conflict going on in Israel right now where they keep getting attacked, and they had a raid on January 7th, and civilians were murdered, decapitated, women were raped, women were kidnapped and continually raped and being held as hostages right now, being raped. What about, how come nobody's talking about those rapes that are going on over there? You're getting people instead, they're talking about free Palestine and all that stuff, even though there is actually no country called Palestine. It's actually Gaza, where they've been granted that area. Now, we got all these Jewish people all these Jewish women that have been raped, and nobody's talking about them. There's no more Me Too. I seen a new thing that was actually going on, because this is going on in New Jersey college campuses. You're getting these kids. If you got kids in New Jersey college, what the hell are you paying for? What kind of education? You're paying for indoctrination over here, where people are calling for that it's okay for the eradication and killing of Jews, and it's okay to rape a woman if she's Jewish. There's no more Me Too movement. It's like there's a whole campaign going on now, Me Too, unless I'm a Jew, which kind of like slaps your face with that kind of a statement. But that's true of what's going on right now. It's interesting to see how the state's going to handle that, because our federal government certainly isn't approaching it the right way. We don't know whose side they're on or who they're with right now, because it's all about campaigning and politics. But it's interesting how civil rights are very important unless you're of a certain political party, or unless you're a Jew or not, or it's really interesting the way people selectively choose which laws they want to enforce or believe or what have you. Just throwing out my own personal thoughts out there. All right, so let's talk about the enforcement of the New Jersey law against discrimination. You could make these highlights, but we're at lunch right now, so I'm going to pause the recording. Okay, so now that everybody's got these highlights, you have 6 months, 180 days to file a complaint underneath the LAD. The fines range up to $10,000 for a first offense, up to $25,000 for a second, and up to $50,000 for further violations. Complaints are filed with the Attorney General's office, and then the Fair Chance and Housing Act can subject someone up to $1,000 for a first violation, and $10,000 up to $10,000 for 2 or more violations. Well, up to $5,000 for a second, and up to $10,000 for 2 or more violations. All right. So you got to give a copy of that Attorney General's memorandum to the owner at the time of listing. It's on page 77. And salespeople and brokers have to refuse listings from owners who indicate they have an intent to violate the LAD. Everybody got that?
1 second. I got it.
All right, now we're going to go over the Attorney General's memorandum, the actual document. As you can see, it kind of looks like an email to, from, date, subject. It's to property owners from the Attorney General. Here's the date that it was updated, and it's about housing discrimination laws. It's coming from the Office of the Attorney General, the highest law enforcement position in the state. And the New Jersey REC requires every licensed broker or salesperson whom you list your property with to give you a copy of this notice. And the purpose is to help you comply with the LAD, the New Jersey Law Against Discrimination, as well as the new Fair Chance in Housing, the FCHA, which is effective January 1st, 2022. Now, under the LAD, it's illegal to discriminate against a prospective or current buyer or tenant because of the actual or perceived, and now they go over all the protected classes: race, religion, national origin, nationality, ancestry, pregnancy or breastfeeding, sex, gender identity or expression, sexual orientation or familial status, disability, liability for services in the armed forces, marital status, civil union status, or domestic partnership status. It also is illegal to discriminate to any prospective or current buyer or tenant because of any source of lawful income that they receive for their rental or mortgage payments. And it's also illegal to make, print, or publish any statement, including print ads and online postings, expressing any preference or limitation on discrimination based on any of those protected characteristics. So the LAD applies to a wide range of activities, including advertising, selling, renting, or leasing, subletting, assigning, and showing property, including open land. And here are some of the issues that commonly come up when enforcing the LAD. The prohibition of discrimination based on source of lawful income means, for example, a landlord cannot reject a tenant or a prospective tenant because they intend to pay with subsidies or vouchers provided by federal, state, and local assistance programs, including Section 8 housing choice vouchers, COVID-19 emergency rental assistance, state rental assistance programs, or TRA, or eviction prevention program, EPP benefits, unemployment, child support, alimony, or supplemental income. So basically, you can't turn away somebody because of their source of lawful income. A housing provider cannot advertise a property in any way that discriminates based on their source of lawful income, including by posting advertisements that state directly or indirectly that they refuse to accept or express a limitation on vouchers or subsidies. For example, you can't have any advertisements that state no Section 8 or TRA not accepted, or this property is not approved for Section 8. They violate the LAD. You know, if a property is not approved for Section 8, it could get really easily approved. In addition, housing providers must calculate any minimum income requirements for the financial standard or income standard based only on the portion of the rent that's to be paid by the tenant, and not based on the entire rental amount, which is being subsidized. So the LAD also prohibits bias-based harassment in housing, including sexual harassment. If a tenant is being subjected to bias-based harassment, that creates a hostile environment. And if the housing provider knew or should have known about it, the housing provider must take reasonable steps to stop it. That includes harassment by other tenants or by a housing provider's agents or employees. A quid pro quo sexual harassment, for example, is where a building superintendent demands sex or sexual favors as a condition for making necessary repairs or for getting your subsidies. Here's an example where this happened in recent years in Elizabeth. You have one guy who owns a bunch of rental properties, apartment buildings and whatnot in Elizabeth. And this guy gets about $102,000 each month from his buildings that he owns, ranging in size from 4 units to 100 units. The lawsuit alleged that since at least 2005 until last year, this was in 2001, Centanni engaged in severe and pervasive sexual harassment that included demanding oral sex in exchange for helping residents stay in their housing to receive the assistance. Authorities also alleged that he threatened to evict tenants who rejected his advances, and also demanded sexual favors even from prospective tenants. Can you imagine? This is a place you're just looking into to possibly move into, and you already got the landlord that's demanding sexual favors from you. That's crazy. I know a girl that lives in this unit. She lived there for years with her mother. And I remember sometimes, you know, she'd come out and she'd be like, "Oh, sorry, sorry you had to wait." She's like, "My landlord's such a freaking pervert. I had to get away from him." You know, well,
She said that to you?
yeah, she said that to me. So I guess I know what that was all about. That was years ago. That was years ago, when we were young. You know, she was like, "Oh, this freaking landlord, he's such a pervert." You know, well, now this story comes out. Now I know what that was all about. Check this out. While it's disgusting and understandable to be uncomfortable living here, knowing things like this are happening, does someone who enters your apartment and masturbates in your fiance's panties, does that constitute a crime or sexual harassment? This is actually what happened here. This landlord's employee, did he actually harass anybody though? Did he have the legal right to be in the apartment? Can a landlord enter an apartment without the permission of the tenant? Well, the answer to that is basically no. They can only enter without the permission. They can only enter without prior permission, except in cases of emergencies like gas leaks, flooding, etc. Otherwise, it's breaking and entering, and they can be charged with a crime. So landlords are not allowed to just use their pass keys to enter your apartment whenever they want. But the crime actually occurred here.
Top story tonight, a Hoboken couple says their privacy was violated. Their bedroom security camera caught a maintenance worker going through their things.
But it's what they touched that has them still uneasy. News 12 New Jersey's Erica Such joining us in the newsroom with more on this story. Erica.
The couple tells us they purchased this security camera to just watch out when anyone was in their apartment, but never expected to capture an employee of their building going through their underwear. Take a look.
It said there was a notification for motion, so I checked it.
The Rivington resident Alex Sacchetti says he was at work just a few weeks ago when his security camera in his bedroom captured moments a maintenance worker did something out of the ordinary.
I started watching and the man was, going towards the dresser. I was like, wow, that's strange. And then he opened it and he was going through my fiance's underwear. And, after I watched the entire event, there was potentially other lewd acts that took place, but mainly just going through my entire apartment.
The worker is seen checking the bedroom door, closing it, and turning off the lights before going into the corner of the room, blocked by pillows on the camera. Sacchetti says he quickly called management and alerted them. That's when this moment shows the man looking at the camera when he answers his radio call to leave the unit.
It was pretty much your whole privacy is violated.
Sacchetti says his fiance has been so upset by the situation, she's staying elsewhere for now. They filed a report with Hoboken police, but were told this.
He had the right to be in here, and apparently anything that took place is not a crime.
The two have been back and forth with Equity Apartments, who owns the complex, but says their responses have been lacking empathy.
There's been some outreach from some sort of manager or something, I'm not exactly sure. But as far as oversight or, hey, so sorry this happened to you, like none of that.
And while this situation still leaves him uneasy, Sacchetti says it's a warning for others.
People here or elsewhere at buildings should just have some sort of surveillance to fall back on.
And the couple tells us they're hoping to switch apartments in the near future. We did reach out to Equity Apartments for comment, but did not hear back. In the Newsroom, America Such, News 12, New Jersey.
So what do you say? I mean, he said he reached out to the cops and the cops said, oh, there's nothing illegal that happened there. Well, I would be demanding I'd be flipping my lid. I'd be demanding to speak to a supervisor because the cop that gave him that answer was totally wrong. Even though you have maintenance workers there, did they have a right to be in the apartment to begin with? Why were they in the apartment? Unless they had prior permission to enter that apartment, or they were there for emergency reasons like a gas leak or flood, there should have been no reason for them to be in that apartment. And that's actually violating their rules. It's considered breaking an entry. So
Does he have access to the keys?
yeah, apartment, maintenance workers or the landlord, they could have keys to the apartment, but they're not allowed to use those keys. Look, if you have a landlord, say, even if it's like a 2-family house and the landlord lives in one unit and you live in the other unit, can the landlord just use his key to walk into your apartment anytime while you're taking a shower, just walk in there? No. What is a lease? Just think about it for a second. What is a lease?
Yeah,
What
just
is a-
renting, right?
What is a lease?
A rent?
Well, what is a lease? What is the purpose of that document?
So you can have like a lease from time to time. I don't know how to explain it.
Okay. Here, let me
Like
explain.
a loan? No.
Let me mute everybody. You got some feedback there. Okay, so what exactly is a lease? A lease is a document. It's a contract where the owner of real estate intentionally conveys their access to their property. They're conveying their property to someone else, a tenant, for a limited period of time as defined in the lease. They're also conveying all their rights and interest in that real property that they have as owners to that tenant for the term of that lease, with the exception of the right to sell or mortgage the property, right? So a tenant's not allowed to sell the property or take out a mortgage on your property because you gave them a lease that turns over the physical property to them, and you're giving up all your rights to that tenant for that limited period of time. You're not giving them the right to sell the property, though, or to mortgage it. So because you gave up those rights and now the tenant has them for that period of time, you don't have the right to enter that apartment. Even though you own the building, you don't have the right to enter it. You gave that right to the tenant to occupy those premises. It's no longer your right to enter, except for with prior notice or for emergencies. Like if the water's flooding from the first floor to the second, water's coming out the front door, or there's a gas leak for in case of a possible explosion, it's for safety reasons, for emergencies. That's the only time you have the right to use that key to come into that apartment. Otherwise, the landlord cannot enter that apartment. That's breaking an entry. And you got some guy here who works for the landlord who's using the key to come in, go through your underwear drawer, and then masturbate in it in the corner of the room. That's disgusting, and it's illegal. It's not sexual harassment because the person may not have even known if they didn't have a camera. It's not sexual harassment, but it is disgusting, and it is breaking an entry. So it is illegal in that way. There's no sexual crime that was committed, unfortunately, there, but it is breaking an entry. He had no legal right to be in the apartment. Now, I had an example of this. I had a friend that I helped them move. They were getting married. It was a couple. I was friends with them both, and they were living in a 2-family house. And the owner of the 2-family house recently sold the two-family house. Now you got a new owner there, and here's another case where you have somebody who's from a foreign country. They moved to the United States. They bought a house here. They own the two-family house, and the owner of this two-family house just used his pass key whenever he wanted to come into their apartment. And she told me, the girl told me that one time she was coming out of her apartment. She was coming out of the shower. She just got out of the shower, and she was walking into her living room, and the landlord's just standing there in her living room. And then she's screaming and yelling at him to get the hell out. And he's like, "It's my house. I could do whatever I want." What would your reaction be if that was your wife or your fiance and she just got out of the shower and the landlord's standing there in the middle of the living room and saying he could do whatever he wants. He has the right to be there.
I would escort him out.
I'd probably beat the hell out of him, but
You gotta keep it a little nice.
yeah. Okay. For classroom purposes, yeah, I'd call the cops because he was breaking an entry. I'd be like, I just got out of the shower. My landlord's there standing in my living room. He got no right to be in there. That's breaking an entry. I didn't tell him he could come in. He had no right to come in. That's breaking an entry. But this guy, that's the attitude that he had. He was keep on coming in and out whenever they want. So they set up security cameras and stuff after that incident. In the meantime, they contacted me to start shopping so they could buy their own house. So I was helping them now look for their own house. But in the meantime, they also had to wait for their lease to expire because he wouldn't let them out of the lease either. And then they had a 2-car garage in this two-family house that it was the 2-car garage was actually connected. There was no wall separating the two units. So they also had a bunch of boxes and their stuff in boxes there. And they got security cameras they set up there in the garage. And they actually caught the landlord and his family going through their boxes and their stuff in the garage. He's like, "Well, it's in my garage. This is my house. I could go through whatever I want." You come across people sometimes like this, guys. I mean, I don't know how they work things in other countries, but generally, isn't it like, even though it's your property, you're renting it to me, that doesn't give you the right to go through my stuff and take my stuff and come into my house anytime you want, my apartment. I would assume that other countries work that same way. Or why has this guy got this attitude like this, But either way, he's not in his country anymore. He's now in the United States. So if you don't consider this to be your country anymore, because he's like, my country, well, this is your country now. You should respect people's rights. You got to follow the laws here, and this is the way that it works.
Wouldn't he have to get a warrant to do that?
To do what?
To go in the apartment?
He needs the tenant's implicit permission or in case of emergencies only. That's the only time a landlord can enter the tenant's apartment.
Gotcha.
Okay. The tenant should have called the police and filed a report. Now, they did, but then the landlord claimed, "Oh, I wasn't in there." So now it was he said, she said, so they're like, "We just want to get the hell out of here," So I helped them find another house. But yeah, it happens, and it happens more often than you think. But their rights are being violated. So the Attorney General's memorandum, once again, housing providers must reasonably accommodate tenants with disabilities, unless doing so would be an undue burden on their operation. For example, if a tenant shows that they have a disability and keeping an emotional support animal is necessary to afford them equal opportunity to use and enjoy the dwelling, the housing provider must permit the emotional support animal, even if they have a no pets policy, unless they could show that doing so would create some sort of an undue burden on them. Maybe they have a medical condition that would not allow that. Now, no pets rule cannot be enforced against a person with a disability who has a service animal, like a guide dog. A landlord may not charge a tenant with a disability an extra fee for keeping that service animal either, which we already went over. Landlords have to permit a tenant with a disability at the tenant's own expense to make reasonable modifications to the premises if such modifications are needed to give that tenant the full and equal opportunity to use and enjoy the dwelling. All right, so if you got a tenant with a disability, can a landlord tell a tenant that they can't put in a wider doorway or a wheelchair ramp, for example, if they needed it to get access to the premises?
You would have to do that, right?
They would have to allow it. But at whose expense? Does the landlord need to pay for it?
No, the tenant.
It's at the tenant's expense. Now, when that tenant moves out, can the landlord require the tenant to put the property back the way they found it? Now, that depends on what the modification was. For instance, if they needed to put a wider doorway to accommodate a wheelchair, that's not going to cause an undue burden on any future tenants. So they can't require that tenant to put that narrow doorway back in. So it depends on what it is. Future tenants would consider that a good thing. It's easier to move their furniture in now and get it through the door, So that's not going to create any undue burden on future tenants by having that. But maybe they could require them to remove the wheelchair ramping. Now, depending on the type of wheelchair ramping, some of them are like those metal ramps, which could cost thousands of dollars. And tenants going to take that with them wherever they go anyway, if they can. But let's just say that they made a makeshift one out of wood. Can the landlord require them to remove one that they built there? Yes, they can. Now, the landlord, the LAD rather, prohibits discrimination based on familial status. That's having the children under the age of 18, which includes pregnant women. So landlords similarly cannot use unreasonable occupancy restrictions to prevent families with children from moving in. I'll give you an example. I once had a couple looking for a house. It was a husband and wife. They had 2 little children and the wife was pregnant. So they wanted to find something to rent while they save up money so that they could eventually purchase a house for their growing family. And so she, while I was showing that, I set up an appointment to show this condo in Roselle Park, I believe it was. I was showing but we had to meet with the landlord there to let us in. There was no lockbox or anything like that. So we met with the landlord to come in, and the husband and wife and their 2 little children, they came in, they walked in before me, and then I was walking behind, and the landlord was there, and he grabbed me by the arm, and he's like, I'm not renting to them. And there was another room there on the side, so I kind of like shuffled them in that room. I'm like, what are you talking about? And he's like, I'm not renting to them. He's like, you see her belly? She's going to pop any day now. That's how he talked to me. He actually said that. Did you see her belly? She's going to pop any day now. Who the hell talks like that? And I was like, shh. I was like, what the hell are you talking about? And he's like, I'm not going to get in trouble for renting to too many people. The city has an ordinance that you can't have more than 2 people per bedroom. And there's only 2. This is only a 2-bedroom condo, and there's already 4 of them. And she's going to pop any day now. And I'm not going to get in trouble for renting to too many people. I was like, whoa. First, keep your voice down. Don't let them hear what it is that you're talking about right now. Because if you tell them that you're not going to rent to them because she's pregnant, you're going to get hit with a lawsuit so fast that it's going to make your head spin. I was like, you're not going to get in trouble for renting to them because, and he was like, oh, you're going to say whatever you want because you just want to earn a commission. I was like, listen, dude, don't take my advice. But I highly suggest you talk to your real estate agent. Forget about your real estate agent. I highly suggest you call a lawyer and talk to a lawyer before you say a word to them. Because if you do tell them that you're not going to rent to them right now because of her being pregnant, you're going to get slapped with a discrimination lawsuit so fast it's going to make your head spin. And I'll make sure that they do. So showed the place to my clients. They were interested and they wanted to rent. So he reached out to a lawyer, consulted with a lawyer, and the lawyer agreed with me. They said, yeah, you can't, first of all, that baby's not here yet, so you can't count that baby as an occupant, right? Right now, there's 4 of them. There's 2 bedrooms. They're in compliance. And when that baby is born, no town is going to say that you exceeded the occupancy requirement because you had a baby. You know, an infant, as it turns out, cannot be counted as an occupant until they reach 24 months of age, so 2 years. So as long as they know that once that baby comes, they gotta be out before that baby turns 2 years old. Okay, then that baby can be counted, that infant can be counted as an occupant. But by then they would have saved up their money to buy a house anyway, and that's what they just wanted to temporarily do. So they ended up actually renting the place. But that was a interesting scenario I came across, the way that guy was talking. Yeah. Hey, real estate's an adventure, guys. I've been in the business for a while. I've come across a lot of weird, strange things, that way that people act and things that people say. I could probably write a book or put a little mini story together, make a little movie out of it. The experiences of real estate agents, you know, from being chased by a deaf dog to having people having dog fighting rings in the basement, to walking in on homeowners who are selling their house, having sex with a cheating spouse. You know, I mean, I've come across it all. I've come across all these things. I showed a house once to this lady who was fearful of animals altogether, any animal really. You figure I'm showing her a house, you know, you figure that there's a Rottweiler or a Pit Bull or a German Shepherd or something like that, and the lady would be freaking out. But we walked into this one house, I opened up the front door. I thought it was a little toy on the ground, you know. It looked like this little toy dog that was walking like this, and then stopped and went meep 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 meep. It didn't even sound like a bark, you know. It was like meep 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 meep. It was like I was like, what the hell is that? You know, I thought it was a toy. And then I started getting on its hind legs. I was like, holy crap, that's a real dog. And I picked it up. I was like, oh my God, this is the cutest thing. And I like turned it to the lady, and she's like grabbing on my shirt and like walking behind me, like scared senseless. And I was like, are you for real right now? You know, and she was like, get it away. I was like, okay, don't worry about it. I got it. Look at it. It's a little thing. He's not going to harm you. Look, I could put this thing in my pocket. Relax. Don't worry. I won't put him on the ground. Let's just go through the house and I'll show the house. And I was like, oh my God, this thing was so cute. I held it in the palm of my hand. It was like one of these tiny toy. It was a real dog, but it was like these tiny miniature dogs.
It could have been a teacup dog.
Oh my! This is the smallest dog I've ever seen in my life. This thing was. I heard of teacup dogs and I've seen them before, but this thing was even smaller. I held it. I fit it in the palm of my hand. You know, but it was the cutest thing. It was like a pure. It looked like a little snowball. It was a pure white little thing, and it was like meep meep. You know, it was the cutest little thing. You know. Anyway, this lady, she was deathly scared of it. She truly deathly scared. Now, if she fell down and hurt herself or something, we got to watch out about stuff like that, because we're responsible. We're letting these people into this house. If she falls down, gets hurt, you know, we could be held liable for that. Or if this animal got hurt by her, you know, so you got to be careful about pet instructions and showings, and be careful about people's safety when you're showing houses too. But either way, that was the cutest little thing. Let's see. So selectively inquiring about or requesting information about the documentation of a prospective tenant or buyer's immigration or citizen status. Yeah, well, first of all, that's racist right out the gate. Just because somebody looks like they came from a different country or sounds like they came from a different country, you can't assume that they're not a citizen and that they don't belong here. All right. Now, in the past, we did have instances, because here in New Jersey and a lot of the United States, you know, if you got to ascertain if somebody is here legally in the United States, you know, but you can't assume that they're not a citizen or illegally here just because of the way they look. That is just a racist thing to do. So the buyer's immigration or citizenship status can't be questioned based on the way that they look, but their perceived original national origin or race or ethnicity or otherwise discriminating on such a basis. That's a violation of the LAD, and it should be, you know. But you know, New Jersey has, so as far as rentals go, you know, people, rentals and purchases go, people's source of lawful income can be verified. And, you know, if they can't prove they got a job or they're getting money from any kind of lawful source, well, then you don't got to rent to them. They got to prove that they could afford the apartment, right? Show pay stubs, show something, you know, where are you getting your money from to live, right? You can discriminate, and it is not discrimination if people are can't prove where they're getting their money from for their pay to be able to afford the apartment. Now, even with that stuff these days, you can't, because now New Jersey waved that magic wand again, and we made ourselves a sanctuary state. So even if somebody is here illegally in the United States, they're allowed to be here because we are what we call a sanctuary state now. So that can't be questioned anyway, not New Jersey. So as explained in the U.S. Department of Housing and Urban Development's April 2016 guidance document, oh boy, here's that thing again about the number of people in prison based on race. Because of widespread racial and ethnic disparities in the criminal justice system, blanket policies that make all individuals with any prior arrest or criminal convictions ineligible to rent, they violate both the LAD as well as the Federal Housing Act because they have disparate impact based on race or national origin and are not supported by legitimate business necessity, according to HUD now, as well as the state of New Jersey. So basically, they're basically saying, well, because now you see there's always a pretext to this. They can't make that claim because it is not legitimate. It's not a legitimate claim that the system is racist. So any background check you do is racist and cannot be trusted. So if you deny somebody rental because they're a convicted criminal, well, that's racist. Why? Well, because the system is racist. That's the leap that they're making. But if you noticed, it's they pretext the argument by saying, based on the HUD's Department April 2016 guidance document, and that guidance document was based on a previous document that person that President Obama appointed to HUD created based on the number of people that were in prison. So basically, he created this report, and now all these other laws and legislation were put forth based on that report from a couple of years earlier. So April 2016, HUD came out with this guidance document that declared the criminal justice system is racist because of that report that says there's not an equal number of people in prison based on their race. So therefore, there must be some sort of I don't even know what the hell that argument is there. That the system is racist. So therefore, if anybody was in jail and served time in prison, you still can't, because they were found guilty of crimes, you still can't use that as a pretext for not renting to them, because that's racist. So housing providers, housing providers may not use criminal history as a pretext for intentionally discriminating based on race or national origin. For example, applying criminal records-based restrictions against Black housing applicants, but not white housing applicants. Okay, well, that one I understand. If you're going to do a background check on people, you don't just do them on Black people, but not on white people or Asian people or Hispanic people. You do it across the board to everybody, right? But, you know, that the prior argument was about, well, you can't do the background check either. Doesn't matter, because the system is racist. So if you use background and their criminal history, that's a racist thing. But this other argument here in this sentence is that you can't just do background checks on these people, but not those people, and so on. Which, yeah, I agree with, because that is a prime example of racism. All right. So penalties, if you commit a discriminatory housing practice that violates the LAD, you may be subject to penalties not exceeding $10,000 for a first violation, $25,000 for a second, and $50,000 for more. Victims of discrimination may recover economic damages related to discrimination, such as if they had to pay for a higher rent somewhere else because the landlord denied them renting here because of racial or any other kind of discrimination, as well as damages for emotional distress, pain, and humiliation. In more egregious cases, a victim could also recover punitive damages. And this is a notice, keep in mind, to the owner. The broker or salesperson with whom you list your property must transmit to you every written offer they receive on your property. How soon do we need to do that? How soon do we need to transmit every written offer that they receive on the property to the owner? Nobody got that? Come on. 24 hours. Remember, any written offer has to be forwarded or presented within 24 hours. And brokers and salespeople are licensed by the New Jersey Real Estate Commission, and their activities are subject to the LAD, as well as the general real estate laws of the state. Okay, what do we call those statutes? Those Title
4515.
Title 45, Chapter 15. Those are the statutes. Those are the laws. And the commission's own rules and regulations, which we call the Administrative Code, or Title 11, Chapter 5. So the broker or salesperson must refuse your listing if you indicate to an intent to discriminate based on any of the prohibitions in the LAD either. And the sale or rental of property, including open land, whether it's for business or residential purposes, is covered by the LAD. Now, there are some exceptions, and these are those exceptions to the LAD. The LAD does not apply to the rental of a one unit in a two-family dwelling if the owner lives in the other unit, or to the rental of rooms like in a rooming house, or a one-family owner-occupied dwelling. A religious organization can give preference to people of the same religion. Now, we're not talking about a religious person who owns a house. We're talking about a religious organization that owns a property can restrict the rentals of its occupancy or lodgings only to people of the same religion. And that's not considered discrimination. In certain types of housing designated for older persons, it's not discriminatory against the familial status requirement to restrict people with children from living in the senior housing complexes and 55+ communities either. Those are the only those are the only exceptions to the LAD. Now, continuing on this new Attorney General's memorandum, now we're going to start getting into that FCHA, that Fair Chance in Housing Act, that was added December 2021, that went into effect in January 22. The FCHA prohibits housing providers from asking about the rental applicant's criminal records on an initial application or otherwise consider an applicant's criminal record in any way until after they made a conditional housing offer to the applicant, and with limited exceptions as required under federal law. The goal of the FCHA is to ensure that formerly incarcerated and system-involved people, see, there's where I told you, they're trying to rename ex-cons, ex-convicts, they want to call them system-involved people now, have fair access to housing around the state. Now, nothing about the FCHA requires landlords or housing providers to do a criminal background check. Yeah, no, duh, they would want to do that on their own, though. That's already well established. People want to make sure that they don't have criminals living in their house, right? If a housing provider, sorry, I got the fax machine going off in my ear here. I'll just wait till that's done. Give that a second. Waiting for that junk fax to come through. Yeah, it's warming up. All right, let's see. A housing provider must conduct an individualized analysis of the applicant's criminal record and may only deny housing if withdrawing a conditional offer is necessary to fulfill a substantial, legitimate, and non-discriminatory interest. So here are some of the specific requirements for housing providers under the FCHA. So housing providers are prohibited from asking about the applicant's criminal. Cancel. Sorry about that. Housing providers are prohibited from asking about the applicant's criminal records until after they made them an offer to rent from them, except if those convictions are drug-related criminal activity for the manufacture or production of methamphetamine on the premises of a federally assisted housing, or if the applicant is subject to a lifetime registration on the state sex offender registry. Those are the only two reasons. So even after a conditional offer, a housing provider may not consider arrests or charges that did not result in criminal conviction. They're expunged records or what have you. They're nullified, or they're juveniles. Yeah, that's a given. If somebody's not, you're innocent until proven guilty. So if you weren't proven guilty on something, they can't use that record against you. If you were a juvenile or your record was expunged, of course, you can't use those records against somebody either. That's a given. But look at the only two times where you could deny somebody renting your apartment in your house. If they were convicted of for a drug offense of manufacturing methamphetamine in a federally assisted housing complex. But if it was in some individual's house that they had a meth lab in that they were convicted for, so you can't deny them rental. You think that they may have a meth lab in your house, possibly, maybe? They've done it before. Well, don't matter. You can't deny it. Only if they're arrested for that in a federal housing, a federally assisted housing complex. Is that weird to you? Does that sound weird to you? It's like the government's carving out exceptions for themselves so that they don't have to deal with these people, but you do. So if the housing provider chooses to consider an applicant's criminal history after they make that conditional offer to rent to them, they can only consider these instances in not renting to them. Convictions for murder, aggravated sexual assault, kidnapping, arson, or human trafficking, sexual assault, or endangering the welfare of a child in violation of this particular law, convictions for any crime that requires lifetime on a sex offender registration, and now, so everything that I just read right now is only if it's a first-degree indictable offense where that person was released from prison for that offense within the past 6 years. If it was a second or third degree offense, indictable offense, that they were in prison for any of these reasons. If there was an indictable offense that they were released from prison within the past 4 years, or if it's a fourth degree indictable offense for any of these offenses, and they were released from prison within the last 1 year. You practically need a law degree then to figure that out. Does anybody here know the difference between first, second, third, and fourth degree? Do you tell me what constitutes a first, second, third, or fourth degree crime under these? Short of having a law degree, that's like crazy. So for a conviction that can be considered, a housing provider has to conduct an individualized analysis. They have to consider the nature and severity of the offense, the applicant's age and time that the offense occurred, how recently the offense occurred. Well, if they were in prison for years and years and years, why should that even matter? Any information that the applicant provided in their favor since the offense, if the offense happened again in the future, would that impact the safety of other tenants on the property? And how would you say that that would occur? And whether the offense happened on or was connected to the property the applicant had rented or leased maybe in the past. So basically, any of these offenses, did they actually occur in your property in the past? Is that where the offense actually took place? Or was it on someone else's property? So if the housing provider intends to consider your criminal history as provided under the FCHA after a conditional offer, they cannot accept an application fee before disclosing that fact to the applicant and offering the applicant an opportunity to provide evidence of any inaccuracies in their criminal record. I ain't do it. Other evidence of rehabilitation or mitigating factors. Yeah, I served my time. And this requirement can be fulfilled using the model disclosure statement. Oh, so look at this. They gave you a model to be able to figure this out. Now, I went to this link, and you know what this link is? It's a PDF document that shows this, what we just went over. It's not like a step-by-step, easy to understand guide to navigate through. If the housing provider withdraws your conditional offer to rent to you based on your criminal record, they have to explain in writing their justification in doing so. They have to justify their actions of not renting to you, which can be fulfilled using that model notice. This. An applicant can then request the information the housing provider relied on. They could submit mitigating information or inaccuracies related to aspects of the criminal record, which may be considered under the FCHA, which the housing provider must then consider. So they make it next to practically impossible without a law degree or having an attorney hired to be able to deny somebody rental based on their criminal history. If the housing provider utilizes any vendor, maybe you're going to hire someone else to do the background checks on people and decide whether they meet those criteria. Oh yeah, great idea, right? How about we hire an expert in this that can evaluate it and then determine if you have any leg to stand on not to rent to somebody? Does that sound like a good idea? To relieve you of that burden? Check this out. If the housing providers are prohibited from discriminating against those criminal records, oh wait, let me see. Okay, if the criminal history inquiry is conducted by a vendor outside person or entity that is conducted in violation of the FCHA if it failed to take reasonable steps to ensure compliance. So basically, if you hire somebody to do those background checks for you and determine who to rent to or not for you because you don't have a law degree and don't want to navigate this stuff, well, you could still be held liable because you're the housing provider. it makes you scared of saying no to renting to anybody. Because you could be accused of discrimination. But check this out. If you say, who cares? You know what? The penalty is up to $1,000 for a first violation, up to $5,000 for a second, and up to $10,000 for 2 or more violations. Anyway, that's the rule now. That's the law now. So if anybody here wants to be a residential landlord, take this into consideration. All right. Any questions on any of that stuff that we just went over? And then both parties have to well, then you got to get the property owner to print their name and sign.
Again. Can you
If
go to
they-
the other slide, please?
If they do any of that, can you like sue for like if they like grow or anything like that in your house, or not in your house, but like, you know, the apartment, whatever you're renting to them?
Oh, do you have actions as a landlord now if a tenant's starting to violate the law that you were kind of forced to rent to them anyway? Is that what you're saying?
I mean, you could kind of put it in that way, but like if they do it, like say like, all right, I'm renting to someone, I can't do a check, so I don't know what they're doing. But then you find out, couldn't you sue them for that? Or can you?
All you could do is file for eviction.
Wow. What happened if it doesn't get approved?
Then you got to deal with it.
But isn't that illegal? Like, what if call the cops on him with and they find out?
I didn't make these wacky laws. I told you they're wacky, right? I told
Yeah.
you these
I'm good.
laws are wacky, right? Now, I can't explain it. Who the hell are we having making these laws now and passing these laws, and for what reason? I mean, they're trying to justify it by saying it has to deal with racial equity and all that, but you know that's nonsense. You know, I get tons of people from all kinds of racial backgrounds in this class, and they're like befuddled by this. They're like, "What the? That's ridiculous." Well, yeah. Well, if you want to be a landlord, this is the crap you got to deal with now. Because somebody made up a reason that it's discriminatory somehow by making these major leaps. And this is all stemming from some report that one guy made up by looking at the number of people in prison based on their racial composition, and then making the leap that, well, the whole entire system must be racist because you don't have an equal number of people in prison based on this and that. And now if you do criminal background checks, then that's a racist thing to do because the justice system is racist. And therefore, you know, it's like linking one bad decision to another bad decision to another bad decision. And this is what we end up with.
Do you have licenses in other states? Is it like in other states, is it the same thing? Like, can you look at people's background in other states?
This is New Jersey, what's it, Michigan and Illinois right now have this, but the federal government also made something similar to this right now as well, which then that would be in all states. But this Fair Chance in Housing Act, this is something for New Jersey. Yeah, it's crazy. It's just craziness, but this is the way that it is. So I'm here just to teach you on this. You know, who can you not rent to? Hire a lawyer and ask them. Because look, even when they spell it out here, I don't know what's considered a first, second, third, or fourth degree crime. And then if they did these specific crimes with a first, second, or third, or fourth degree within a certain time frame is the only time you could consider it. And then you have to give them copies of that background check, give them an opportunity to explain to you why it's inaccurate, and then consider those inaccuracies. Because so now all of a sudden you need to be the investigator to consider the inaccuracies that maybe the police and a judge and a jury didn't.
Is there any workaround? Like, say if you did a background search, right? Then you didn't give them the house and you try to do like another reason or like a workaround around that?
The only reason why you could turn somebody down is if they don't qualify financially to pay for the rent. But if they're getting a subsidy, remember, you can only count the money that the tenant, that's coming out of the tenant's pocket, what their obligation is to pay, not the subsidized amount, not the full rental amount, just the subsidized amount of the rent that has to come out of their pocket. You got to make sure that they can afford to pay it. You could also look at their credit report and see if they have a history of paying on time or not. But now, if you're going to turn somebody down because of their credit, now you got to send them an explanation why they're being turned down specifically, and give them a free copy of their credit report from the 3 credit reporting agencies.
Gotcha.
Yeah, they're really making it tough on landlords to rent, for residential anyway. So I'm showing you these are the actual forms and the actual explanations on those forms. I told you, don't trust my word for it. Look and see. Am I missing something here? You know, you guys seeing something I'm not? This is confusing as hell, right?
Yeah, it's
They're
very
making it
contradicting.
Yeah. Yeah.
I'm just wondering how like you would deal with this, because you already been in the industry and stuff like that. So like, how would you go?
Well, this law recently changed. I haven't done with any deal. I haven't had to deal with any rentals like that since, but I basically don't do background checks on anybody.
But then can't you get in trouble if other tenants are in danger?
Yeah.
So like it's crazy.
You said it. It is. It is. But it is what it is. I hate that saying, but it is what it is. I know. You're just sitting there shaking your head, right? All right. Let's move on from this nonsense. Unfortunately, this kind of stuff is becoming a law all across our country because politics, basically. And politics that's pandering. And people are pandering, thinking they're pandering to a race of people, thinking that these are protections for you. But listen, people that are minorities look at this and they're shaking their heads too. They're like, this is stupid. This is ridiculous. You know, how is this protecting me or my family? You know, I don't condone criminal behavior either, and I don't want that around me or my family. You know, so it's ridiculous. But that's the excuse that they use as the nonsense to predicate this kind of decision making and law making. At lunch hour, let's see, a couple things happened during the news. I seen that, the first woman Supreme Court justice ever just died, Sandra Day O'Connor. She died at 90 years old. She's retired from being a Supreme Court justice, but she just died today. And then what happened? That guy Santos, from the senator from Long Island, he was for the 3rd time they tried expelling him from Congress, and they successfully did so this during lunch, during the lunch hour here. Do you guys know why he was expelled from Congress? These are like people weaponizing the justice system, the rules, to go after political foes and stuff. Now, this guy, he's probably a piece of garbage, but nonetheless, he was voted in by the people, his constituents, and they should have the right to determine who they want to have representing them or not, or vote them out next time. Congress should not be voting on behavior like this. The claim is that he used some of his campaign money that was donated to him to get some Botox procedures done. Really? You're going to expel somebody from Congress because they misappropriated some funds for getting a Botox procedure? But yet you're going to let a guy go who pulls a fire alarm and interrupts a congressional vote by giving him $1,000 fine and not giving any charges against him? Our world is upside down right now, guys. Okay, let's see. Other provisions. The following miscellaneous provisions governing rentals in New Jersey. A landlord cannot refuse to rent a one-bed. Okay, well, we already went over this stuff. Who you can turn down rentals to, who you can't. But a landlord cannot refuse to rent a one-bedroom apartment to two members of the same sex. Yeah, because that's sexual discrimination. What if they're gay or lesbian or whatever, you know? This would be available to members of the opposite sex who are equally qualified. It's also illegal to subject a tenant to sexual harassment. Leases may not provide that a rent will be a lease may not provide that it will become null and void on the birth of a child. A facility that does not admit pets must permit a guide or service animal. A person with AIDS is considered a person with disability, and under New Jersey law, they're protected against discrimination, just like COVID-19 or any of those other things. And then they end up giving that, likewise, a landlord cannot refuse to rent to someone who's Asian because they believe Asian people are responsible for spreading COVID-19. That's nonsense. Even though we know COVID-19 came from China, I'm not going to come to the assumption that all Chinese people spread COVID-19. That's idiotic. Yeah, how big of a moron you got to be? Who are they pandering and writing these things for? Landlords are allowed to enforce health regulations, limiting the number of persons allowed for the size of any given apartment. And it is, of course, always proper to accept or reject prospective tenants on the basis of their ability to pay their rent, their income, and their likelihood in doing so, their credit rating. So there you go. There's that alternative that you're talking about. Can they pay the rent, and are they likely to do so? So you can put in place a minimum credit score requirement and a debt to income ratio. So not just based on how much money they make, but what their debt to income ratio is. What percentage of their income are they spending in regard to the money they're making? So that debt to income ratio, you can use that as a factor to determine if you're going to rent to them as well. But you could only use that to judge the amount or of the portion of the rent that has to be paid by the tenant if they're being subsidized in any way as well. Okay. And apartment buildings with 25 units or more, the apartment complex management is required to make annual inquiries as far as the racial composition of the tenants that live there. And they have to report that to the state. Why? Well, they want to be able, the state wants to be able to monitor to make sure that if no minorities are living there, they could look into it to make sure that there's no discriminatory practices that are going on. Love letters. Sounds so sweet. I actually hate these things. I think they're very manipulative. I don't like manipulative people. Look, I've had offers before that my offer was a better offer and it was rejected in favor of someone else's who accompanied that offer by a letter trying to pull on the heartstrings of the owner. And that was even in the case of one of my own listings one time. I found the buyer for one of my listings. So I could have gotten both ends of the deal there. And my offer was better than all the others. But this other agent, she sat her client down and they wrote a letter trying to pull on the heartstrings. Oh, we'll raise our family here and we won't change a thing in the house. And it was all kinds of nonsense like that. We love the way that you have it and we want to raise our family just like you raised yours and da, 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 da. And then my clients actually fell for it and they took their lower offer because they accompanied it by such a letter talking about family and raising and they're like, oh, that's, so sweet. but that has nothing to do with the business. And listen, you're a property owner. You hired me to try to get you the most money you can for your house, and now you're making a decision for a lower amount because somebody wrote you a letter and they're basically screwing with you. They're playing mind games. But now I'm finally vindicated because a lot of those letters can be construed as discriminatory, and here's why.
Hi, I'm Charlie Lee, Senior Counsel and Director of Legal Affairs at NAR. As buyers compete in a hot real estate market, they are searching for ways to stand out from the crowd. One method being used is to send a love letter to entice the seller into choosing their offer. While a love letter may seem innocent, they can raise fair housing concerns and risk exposing both the real estate broker and their clients to legal risks. The Fair Housing Act makes discrimination illegal in the sale or rental of housing and prohibits making housing otherwise unavailable because of race, color, national origin, religion, sex, disability, or familial status. Many states and local governments have their own fair housing laws, which can include additional protected categories. The use of a love letter often presents fair housing issues because they often contain personal information about the buyer, such as their race and culture or traditions, as a way of appealing to the seller's emotions. Some buyers even go as far as sending sophisticated packages that include photographs and videos. For example, a buyer might send a letter with a photo of their family around a Christmas tree. As a result, the buyer has revealed their religion, which is a prohibited basis for a seller to base their decision to reject an offer. While it may not be the buyer's intent for the seller to use this information to discriminate, that is essentially the position that a love letter can place the seller. When considering that the information cannot be easily forgotten or unseen, a love letter may ironically cause the seller to be fearful of selecting the buyer's offer because of potential discrimination issues. Therefore, real estate professionals should advise their clients about the risk of love letters and, at a minimum, stress the importance of avoiding including any information in the letter that could be used to illegally discriminate. But of course, even a photograph of the buyers could lead a seller to give preference to a buyer or reject them based on race or other background. Fair housing is a high priority throughout the country, and states are closely monitoring the practice of love letters. In fact, just recently, Oregon enacted a law to take effect on January 1, 2022 that bans the use of buyer love letters. Here are some best practices to consider when it comes to love letters. At the outset of a relationship, speak to your client about the risks of buyer love letters and the potential fair housing issues they raise. Remind your seller client that an offer should be assessed based only on objective criteria, such as price and timing. If your seller client insists they want to receive buyer love letters, advise them to consult legal counsel and to document their decision-making process in selecting an offer. Avoid helping buyer clients to draft or deliver love letters. Be sure to warn them against revealing any personal information that could raise fair housing issues. Counsel them to focus on the characteristics of the home or other objective information. Lastly, help your buyer clients find other ways to differentiate themselves to win the property. Beyond offering more money, the buyer may consider offering more flexibility with the closing date, additional earnest money, or waiving other contingencies that may appeal to the seller. Thank you for watching this episode of Window to the Law.
Another video that wouldn't be bad to include in a buyer or seller's listing presentation for things for them to consider. Do they want to hear about buyers' love letters or not, and explaining to them what that is. All right, let's talk about Mount Laurel. Mount Laurel court decisions. Everybody familiar with Mount Laurel? That's a town in New Jersey. Well, in
some discrimination stuff going on or something like that.
Yeah, well, there's some lawsuits that were based on Mount Laurel. They started from Mount Laurel. Now, New Jersey has a rich history. We have a big history where we were the third state admitted to the United States when our country was being created. So we have a lot of history here. Part of the history is you guys remember being in school, elementary school, and them teaching you about something called the Underground Railroad. It had to deal with slavery and slavery. We were having slavery was legal in the South, but not in the North. So we had the Underground Railroad to smuggle slaves from the South to the North where they could be free. And well, New Jersey was one of the endpoints of the Underground Railroad, where people would end up, and then some people settled here, and then some people moved to other places throughout the country afterwards. But Mount Laurel, New Jersey was one of those points where the Underground Railroad ended. And so you have a lot of history where you have a lot of those descendants and family members of those slaves, that former slaves, that ended up building homes and then passing them on after generation to generation to generation, having these houses built, you know. Now, back then in those days, there was no such thing as zoning laws or whatever. If you had a property, you built a house on it. So you had people that were building houses. There was no regulations on the size of the houses or how close you could build them to each other and all that stuff. So you had a lot of small houses that were built real close to each other, practically on top of each other. And the problem is now we come to modern ages and modern times, and you have your cities and towns. They want to improve their city's infrastructure, right? They want to have better schools, policing, fire services, build better roads, and all that stuff. Where does your town get the money to do that?
It's supposed to be from taxes, no?
Taxes. You hit the nail on the head. It comes from taxes. What are taxes based on? How much the city charges you in property taxes? What is that based on?
A percentage of how much you make?
Not your income. It's based on the property's value.
Wait, okay.
We're not talking about income
Your
tax.
property,
We're talking about
you're talking about property taxes.
property taxes.
It's what they zone
Yeah, so this comes from the property taxes.
the area. It's how
So-
they zone the property.
Well, what happened here in Mount Laurel is you had a lot of houses that were built practically on top of each other, very small lots, homes built. So there were small homes built close together. So the towns, the cities, they don't have control over how much a house is worth, but they can try to increase the values in other ways by requiring you having a larger lot size. Now, they can't do anything to people who already live there and people who already own homes. Any new rules that they create pertaining to zoning that could, for instance, dictate what the minimum or maximum lot size that is required in order to build a house on it, we call those zoning regulations. And so the city of Mount Laurel came up with a bright idea, and it wasn't a bad idea, of requiring a larger lot size to build a house on. And then if you have a larger lot size, some people will build larger houses on them too, and thus increase in value. And thus they could charge more taxes and earn more money, and then use that to improve the city's infrastructure, right? Now, it doesn't affect the current residents that are already living there. It just affects any new ones that want to build there. Now, so the town of Mount Laurel, New Jersey, they came up with that great idea that this is what they were going to do. They were going to require any new construction require a larger lot size. Sounds like a good idea to me. The only problem is they implemented it. They went about the wrong way to implement it. Now, I don't know for sure. I didn't do that much research into it to find out what the lot size requirement was that they made, but it was an abnormally large lot size. So they went a little bit extreme with that regard. So let's just make up a number here for our argument's sake that the town of Mount Laurel, New Jersey required you to have 1 acre of land in order to build a house on it. That's a pretty big lot size. And now when you have 1 acre of land to build a lot on it, you had people building larger houses. You had people building these like luxury like mansions over there now. And what does that do to a neighborhood's value just for the raw land? The price of the land goes up as well. Now that's all good for the town, it's working. But now you have a little bit of a problem. You created an unintended consequence here. Because you have a larger lot size requirement that's ridiculously large, and now you got all these expensive homes being built there, which increases even the size of the price of vacant lots. You are now effectively pricing poor people out of the town who can't afford to buy the land, let alone to build in that town. And so came the first lawsuit from the NAACP against the town of Mount Laurel, New Jersey in 1971. So this lawsuit came to be known as the Mount Laurel 1 court decision. It was filed by the NAACP against the town of Mount Laurel, New Jersey, for illegal discrimination against low-income and moderate-income persons. Now, the town of Mount Laurel wasn't out to get low-income and moderate-income people. I just explained to you what they were trying to do. I did research on that, and that's what their intent was, and that's what they were trying to do. But effectively, what ended up happening is they were pricing low-income people out of the neighborhoods who couldn't afford to buy those larger lots to build on. So they're effectively pricing them out of town. So the ending consequence is they were discriminating against low-income persons. So they called this practice exclusionary zoning because poor people were now excluded from these areas because they couldn't afford the land. So the court stated that all developing communities had to zone for their fair share of the region's need for low-income and moderate-income families. Now, in 1975, the court ended up ruling that the poor may not be excluded from residential areas. Because let's just say that they said, okay, well, we'll allow smaller lot sizes, but they need to be over here by the commercial districts, okay? In 1975, the court added, well, you can't do that either. You have to provide a range of housing for lot sizes all over town. Okay, so 1971, this Mount Laurel 1 court decision, a good decision, right? You can't price poor people out of the town by effectively requiring some kind of ridiculously large lot size. You had a good idea, but you poorly implemented it. If you went with like 50 by 100 minimum lot sizes, that would have been more realistic. Okay, so now the town of Mount Laurel, New Jersey started getting all these effectively pricing poor people out of town. So Mount Laurel 1 court decision, we could agree on, that was a good court decision, right? That said that the town had to provide a range of lot sizes and housing so people, even poor people, can afford to buy in the town. Good court decision. Now, in 1983, a second lawsuit came about called Mount Laurel 2. The second lawsuit filed by the NAACP against Mount Laurel resulted in the courts providing specific guidelines for all developing communities. They said that all municipalities have an obligation to provide a range of housing. This was accomplished by allowing for higher density developments, meaning that you could build homes closer together than would normally be allowed by the zoning laws. A 20% set aside. What does that mean? You know, the legal speak that they use, the language they use sometimes can be kind of complicated. A 20% set aside would mean that you're allowed to, for every 100 homes that are built, 20 of them need to be for low income or low or moderate income housing. Why don't they just say that?
Well, why don't they say that then? Like,
I know. Well, they use all the legalese speak, the legalese talk. They call them set asides.
Yeah, but it's so vague that it leaves it open for translation of what you want it to be if you don't say what it actually is.
It does, but it's generally accepted that that's what set aside calls for. But anyway, let's just move on and just assume that that's what it means, and let's go on with this. So zoning for mobile homes. And the communities also need to require that communities must cooperate with efforts to obtain subsidies from both the state and federal government. What are subsidies? Ooh, that's a dirty word for money. They need to try to get money from the state and federal government to accomplish these goals. Is the state in the business of being a landlord? Are municipalities in the business of being landlords? So what are they going to do with all that money? Well, they could try to incentivize investors who are builders and landlords to build housing, rental housing in their community, houses for sale and houses for rent in their communities, and give them tax breaks. And the municipality makes up for the money that they lose in the tax breaks by the subsidies that they get. So a panel of 3 judges that was appointed by the Chief Justice of the New Jersey Superior Court was set up to handle listening to cases of hardships of people who have experienced hardships because of what? Let's go back, let's dial it back to the beginning of this paragraph again. In 1983, the Mount Laurel II court decision was filed by the NAACP against the town of Mount Laurel, New Jersey, that resulted in courts providing specific guidelines for all developing communities. No, they did not. They did not. They never created specific guidelines. You know what the courts did? They required that the local communities create their own specific guidelines on how they were going to accomplish these goals that they set in place. Now, let me ask you a question, guys. Let's pretend that you are running a town. All right? You're in charge. And a court tells you you need to come up with a bunch of laws, of rules, and that will restrict you. And if you violate any of those rules, you're going to be severely punished. Would you create a bunch of them?
No.
Common sense, no. And therefore, more than half the towns in New Jersey never did. Even though the court said, well, you have to provide specific guidelines. But they never put penalties in place for if you didn't. Kind of, sort of, they never did. There's no written penalty on this. They just set up a panel of 3 judges to listen to hardships, and then they could do something about it. And what could they do? Well, here, let me explain. Say I'm a builder, and I want to build a project in this town. I just bought up a block of properties. I want to tear them all down, and I want to put storefronts in with luxury housing above it. All right. Now, none of that's going to be cheap or affordable housing. And the town says, you can't build that there. And I say, why not? And they say, well, it's all zoned for single family homes. And I say, so what? I want to build it. They say, no, you can't. You're denied because that's all zoned for 1-family homes. If I'm a smart builder, what I could do is I could do my research and try to find out if that town put in place those specific guidelines that the court required them to do under the Mount Laurel II court decisions. And if they never put these rules together, if they never created these rules, I can go to this 3-panel of judges and file a lawsuit against the town. That lawsuit is called Builder's Remedy. You see, I wrote it here on the side. You don't need to know that for exams, but it's useful to know in real life. Builder's Remedy is a lawsuit where I could sue a town who denied me the right to be able to build whatever I wanted because the area was not zoned for that use. But if the town did not create these specific guidelines to meet the Mount Laurel court decision's goals for building a low-income and affordable housing, under Builder's Remedy, I could say, well, they're denying me being able to build homes closer together than normally allowed, and they never put together rules on how they were going to do it under the Mount Laurel court decisions. The judges will examine it. They'll say, is that true? It's true, that happened. Well, guess what? You could ignore that town's zoning laws and build whatever the hell you want. that is the decision and that is the remedy, the consequence of not putting in specific guidelines for those towns. But it's only by people who know the rule and will challenge it and take your town to court and sue them under builder's remedy that'll get granted the permission to ignore the zoning law and build whatever the hell they want. And now I could build my storefronts with my expensive luxury housing, none of it which is going to be affordable or low income or even moderate income housing. I'm basically using it as a loophole to build whatever I want and ignore the zoning laws. This is what we have right now in New Jersey. Now, if you guys remember a couple of years back, Governor Christie, when he was still governor in his last term, he tried running for president. You guys remember that? When he tried running for president, for about a week or two, you heard nonstop in the news, in the national media, because he's a Republican, New Jersey's big Democrat state. But all you heard in the New Jersey and national news even was this argument, because this is what Governor Christie did. Governor Christie went to all the politicians in New Jersey, because if you guys realize, the governor does not make laws. We have legislature, the politicians make the laws. They go through their lawmaking procedures. Once all the lawmakers agree on it, then it goes final to the governor's desk for signature for him to sign off on it and sign it into law. So the governor doesn't implement the laws. He's like the last step that signs them into law for state laws. So he went to all the politicians in New Jersey from both sides of the aisle, and he said, listen, these Mount Laurel court decisions, they're broken. They're not doing what they were meant to accomplish. We're not getting all this low and affordable income housing built that we are supposed to get built. You got towns that are keeping track of 20% set-asides that they need to build, but it doesn't say when they need to build it or where they need to build it, so they're not getting built. They're just keeping track of it, of how many need to be, but they're not getting built. So these laws are failing on their face. They're not doing what they were meant to. We should just do away with these laws because they're full of loopholes and just sit down and write a new law from scratch, agree on it, put it across my desk, and I'll sign it. Now, that makes sense, especially since we just explained this and we understand what's going on with these Mount Laurel court decisions, right? But the average person in the general public doesn't know anything about that. So all you heard about for like 2 weeks in the news, in New Jersey and in the national media, was Governor Christie, Republican Governor Christie proposed some racist legislation to do away with longstanding protections for poor people and minorities, which was the Mount Laurel court decisions. I guess that's one way you could word it, because technically these were protections for low income and moderate income persons, right? Affordable housing. But that's a bit of a stretch from what he was actually trying to do, right? He actually said it's full of loopholes. It's not doing what it's meant to do. Do away with the damn law and write a new one from scratch if you can't fix it. And they ended up twisting those words, making them very political and turning it into a political argument. And this is why we can't get anything done. And this is why we can't improve our society, because everything has to be an argument to one extreme or the other. And they twist these words that people say and what their intentions are to turn it into a big political lie so that we could have a political argument so one party can get more power than the other. This is such nonsense. But nonetheless, he ended up saying, mercy, mercy, mercy. I see I'm not going to win on this. Forget I ever brought it up. And so nothing ever happened. It faded from the news, and we still have this in place. Now, why did politicians attack him on this? Well, they could, because it was a political argument and they were using it for political reasons. But I'm sure they're also making a lot of money on it too. I'm sure a lot of people, a lot of these politicians have friends and family, or maybe even them themselves are involved in real estate and construction projects where they're using this loophole for their advantage. Okay, so now that you guys know about it, as real estate professionals, if you ever have clients, or maybe you yourself want to get involved in a real estate project, you want to build something and your town denies you because they say it's not, the property that you own is not zoned to build that, so you can't build it. Can you still build it? Whatever it is you want to build. Yeah. How do you go about doing that? You got to find out if that town who implemented their specific guidelines that the Mount Laurel court decisions required of them to do. Now, I'm not sure about how to go about that process, but you get to hire a lawyer to find out for you. And then you could sue the city under builder's remedy to get the permission to do it anyway. Anybody here familiar with Cranford?
My backyard.
Yeah.
Okay. You know, across the street from the Cranford train station, you got all those storefronts with the luxury housing above it. None of that stuff is cheap, by the way. That all used to be one-family houses. It was all zoned for one family. That developer bought up a couple blocks over there, tore it all down. That basic scenario that I just spelled out for you, I'm using Cranford as the example. That's exactly what happened there. Don't believe me. Like I tell you throughout this course, don't believe a word I say. Trust but verify. Go search it yourself. Do a Google search. Go to Google and put in there in the Google search, do a search for New Jersey builders remedy lawsuits and see how many come up. Tons of them. Tons of them. You'll probably see Cranford and Summit and all kinds of other towns will come up in there throughout the state. Okay. Don't trust my word. Research, be critical thinkers, do things on your own. Okay. Now, what do we need to know for exams? Because that's the important question here. This is what you need to know for exams. By the way, everybody get, well, to highlight here, I would just write builder's remedy, highlight the title and this term exclusionary zoning. But it doesn't give you a really good, clear definition here that there's not like one sentence that you could highlight to know what to study here. So instead, I created this slide. This first bullet point is what you should study. Maybe write this in the book over here somewhere. If there's room in the book, where is that? 83. I don't know if there's room for it, but this first bullet point, if you were to write this maybe there at the bottom of the page or the top or on the side, you could squeeze it in there. Exclusionary zoning is a discriminatory zoning practice outlawed by the Mount Laurel court decisions, which discriminated against low-income persons, the poor. The low-income individuals may not be excluded from residential areas, and municipalities have an obligation to provide a range of housing. And then here I give you the explanation about builder's remedy. Or it may not be a bad idea just to snap a picture of this slide, because the book doesn't have a good, clear, single sentence definition you could study. But this is definitely, absolutely going to be a question on exams about exclusionary zoning. Okay. How about this? Mount Laurel made this discriminatory practice against the poor illegal. What's it called? Exclusionary zoning.
Exclusionary zoning.
Or exclusionary zoning is a discriminatory zoning practice outlawed by the Mount Laurel court decisions. You see different ways that they may ask it. So you need to understand what this exclusionary zoning is, and that the Mount Laurel court decisions are what made it discriminatory. And who did it discriminate against?
Low-income persons.
Low income, the poor, and often they may refer to them as moderate income too. They always try to throw in the middle class and include the middle class. You know why? Because it's the largest segment of people, and they like to, when they tick people off, they like to piss off the biggest population possible. So that would be the middle class, which right now they're eroding anyway. But exclusionary zone, there you go. It discriminated against poor people and moderate income persons. And the law that outlawed it made it illegal, the Mount Laurel court decisions. Okay. Now, is it okay for me to change the slide? Does everybody snap a picture or do whatever they need to do here? Okay,
1 second.
sure.
All right, I'm done.
Blue beans. All right, code for equal opportunity. We have standard of conduct that realtors need to follow. All realtors take an affirmative pledge to offer equal services to all persons. And HUD and NAR often partner with each other to offer classes in fair housing and different ownership initiatives, having classes, teaching communities about how to get into housing, and maybe also even have community improvement projects for like revitalizing a park or something like that, you know. Anyway, that's their fair housing partnership stuff. Nothing there for exams, really. All right, turn to page 84. You know, HUD, we have to display the posters, both the HUD Equal Housing Opportunity poster as well as New Jersey's Equal Housing Opportunity posters. We have to prominently display a sign stating that discrimination is against public policy as well as state and federal laws. That's what these posters do. And we have to make proper responses when clients express discriminatory desires in their searches for homes for us. So if you got a buyer, they're looking to buy a house and they tell you, oh, well, I don't want to live by these people, or I don't want to live by those people, you know, oh, where exactly is that? You tell me where it is you want to live. I can't search for homes based on the criteria of where these people or those people live. I could search for a home based on your price range, the architectural style, how many bedrooms, how many baths, and the location of where it's at. You tell me where it's at and I'll look for it there. But I cannot engage even in that conversation, that kind of banter about these people or those people, okay? We live in New Jersey. It's a melting pot. We're the most densely populated state in the nation. That's a factoid, by the way. We're the most densely populated state in the nation. We have a mishmash of people from all backgrounds here. So we have to make those proper responses to people if they express any kind of discriminatory sounding desires in their searches. And reverse discrimination is a thing too, believe it or not. Even though I'm seeing this an awful lot on social media lately, actually in the last couple of years, not just lately, we're actually seeing these arguments that it's impossible. You cannot discriminate against a white person. That's what reverse discrimination is. You got these people that are arguing and saying you can't discriminate against white people. You could discriminate against any people. The argument that you're white so you can't be discriminated against is nonsense, and it's proven time and time again with lawsuits. You're getting people for maybe public jobs. Well, here's a recent one. There was a lawsuit somewhere around here locally where I think there was like 5 firemen who sued because they have a civil service job and they have to take tests and they have to rank in a certain thing. And preferences were given for, they were already in positions working for the fire department, but they were turned down for job placement advances because those jobs were instead given to people who were minorities, people of a certain race or gender got the advancement first. See, I'm a person that believes that your qualifications for a job should get you an advancement, not any kind of outside influence of who you know or identity politics or anything like that. I think all that is nonsense. It's a recipe for disaster. But reverse discrimination is a thing too. It even has the word discrimination in it, you know. And then advertising should not contain any preference or limitation based on a protected class. We're going to go over the advertising ones and the reverse discrimination in a moment. Let's first highlight this. This is on page 84 under implications for brokers and salespeople. This is in the first paragraph there underneath that heading. The complainant does not have to prove guilty knowledge or specific intent, only the fact that discrimination occurred. So in order to be found guilty of discrimination, nobody needs to prove it was your intent to discriminate. All they have to prove is that a discriminatory act had occurred. I brought this screenshot up from earlier in this chapter. Well, here we are finally visiting it again. Highlight it now if you did not earlier. So people don't need to prove it was your intent to discriminate. They only need to prove that a discriminatory act had occurred, and boom, you're guilty of discrimination.
Can you fight against it?
Can you? All right. Anytime throughout this course, if you ask me, can you or could you, the answer is going to be yes. Can you kill your neighbor? Sure you can, but there's always consequences. You could go to jail. Can you fight something in court? Sure you can. Doesn't mean you're going to win, you know.
But what I mean by that is like, is it worth it? Like, I don't know. I think so.
I guess that
I
would
think it's worth it to kill your name if that's not what you wanted. Like,
yeah,
right?
It would really depend on the outcome of the case, right? If suing somebody would be worth it. All right,
I
now
think only you can determine that, right? Like, only you can determine if it's worth it to you.
As far as what? Hold on a second.
Fighting it. Like, if he asked if you could fight it, and like it's only worth it to you. Only you know. I mean, you know what your intentions were. If you didn't mean to be discriminatory or anything like that.
Yeah, but the law is clear on it. If somebody can prove that you discriminated in some way, shape, or form, even if that was the furthest thing from your mind, it was not your intention to at all.
Innocent misrepresentation.
You're not a discriminatory person at all, right? It doesn't matter. Your intent is irrelevant according to the law.
And that's
The only
crazy.
thing the person has to prove is that discriminatory act occurred. It does not matter whether you intended to discriminate or not. I know it sounds kind of messed up, right? But that's the law. You know, so the complainant does not have to prove guilty knowledge or specific intent. That's like, remember at the beginning where I told you about that exclusive buyer agency agreement where you're searching for homes and maybe filtering them out based on the amount of commission that's being offered? And you had that conversation with your client so that you can then write it that they told you not to show you homes that are not offering a minimum commission because they don't want to take it out of their pocket, and put that in writing on an exclusive buyer agency agreement. Because if you don't, whether you had the conversation or not with them, if you didn't get it in writing, and now later on they see, oh, you were not showing them homes from a certain area, even though those are the specific homes that were not offering that minimum commission that you spoke about. If you didn't put it in writing where they told you not to show them to you, they can show a pattern where you were steering them away from that area. And we learned that steering is an illegal practice under the Federal Fair Housing Act. So boom, you're guilty of discrimination. But no, that wasn't my intent. It was about the money and the commission. Doesn't matter. It's irrelevant. Your intent is irrelevant. Doesn't matter. Steering's a discriminatory act. If you did it, boom, you're guilty. Unless they put in writing for you specifically not to show them those homes, boom, you're guilty. That's it. You could argue till you're blue in your face. Doesn't matter. And listen, your race doesn't matter either. You could be a black person and be accused by another black person of discrimination, and you could still be found guilty of discrimination. Your race or color is irrelevant as well, or other protected class. You know, race, color, religion, yada yada yada. You know, you could be the same as the other person or the opposite, and still be accused of discrimination. So be careful. Don't assume that you got any armor on you because you're the same as the other person who's accusing you of something either, you know. Let's go down a couple paragraphs here and let's highlight this. If a prospect expresses locational preference for housing based on race, the association's guidelines suggest the following response. I cannot give you that kind of advice. I will show you several homes that meet your specifications. You will have to decide which one you want. Now that's kind of a dry answer. It sounds kind of robotic to me. You guys need to find a way to be comfortable and talking to people about certain sensitive topics. Talking about race and religion and a lot of these hot button topics these days, I feel comfortable talking about them because I'm not discriminating against anybody in any way, shape, or form. So I usually don't have a problem, even though it is a sensitive area. I feel comfortable talking to people about these things. And you should find a way to be comfortable about it too. Because talking like a robot, where somebody tells you, well, I'm looking for a home based on some sort of a racial preference. You can't be like, I cannot give you that kind of advice. I will show you homes that meet your specifications. You will have to decide which one you want. That's robotic. Instead you got to say, wait a minute, I can search for homes for you, Mr. and Mrs. Buyer. I could search for homes based on your criteria, your price range, the architectural style, the features you're looking for in a house, or even the features you're looking for in the neighborhood, or like the location is close to the train station or something like that. But I cannot search for homes based on who lives in the area. This could be deemed discriminatory, and licensees are not allowed to enter in that discussion. They can lose their licenses for that, and they could be fined heavily. So I have to avoid any kind of discussion like that whatsoever, okay? So if there's a certain area where it is that you want to live, you tell me what that area is, but I can't search for homes for you based on who lives there, okay? So let's just get that out of the way right now. See, I'm talking to you like a person, like a human being. I'm not talking like a robot. I cannot give you that kind of advice. You got to find a way for it to flow a little bit easier, not be super offended by everything or scared to talk to people. And if people got a chip on their shoulder, well, that's their problem. That's the way I look at it. All right, everybody got these highlights?
Yes.
Excellent.
Yep.
So now reverse discrimination, that's a thing too. If we go to the next page at the top in the second paragraph, let's highlight reverse discrimination regulations are intended to preserve racial balance in given areas. Who cares? It's still discrimination. We just went over and we just highlighted on the previous page, your intent is irrelevant, right? So it's funny that the people that push well-meaning quotas, in recent years, brokers sometimes have been caught in the middle when local governments, mainly politicians, enact well-meaning quotas that give rise to reverse discrimination regulations. Well, your intentions are irrelevant, so it doesn't matter if they were well-meaning. If the end result was it was discriminatory, well, you discriminated. So it doesn't matter if it's intended to preserve racial balance or whatever your intent is. It's discriminatory. You can't do it. So even though these local laws sometimes run counter to federal and state rules, it poses a real problem for the conscientious licensee. It shouldn't. Follow the laws. Federal laws will tell you you cannot discriminate. State laws even tell you you can't discriminate. If you got a local politician that's trying to tell you that you can because they have an intent to try to harmonize people and mix the races a little bit better, well, why are you looking at race? So far, every law that I taught you, every rule that has been fought for in this country has been so that we're blind to this. Treat everybody like a person. Don't look at their race. Don't look at their religion. Treat everybody fairly and equally, right? When you start focusing on those things, that's where the problems occur. I don't like to knock the guy because, he was the first Black president that we had, but President Obama, he did some messed up stuff too. He actually spent millions of taxpayer dollars on a project where he took the census, where he had the Census Bureau take all of their information about, people's demographic data, and he had HUD combine it to make these maps I forget what he actually called the maps, but for lack of a better term, I'm going to call it what it is. They created these race maps because that's basically essentially what it was. Like all the white people on a map were blue, or all the white people were a blue dot on a map. All the Asian people were a red dot on the map. All the black people were another colored dot on the map, and so on and so forth. So he actually had a speech in front of the Black Caucus and the FHA. And he said, this is my dream, this is my plan. We're going to implement rules. We already started putting together this database where you could zoom in on a map. If anybody in the property field is looking to sell real estate or buy real estate or finance it or insure it, and in any way, shape, or form that property is going to be insured, or that money is going to be insured, or coming from the state, federal government, or any program where that money is being held is FDIC insured, FSLIC insured, insured by the FHA or guaranteed by the VA, or in any way related to the federal government, before we're going to allow that funding of that sale to be done, or anybody who's granted a license from the government, like the real estate agents or mortgage agents, to be able to give somebody a loan or sell a house in an area to somebody where there's already an overpopulated representation of that segment of our population. Really weird wording, the way they start talking like that. You're going to have to first take a look at our map. And if you're zoomed in, you could see that these color people will be this dot, those color people will be that color dot on the map. And you're going to have to zoom out on that map to see the whole area. And if it's not a nice neutral purple color, which is a good mix of all the different colors of people, and you see more of a concentration of one color or the other, you're not going to be able to sell a house to somebody who already is that segment in that area. Basically, what he was describing was forced integration. Now, we realize people have a right to live wherever they want. See, we can't tell people where they want to live. That's steering. That's a violation of the federal law. Like everything that he was describing was violations of laws already. Now, I know what his intent was, but if we also look at the laws, they also say your intent is irrelevant. If you do any of these things, it's discriminatory. So he was describing something he wanted us to do, which is in violation of all these laws already. And he spent millions of taxpayer dollars on starting to implement a project like this. I don't know how he could possibly ever get that passed. Somebody would take it all the way to the Supreme Court, and it would always be struck down based on the laws, the long-standing laws that we have in place as protections for people, where you get to choose where it is that you want to live. Nobody can tell you where you can live or can't live because there's too many people of your background there already. You know, that's crazy. Look, I've had situations before where let me give you this one example. I had this one older Hispanic gentleman. He was buying a house, hard worker guy. He had 2 jobs, made a lot of money, made a decent buck. He was a contractor of some sort, and he saved up a lot of money. He saved up 200 grand to buy a house. He wanted to buy a 2-family house down in Port Elizabeth, and it was new construction, and it was kind of expensive at the time for a 2-family house down the port, not the greatest area. It was a $600,000 home, 2-family house, new construction down Elizabeth Port. I could already foresee the future, knowing the real estate business, that house was not going to retain its value. It's going to go down in value over time. I knew it. I could see the writing on the wall already. So we were just in an inflated real estate market. So I told the guy, I was like, you got 200 grand to put down on a house. I was like, you know, I could get you a house in Westfield for that price. And then he started explaining to me, oh, no, my English not too good, my people over here, my church, the food. I was like, stop. You don't need to explain yourself to me. You don't need to explain. I'm just saying, for the money that you got, this is a nice area, but you know what? Forget I mentioned anything, because I don't want to be accused of steering the guy. Because when he started explaining, well, no, my people here, my English not too good. There's people here that speak my language. He feels comfortable around them. They got the storefront, his church, ethnic foods and all that stuff. I was like, stop. You don't need to explain yourself to me, you know? Because, you know, I realized that's steering and I don't want to get involved in steering. Even though my intent, which is irrelevant, was seeing the writing on the wall that he's going to be losing money in the long run in this house. Now, as it turns out, the real estate market did take a dive and the property values did drop. And then he reached out to me after he bought that house and he was like, Victor, I want to sell. And I was like, you just bought not too long ago. And he's like, oh, no, the property value's going down. I'm like, well, it's real estate. You know, real estate markets are cyclical. Property values go up and down. He's like, no, I want to get out. I want to get out. You know, property values are dropping. So I was like, all right, but if you do, you're going to lose money. He's like, yeah, I know. I was like, okay. So I looked up the value on it. He was already going to be losing that 200 grand that he put down. That's how much value the property already lost. And I told him, I said, listen, you're better off. You don't lose any money if you don't sell. Just stay in there and make your payments. Unless you're forced to sell for some reason, don't sell. He's like, no, I got to get out. I want to get out. I was like, all right. So I put it on the market, no showings. We had to keep dropping the property value until we got to half the cost. He bought it for 600,000. So once we got down closer to 300, it was like 320 or 340. That's when we started getting buyers that came in to look at it. But I told you it was in a great area. There's a lot of gang activity down there. And a car was blown up in front of his house with a Molotov cocktail. You know, it's like a bottle filled with gasoline and other stuff. Somebody blew up a car that was in front of his house on the street. And so now we have an appointment to show a house. The car is now cleared away, but all you see, it looks like Iraq. You know, all you see is like a stain on the ground from like a blown up car, the black stains from the fire. And I was just like, oh man, I got there. I was like, oh man, you know, the buyer's seen that. They're like, what happened here? What do I have to tell them?
Yeah.
Yeah, because you knew.
I do, and they asked, I have an obligation to tell them now. So I told them what happened. And they're like, yeah, so this ain't a great area, is it? I was like, it is what it is, you know? And they're like, yeah, no, I don't want to see it. They didn't even go in. So I told the guys, like, listen, if you really don't, I was like, listen, you're getting hit here by the market values dropping. You're going to lose all your money. This happens. It's a sign. Don't sell yet. Just, if you don't have to sell, just stay in the house. So he ended up not selling and staying in that house. I don't know if he's still, I should follow up and see if that guy's still there or not. But this was years ago already. I wonder if he ever did pick up and sell, because the real estate market did rebound. It took years and years and years later. The real estate market did rebound again in recent years, but then we started diving again now with this freaking Biden economy. So I wonder if that guy's still in there or not. But anyway, that was his case. That was his situation. But I could have been accused of steering. That's what the whole story was about. But then once he started explaining, and I was just like, you don't got to explain yourself to me. So people can choose where they want to live. He started explaining to me where he wants to live, and he wanted to live by other people like him that spoke his language, that he felt comfortable around. So who am I to tell him, or who is the federal government to tell him you can't be there because there's already too many of your people there? You know, that's ridiculous. But the intent is irrelevant. All right. So when it comes to advertising, here are the rules. You cannot express any discriminatory preference or limitation. So here's the category, what the rule is, what's allowed and what's not allowed in the advertising. So we could turn the page. You could see advertising on page 85. It's all in writing here, but if we turn the next page, they got it in a nice little chart too. You know, the writing, the long drawn out writing on the whole page 85 gives you some good explanations of some of the stuff, but let's reduce it to a time thing, and then I could just explain it to you in the chart here. So when it comes to race, color, or national origin, once again, the rule is the same pretty much for all of them. No discriminatory preference or limitation can be expressed. You're allowed to say things like master bedroom or good neighborhood, and those are not considered discriminatory phrases. I mean, why would a good neighborhood be considered discriminatory, or a master bedroom? How racist do you got to be that you're thinking back to slave days? Oh, the master's bedroom. You know, that's like somebody who's always got race focused on their mind. They're race obsessed, you know, a master bedroom. Does anybody here know what an actual master bedroom is on a house?
Yeah.
What's your interpretation? Because listen, there's a lot of HGTV programs even misinterpret what a master bedroom is. So let me just see if anybody
Yeah,
here.
they started saying primary now.
It's like
probably don't know the
bathroom
right.
attached to the room and then like walk-in closet or something.
It's usually the largest bedroom in the house, but look, just having the largest bedroom in the house does not make it a master bedroom. It has to have a bathroom attached to it. If you have a bathroom attached to the bedroom, it's considered a master bedroom. You can have more than one master bedroom in a house. But we always see, like on those HGTV programs where they're showing in houses and flipping houses and doing everything, they're like, oh, this must be the master. It looks like the biggest. That's not what makes it a master bedroom. But, you know, we're not going to be correcting people on TV, I guess, either. You know, we'll just, a master bedroom technically is if you have a bathroom, a full bathroom attached to your bedroom. That's a master bedroom. Not all houses have a master bedroom. Okay. So it's not a racial term, even though you get a lot of people who are hypersensitive about all kinds of terms and words, and they're doing all this the word police out there, don't want us to use certain terms anymore. But that it could get to the ridiculously stupid level. If you guys recall, it was about 2 years ago, even right here in New Jersey, they wanted to do away with the names of streets that were gendered. The names of towns, I think it was, not the names of streets, it was the names of towns that were gendered. Manville. You know, things like that, you know. And it got really ridiculous. Thank God that blew over, but you never know what the future brings. You know, there's a lot of idiots in the newer generations that are coming up. No offense to the younger folks, but hopefully you're not one of those people who are hypersensitive and overly sensitive to everything. Everything's going to hurt your feelings. You know, come on, get a thicker skin. What do you want me to tell you? You know, what's not permitted is terms like white neighborhood or no French. When it comes to religion, no discriminatory preference or limitation. You're allowed to use terms in your advertisements like chapel on premises or kosher meals available and Merry Christmas. Well, wait, doesn't that discriminate against people who are not Christian or people who are not Jewish? No, you're describing a feature on the property. If it has a kitchen there that prepares meals and they're kosher meals available, you're just describing that. Or if there's a chapel on the property, on the premises, or this is just a season's greeting. You could say season's greeting, or you could say Merry Christmas, Happy Hanukkah, Happy Kwanzaa, Happy Festivus for the non-religious folks. You know, you could say whatever you like there, and it's not considered discriminatory. Come on, loosen up a little bit. You're not allowed to say things like no Muslims, nice Christian family, or walking distance to synagogue. Okay, well, first of all, keep your ads positive. How about that? Let's start off there. Keep your ads with a positive, happy smile face on them, right? Don't keep negative things out of your ads, like no. But don't say things like walking distance to synagogue, because that could be considered like either a dog whistle. Hey, there's Jews in the area because Jews go to synagogues, or it could be a thing like, oh, we're only looking for Jews, so we're targeting Jews as the audience. Or a nice Christian family. This is a Christian neighborhood, you know. You have to use more secular terms when it comes to that. Of what's in
how about local places of worship?
Yeah, instead of within walking distance to synagogue, you could say within walking distance to houses of worship. That's acceptable. It's more secular, you're not targeting a particular religion. Because look, devout Jews as well as devout Muslims, I think they both need to be within walking distance to their house of worship on their certain high religious holidays. They can't be driving. They have to walk, they can't even answer their cell phones, on certain holidays where they're supposed to, not use any work. They're not supposed to have any work. And they're everything's supposed to be healthy about their bodies and such like that. The one that God gave them, they got to treat it right and all that stuff. But either way, whatever the thought process is behind it, it's important for them to be within walking distance to their house of worship. So if you just write walking distance to houses of worship, and it's important to them, well, is that my house of worship? They'll call up and they'll ask you, well, what is that? Is that a synagogue? Is that a mosque? What is that? Is that a church?
It's houses of worship.
Yeah. Well, you could tell them
all of the above.
No, if they ask you, you could tell them over the phone. Oh,
Well,
no, that's within walking distance of this place, but but the other place that's kind of further. That's a little bit of a ride away, you could tell them and describe to them, but in an advertisement, you got to be careful because you get these hypersensitive snowflakes that are going to have a meltdown if you say it's a synagogue or it's a mosque. Somebody's going to be offended by something. You don't want to offend people in the advertisements or draw attention to those people who are looking for a reason to sue, especially New Jersey. New Jersey's full of those nutbags too. Look, you guys remember during every couple of years during the Christmas season, you see these billboards that are put up that are like anti-religious billboards, or they're atheist billboards, or they try to, in cities that have like a nativity scene, they like to rent out that place so that they could put their anti-religion nativity scene next to it. Well, that place for the non-religious folks, the atheist group that puts up those billboards all over the country. They're actually based right here in New Jersey in the town that begins with the letter B, Berkeley Heights. That's based in Berkeley Heights. That's where those people come from. So you may get the attention of some of these nutbags that'll come after you just for the hell of trying to sue you. So be careful about the wording that you put in the ads. Now, when it comes to sex, no discriminatory preference or limitation. You are allowed to say in-law suite, mother-daughter, or female roommate sought. Okay, why is female roommate sought allowed?
Say that again.
How come this term female roommate sought is allowed? Why is that permitted? Isn't that
permitted or
more direct to the gender? No.
Well, isn't that against men for gender? No, because this is a roommate, somebody who's going to live in the same apartment as you. You want to select. Look, I'm renting an apartment and I have an extra bedroom in my apartment, so you're going to be sharing the apartment with me. If you're a young woman, maybe you're uncomfortable with some strange guy coming there to rent it. You'd feel more comfortable with another woman. Okay, so it's not discriminatory to say that a female roommate is sought. But if it's just a condo and we're only looking for people of one gender or the other, that could be discriminatory unless the whole housing complex is specifically meant for a specific gender. But then in those cases, remember, if somebody self-identifies as a woman, then you have to allow it. All right, now permitted in-law suites or mother-daughter. Both of these things are described. These are two terms that describe the same thing. An in-law suite or mother-daughter is a single-family house that is set up like a two-family house, but you can't rent out that separate apartment. It's a one-family house. It's zoned one family. It's legally one family, but it has a setup with a separate entrance. a separate bathroom, etc. Okay, that's what the in-law suite is, or mother-daughter. And these are highly desirable features. And some MLSs actually have a checkbox where you could enter the listing into the MLS and put a checkbox there in the database. So when people do a search, they actually find these houses that have these features. Remember that couple I told you about where the wife came out of the shower and her landlord was standing there in the middle of her living room? They were actually looking for this type of setup, an in-law suite or mother-daughter, because the to-be husband's father was elderly, and they wanted to keep him close by where they could keep a close eye on him and make sure how he's doing. But they didn't want him all in their business either. You know, they wanted their freedom so that he's free to come and go as he pleases, and so are they. But he's close enough that that they could keep an eye on him, without him being all in their personal life and business, as they said, so that they could get their freak on without him being able to hear it. And they also said that if they can't find this type of setup, at least have a bedroom for him that's like way on the other end of the house, because they like to walk around in the nude and do their own thing, you know. So I was like, all right, I got it. Now, not permitted is a great house for a man, or a wife's dream kitchen, a man cave, or she shed. You can't use those terms in advertisements. Now, if I'm having a conversation with you, that's different. Like, we could go down, I'm showing you a house and I'm showing you the basement, and I could be like, yeah, wow, this would make a great man cave down here. You could set up the pool table here, or set it up like a movie theater, or set up a bar down here. Anyone know what a man cave is? That's a place where the guy can get away from the family for a bit and enjoy his space down there with his buddies and his pals, you know, set it up as a bar, or put a dartboard or a pool table down there, or set it up as a little movie theater or something. It's where the guy can get away from the family for a little while and have his own separate space. And similarly, a she shed is the same type of scenario, where you could have a shed that has electricity and heat and all that stuff, perhaps, and the wife, maybe that's her getaway place. Now, it doesn't all have to be about wife's dream kitchen. Why not a man's kitchen? Why not just the dream kitchen? How about that? It doesn't have to be genderized. Keep the gender out of it. Or great house for a man. What about a great house for a woman, or one of the other 5,000 genders? So, let's look at the next slide where they talk about the she shed. I actually have a link to it here on YouTube, but let's, anybody ever see this commercial before?
Well, it finally happened, Zachary. Somebody burned down my she shed. Nobody burned down your she shed, Cheryl. Well, my she shed's on fire. The she shed was struck by lightning. Zachary, is my she shed covered by State Farm?
Your she shed's covered, Cheryl.
You hear that, Victor? I'm getting a new she shear, she sheds. She shear? Mm-hmm. That's wonderful. That was the one that's here?
Now that's a hell of a she shed. She got a chandelier in there. You see that layout? What a pad she had there. All right, so that's a she shed. Now, when it comes to disability, no discriminatory preference or limitation can be expressed. You are allowed to use in your advertisements the words wheelchair ramp, walks to shop, walk-in closet, jogging path, or walking distance to, and it's not considered discriminatory against people who can't walk, okay? You're just describing a feature. It has a wheelchair ramp, or it's within walking distance to shops, or walk-in closet. What is a walk-in closet? It means that it's a large closet. That's all that means. Okay, but it's not discriminatory. You're just describing features that this has. Now, what's not permitted are things like no wheelchairs or able-bodied tenants only. First of all, that's negative. What did I already tell you about that? Keep your advertisements positive. You know, if something is not handicap accessible, you know, I wouldn't even put in there it's not handicap accessible. You know, instead, here, let me give you an example. I had a condominium, a condo unit. It was a 3rd-story condo unit at the Waterford in Edison, that I had as a listing to sell. And, I put in the advertisement, I described it as a 3-story walk-up. So I actually had a guy that called me up who was wheelchair bound, although he could not 100% of the time, he could stand and walk a little bit. You know, he had difficulty doing it though, but otherwise he was bound to the wheelchair. So he actually he caught on to the wording I used, and he called me and he asked, he's like, well, I'm kind of confined to a wheelchair, although I can get up and stand, I can walk up a step or two, but that's about it. Is there a way that I could put in a ramp, or is there an elevator available in the building? And I was like, yeah, no, unfortunately there's not, because it's a winding staircase there, and there's the distance in order to have a ramp there, it would be impossible to do. If that's important, what I could look for you, so this unit may not be good for you. I was like, but what I could try to do is I could try to see if there's a 1st-story unit available for you, and then that would be better. So what is it you're looking for? Where are you looking? I'll look in this complex and I'll look in other complexes nearby. Let me know your price range, what you're looking for, and I'll look for something that's handicap accessible or something that's on the 1st floor, which would be better for you. And now I didn't lose that person as a client, because if I just said in my advertisements, no wheelchairs or able-bodied tenants only, or not handicap accessible, the guy would never have called. Instead, I said 3-story walk-up. You get somebody who that's important for them, that they need to find out, like this guy, he called up and he asked. And then I ended up getting him as a client so that I could show him properties. Don't lose out on the clients because of some nonsense like this. Don't keep your ads positive. Don't use that negative wording, and get people like what I consider negative. I don't even like sold sign riders on real estate signs. To me, I think that they come off negative, under contract and sold sign riders, because that chases away potential buyers from calling up because they don't want to get involved in bidding wars. Right. So up until the property is sold, I'll leave the sign up there. There's nothing in the law that requires you to put a sign rider on. But if you're going to do it, it has to accurately reflect. So I just don't like putting sold or under contract sign riders. I'd rather have the sign stay up there as long as possible and still have people call. And then I'll be like, well, when they call, I'll get all their information and then I'll let them know, oh, well, this property is already under contract. It hasn't closed yet, but it is under contract right now. But if you want, I could help you. I could help you find another home in the area. And if this property comes back on the market, I could always let you know. But in the meantime, what is it that you're looking for? Maybe I could help you find something. I could show you any house that's available for sale. Doesn't have to be listed with my company. I could show you any home that's out there. So if you come across any properties you may be interested in, call me. I can be your one point of contact and let you know. And now they're not calling every agent that's out there, and they're reaching out to me. Don't chase away clients. Keep things positive. Your job is to build up business, get as much business as you can, right? Now, when it comes to family status, no preference or limitation on family size. 2 bedrooms, family room, quiet neighborhood. How does a quiet neighborhood relate to families? I don't know about you guys, but families are loud. 2 bedroom, family room, quiet neighborhood, you're just describing features. What's not permitted are things like married couples only, no more than 2 children, retirees dream home, or no young children. Look, even if it's an age restricted thing, 55 plus community, don't put down things like retirees dream home or no young children. That's negative. No more than 2 children, negative. Even if the town has an ordinance that you can't have more than 2 occupants per bedroom, what's to say that it's not a single person that has a kid or 2? Be careful on your wording. Married couples only. Why? What's wrong with single people? That's discriminatory. Okay, we already went over her she shed here. And Over that. Okay, now let's talk about testers. HUD has these undercover mystery shoppers we call testers. They act like they're volunteers. They're undercover volunteers that are trained by HUD. HUD teaches these volunteers, who are like the social justice warriors of real estate, I guess. They test licensees. They pretend to be buyers and renters to see if you're treating everybody equally and the same. They may use like hot button topics and use words that are discriminatory to see if you chime in on them and you accept them and you start engaging in that discriminatory banter with them. And then later on, they end up filing charges on you. You know, so you got to be careful about the wording. You never know with whom you're dealing with. So treat everybody the same. That's why they have these testers, because it works. But they're not employees of HUD. That would be entrapment. The reason why it's not entrapment is because they're undercover volunteers that are trained by HUD, but they don't work for HUD. So they could be the same sex or gender or race as you, the same sexual orientation, same nationality or religion, or the opposite. Okay, you never know with whom you're dealing with. Look, I've dealt with people before. I had this one young Black girl that met me at a house that I was selling in Roselle. And we set up the appointment. She got there a little bit early. She was there before me. She already got to check out the yard and the property, which was beautiful. It was a really big property. And the guy really took great care of the house. It was a nice house. So we get inside. She loved it. She loved it. She loved it. So after I was done showing it to her, I'm putting the key back in the lockbox, and while I'm doing that, she's talking to me about the housing and stuff. And she was like, yeah, when I was on my way here, I currently live up someplace in North Jersey. She's like, I had to come off the Parkway, and then I came around here. And she's like, you know, I love the house. I love the property size. The property size is beautiful. I love that. And the house, wow, it's so well maintained. She's like, the only thing I didn't like is when I came off the Parkway, I had to drive through this neighborhood over here. And I had to drive by a couple of fast food places. And so now she's starting to throw out some of these kinds of stereotypes, the way she was wording it, like stereotypes against Black people, you know, like, oh, I had to go drive by all these fried food places. And she's like, and then I had to go through this neighborhood, which there was too many Black people there. All it was Black people. She's like, and this is like, keep in mind, this is a young Black girl. And so now I already got the key in the lockbox. So I lean up against the other railing, you know, on the front porch, and we're looking at each other, and I'm just like eyeing her up. I'm just like listening to what she's saying, and I'm just eyeing her up, and I'm like, okay, I got to be getting punked here or something, because this young Black girl's throwing out like every kind of racial stereotype you could imagine against Black people, and I can't believe what I'm hearing right now. And she's like having this matter-of-fact conversation with me. And I'm just like, she's got to be a tester. Like the whole time I'm thinking like, this girl, she's trying to punk me. Or she's got to be a tester. What the hell is this, you know? And so I'm not chiming in on her conversation at all. I'm just letting her do all the talking, you know? And I'm just like, you know, as it turns out, we ended up progressing with our conversation, and I started asking her questions in a different way. I tried to change the direction where this conversation was going, the way she was talking. And as it turns out, she was a very nice girl. She just didn't know how to express herself, I guess. She was going through a lot of stress at the time. And she actually ended up being a client and ended up buying a house from me. Now, at the beginning, I thought that she was just punking me out with all this racial banter that she was throwing out there, or what sounded racist to me. It turns out she was going through a lot of stress. Both of her parents just died in a car accident. And then she had two younger twin sisters that she became the instant parent for, that she had to care for them. And although she had a good job, she wasn't making as much money as her parents were, so couldn't maintain that lifestyle and that home that they used to live in. So she had to move, and she had to buy a house. And so she's under a stress with the timeline to get another place and get out of where they were at. And dealing with the parents who just died and all this, it was a lot of stress that she was under. And, so I ended up helping her find out what she was looking for. But the way that her thoughts were coming out of her mouth, they just didn't sound right, So be patient with people too, don't automatically assume that the person's a tester and that they're trying to punk you or whatever like that, I could have just been like, all right, screw this girl, I'm out of here, but I stuck with it. I listened to her and I got an idea of where she was coming from. And then I started talking to her, she was looking for a diverse neighborhood, and all that stuff, but she just wasn't saying it right. But either way, I told her, I can't look for homes based on who lives in an area. I could show you homes in different areas if you got an idea where it is you want to be, but you'll have to, when I show you the homes, you can look in the neighborhood, see if it's an area that you feel comfortable with. But I can't really search for homes based on who lives in an area and all that stuff, and she just wanted to have something similar to where she was up north somewhere. She was in a very mixed neighborhood that was wealthy, and but she couldn't, she wasn't wealthy, like her parents were making a decent buck. All right. Anyway, testing. Let's highlight testers or checkers are undercover volunteers who want to see whether all customers and clients are being treated the same. I guess that could give it, leave it at that. And the reason why it works is because you never know with whom you're dealing with. I've had plenty of people that called me up and made inquiries about property. They wanted me to search for homes for them and all that. Then all of a sudden their phones are turned off, their emails are bouncing, that are not working anymore. Maybe they were legitimate, maybe they were testers. I don't know. That's the whole thing behind this. You don't know. You don't know who you're dealing with. So it was never brought up on any kind of charges for anything. So apparently I never did anything wrong. So thank God for that. All right. So everybody got that highlight, and we're done with this chapter. Let's do the key terms to review for this chapter then. And before we get started with the key terms to review for this chapter, go down to letter G in the key terms. And next to letter G, where it says moderate income, right just above that, low. So that also includes low income. See, over here, they excluded low income altogether, and they just put moderate income now. Write the word low just above moderate. And then next to letter I, cross out the first word that says benign. The word benign means there's nothing wrong with it, but all discrimination's wrong. So let's cross out the word benign. Benign means there's nothing wrong with it or that it's harmless, but all discrimination is wrong. All right, now let's get up there to the top and let's do refusal to lend in certain areas, usually inner city.
F. Oh, I'm sorry.
No.
I'm so sorry.
The answer's on the right side.
I'm so sorry.
That's fine. Give me the number that it corresponds to on the other side. So refusal to lend in certain areas, usually inner city.
Redlining?
9 is A, redlining. Inducing panic selling based on prejudice.
Blockbuster.
2 is B. A federal law, the protected classes are race and color with no exceptions to it.
Civil Rights Act.
Do they have more than one listed here?
Fair housing.
The Civil Rights Act of 1866. Okay, 3 is C. Section of this Federal Civil Rights Act that covers housing.
Federal Housing Act.
There's a key word here. Section of the Federal Civil Rights Act that covers housing.
Section. Law against discrimination.
What section of the Federal Civil Rights Act covers housing?
The law against not discrimination.
Title 8.
Title 8. Title 8. 13 is D.
13 is D.
Yeah.
Oh, okay. That's a good one. Now I gotta go look at that.
Channeling home seekers to or away from certain areas.
Steering.
Hearing, 11 is E. The statement about discrimination everyone listing property must receive.
Attorney General's memorandum.
1 is F. Court cases covering low and moderate income housing.
Court case. That would be Mount Laurel 1 and 2.
7 is G. Specific group that may not be discriminated against.
Protected class.
8 is H, a protected class. Discrimination intended to correct past wrongs.
Law against discrimination.
Reverse discrimination.
Reverse discrimination, 10 is I.
Okay.
Federal agency enforcing civil rights compliance.
Department of HUD. No.
Yeah, Department of Housing and Urban Development, which is HUD.
Okay.
4 is J. Undercover checker who monitors fair housing compliance.
Tester.
That's a tester. 12 is K. New Jersey law governing discrimination in real estate transactions.
Law against discrimination.
Or the LAD, correct. 6 is L. And a federal law setting many protected classes, but it has some exceptions to it.
Federal Housing Act.
The Fair Housing Act of 1968. 5 is M. All right. All right, let's move on to chapter 5. Now we're finally going to get into real estate. So far, everything we've been learning is about advertising, rules and regulations, licensing, licensing renewals, fines, discrimination. Now we're finally going to start learning some stuff about real estate. You know, even though I did inject when we were talking about the other stuff, I started injecting some stuff about real estate already and bringing up and talking about real estate. Now we're actually going to have topics that are focused on real estate. So it should be getting more interesting for you. So hopefully this dry material is going to get more interesting and you'll enjoy it even more. But don't forget the first couple chapters, those first 4 chapters we went over, loads of question on the school and state exam about. Okay. State exam is going to be kind of heavy on questions from those first couple chapters. Just a little tip for you. So what is real estate? Pretty good question for a real estate class. In this chapter, we're going to talk about the characteristics of real estate and what exactly is real estate. We're going to understand the differences between land and real estate because there are 2 different terms that are often used to describe the same thing, but they do have distinct differences between them. We're going to distinguish between the characteristics of personal property and fixtures as well. Now, when you buy real estate, you don't just get the land and the building and the structures that are on it. You also get the bundle of rights. You also get a set of rights with that property. So included in the bundle of rights of ownership. So real estate ownership is described as that bundle of rights along with the property itself. And those rights include the right of possession or season. That means that's an exclusive right to possess and own the property. The right to use the property in any legal manner. The right of quiet enjoyment. That means to be able to enjoy the premises without being disturbed by others. And remember in the last chapter, we were talking about landlords entering someone's property without their permission. You can't just use the key to walk in because the landlord transfers all of these rights to their tenants for a limited period of time during that lease. That includes the right to quietly enjoy the property and not being disturbed. the right to exclusion, to use the property without having others entering or occupying it, and the right of disposition or alienation. That's to be able to sell the property, give it away, lease it, or transfer the rights to another person. Now, when you're leasing a property to somebody, you're not giving them the right to dispose of it or to alienate it. So the word alienation, to be in a simplest form, is basically a transfer of property. And this could occur while you're alive or after you die, you could transfer that property. Voluntary alienation is something that you want to do by your own will. You want to sell it, give it away, devise it, lease, license, or dedicate it. All right, what is devise? It's a transfer of property by will. Upon death, you could dictate who's going to get it. Dedication is when you give land to the government for greater public good. And then we have involuntary alienation. Some forms of involuntary alienation is when the property, when the property is taken from you involuntarily, you don't have a choice, like in foreclosure or escheat. Escheat is if you die without a will and no natural heirs can be located, the state will take your property. So you didn't dictate who was going to get it. So that's involuntary, even though it's after your death. A partition proceeding, which is a court proceeding where one co-owner sues the other, forcing them to sell or divide the property. Or a suit for adverse possession. This is where, sometimes known as squatters' rights, this is where somebody may sue you to claim ownership of the property that they've been adversely possessing for a period of time as defined by law. Within these rights are further rights to improve or devise, that means to leave by will, mortgage, encumber, cultivate, explore, mine, build, lease, license, dedicate, give away, abandon, share, trade, or exchange the property. So let's highlight that real property ownership is often described as the bundle of rights. And when a person purchases a parcel of real estate, they're actually buying the rights that were previously held by the seller. Now, if somebody owns a property and they're selling it, could their rights already have been limited in some way, shape, or form? Yes. I've given you guys an examples that when you sell your property, you could put a restriction on how somebody can use it. So that's more often used in commercial real estate, but it can also be done with residential. But it's more common in commercial, like when a gas station sells one of their properties, they could put a restriction that the property can never be used as a gas station again. Or they could say it could be used only as a gas station again if it's like if it's Shell Corporation that's selling one of their gas stations, they could put a restriction that it could only be used as a Shell gas station. They don't want a competitor moving in there, just as one example. And within these ownership rights are included further rights to improve or devise, that's to leave by will. And then give the little cross reference of page 374, because that's where they go over the word devise in chapter 20. Good. I don't know why it muted there. Can you guys hear me again?
Yes.
Yes.
Were you not able to hear me on the previous slide? I hope you were.
For a minute you were out, but we heard you. Well, I heard you from the.
You guys heard me explaining all this stuff though, right?
Yeah.
Yes.
Okay. So real property ownership is described as the bundle of rights. You could also devise the property to leave it by will, and page 374, that's chapter 20, where we'll discuss those, what happens to your property after you die. And here are some of those death terms that are in chapter 5 here that we're going to discuss in chapter 20. But I put together this list of terms for you. We're going to go over these terms now, but they're also going to be gone over when we get to chapter 20. Usually right now is when I just skip over to chapter 20 and then I come back to chapter 5. But what we're going to do is we're just going to finish chapter 5 and then we'll go to chapter 20 to do that chapter. So one chapter at a time. An heir is a natural blood relative who can inherit your belongings and lay claim to what you had while you're alive. Heir. A lot of these medieval time shows are on TV these days, like Game of Thrones and all these Reign and all these other different blasts from the past, from the medieval times. You get all these shows about kings and queens and all that stuff. Who's the natural heir to the throne and all that, right? Well, only a blood relative, right? So a heir is somebody who can lay claim to your belongings if you die, and only a natural heir can inherit those belongings and lay claim to them. Devise is a transfer or to transfer or leave property by a will. You know, the last will and testament that we make in case we die, who's going to get our stuff. Now, the word devise, let's see, devisor. So the root word is devise. That's the act of leaving your property in a will to somebody. You could name somebody to get your stuff. A devisor is the one who names someone else to get their stuff in a will. That's the person who's dying or who made the will. The devisee is the one who's named in a will to get those belongings. See, we're going to learn that words that end in OR is the one who's giving something, and the words that end in EE is the one that's receiving it. We could even talk about a lease in that regard. A lease is a document where an owner of property intentionally conveys their rights to a property to a tenant for a limited period of time, as defined in a lease. And so therefore, the lessor is the one who gives the lease, that it would be the landlord, and the lessee is the one who receives the lease, and that's the tenant. So OR is the one, words that end in OR is the one who's giving, and the words that end in EE is the one that's receiving whatever the root word is. So devise should not, demise, this word looks very close to devise. Demise is often confused with devise because there's only one letter difference there. Devise, demise, devise, demise. So people often confuse these two terms. So demise actually sounds like death, but it's not. Demise is a transfer of property by lease, whereas devise is the one that's a transfer of property by upon your death in your last will and testament. So I guess this one, you could think of it this way. The one that sounds like death is not. You finally met your demise. No, demise is a transfer of property by by lease. And every lease has a demising clause in it that says the landlord is to let the premises and the tenant is to take possession of it. Then we have testate. Testate means you prepared a will. So you may have died, but you prepared a will. Intestate, see, these are Latin terms. Usually when you see in before a word, like testate, here's testate again, but it has in front of it, intestate. It means the opposite of, like not. You did not have a will. You did not prepare a will. So testate means you prepared a will. Intestate means you did not prepare a will. A testator is a man who makes a will. A testatrix is a female who made a will. See, these terms are gendered because they're based in Latin, and most languages are gender-based. So testator is a male who makes a will. Testatrix is a female who makes a will. Probate is a court proceeding that determines who the natural heirs are, or to confirm who the devisees of an estate are, who you're going to leave it to in a will. No matter if you had a will or not, and what the assets are after the debts have been paid. So before any assets can be given or handed out, or any money of an estate can be distributed, the estate has to first go through probate when somebody dies. Probate is that court proceeding that determines who the heirs are, to ensure that a will is genuine, and to confirm that the people that are named as devisees to get certain belongings are in fact who they are, say they are. And the purpose of probate is mainly, though, to make sure that all that person's debts have been paid, because you can only pay out and leave the people in a will stuff after all your debts have been paid, mainly your taxes. Two things are certain in life: death and taxes. We're all going to die at some point, and we all got to pay taxes. Hell, you need to pay your taxes even after you die. And that's what the probate process ensures, that before any of your assets are distributed, your taxes have been paid. Now, it's important that when you make a will, you name somebody in the will to manage that will and make sure your assets are distributed according to your final wishes. And an executor is a male. It's a man that you name in a will to do that. An executrix is a female you name in a will to do that. If you did not name a male or a female in a will to be in charge of distribution of your assets upon your death, the court will appoint an administrator to do that. That'll usually be an attorney or maybe even a family member if they choose. But the court, somebody chosen by the court to take on those duties would be known as an administrator. If you name somebody in a will, they would be an executor or an executrix. If a court names somebody, that would be an administrator. Every state has their own laws of descent and distribution. Descent and distribution is the law that determines who your natural heirs are to get your assets if you die intestate. Only in the case if you die without a will do the laws of descent and distribution come into play. And they would determine who gets your stuff, which is an interesting conversation, which we'll go over from chapter 20 when we do that after chapter 5. Escheats is when you die without a will, you die intestate. And no natural heirs, the blood relatives, can be located or step forward to make a claim to your estate. The property would revert to the state. Yes, the state of New Jersey would take your stuff. They'd sell it at auction and they'd keep the money. So if no heirs can be located or step forward, if you die without a will, the state is just going to sell everything. They're going to sell the property, all your property you have, and they're going to put that money in a fund. And they'll keep that money in a fund for 1 year, in which time any natural heirs can lay claim to it. If nobody steps forward to claim it, then the state will take the money, and they call this process escheat. Or you can look at it this way: the state has cheated you out of your money. They're not cheating you out of anything, but that's how they get it, through the process of escheat. Now, the legacy is your personal property that you've amassed during your lifetime. That's a legacy. The legacy is all your property that you've amassed during your lifetime while you're alive, your legacy that you're leaving behind to your heirs. And a bequest are your final wishes of who you wish to get your stuff. So the legacy is a gift of personal property after death. It's what you left behind. Or actually, the legacy is the personal property that you left behind, and the bequest is your wishes on who you wish to get it. I bequeath to thee my vast fortune of $4 in my bank account. Okay, so my legacy is $4, and my bequest, that's my wishes on who I want to get it. Everybody with me still?
Yeah.
Yeah.
Awesome.
Yeah.
Now, dower and courtesy, these are ancient rights, particularly in New Jersey. Dower and courtesy is an ancient right in which, in this case, dower is an ancient right in which the wife has certain interest in her husband's death for any real estate that he owned during their marriage. Courtesy is a similar right that the husband has in any property that the wife owns during their marriage. So New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. They abolished the creation of any new dower or courtesy rights. But what about any existing ones that may have already existed before then? Well, then they're still in effect. They did not abolish existing rights. They just abolished the creation of any new dower and courtesy rights. So basically, if you were married before May 28, 1980, you and your spouse have dower and courtesy rights. Your spouse has a marital interest in all the property that you owned before you died. And courtesy is that similar right that the husband has. Now, how do you remember which one is the wife's right and which one's the husband's right? I got this way of remembering this. Dower begins with a doe. Anybody know what a doe is? A doe is a deer, a female deer. Okay, that works for me. That's how I remember it. Okay, and courtesy, because men should be courteous to women, is the man's right. So that's the way I remember it. Dower begins with a doe, and a doe is a deer, a female deer. So that's the female's right, the wife's right. And courtesy, because men should be courteous to women, is the man's right. That's how I distinguish the two. Remember them. And as far as the date goes, you just need to memorize the date. May 28, 1980 is the date that New Jersey abolished the creation of any new dower or courtesy rights. You will need to know this for exam. Now, marriages after May 28, 1980, if you're married after that date, your spouse only has a right to your primary marital residence, but not all property that you owned before this date. So they only have an interest in the primary marital residence. The other house you could leave to your girlfriend. Just kidding. All right, now New Jersey used to be a part of this website, missingmoney.com. You guys may have heard of it before. This is a website that's actually managed and run by the federal government. It's free to use. And New Jersey used to be a part of it. They no longer participate. They claim they created their own version of it. So instead of any money or like if you had a savings CD that matured and you never cashed it out, it had to be turned over to the state, and then the state will list it in missingmoney.com. Well, New Jersey does not participate in this website anymore, but other states do. So you could still search missingmoney.com for your name or your relative's name to see if there's anything due to you or your family members from other states. New Jersey has their own version of this website now called unclaimedproperty.nj.gov. This is like New Jersey's version of the missing money claims page. So if you have a relative that died and didn't have a will or heirs and the state sold the property at an auction, and they're waiting for some heir to step forward and lay claim to it, you could search this database to see if that money is waiting to be claimed. But there's also money in there for things like savings CDs that weren't cashed out, or bank accounts that were closed that had money in them because of inactivity. The banks turned it over to the state. The state has to hold on to it for so many years, depending on what it was for. If it was because of an escheat thing, that money is held there for 1 year. If it's because of a bank account thing, well, it could be anywhere from 6 to 10 years, depending on what it's for. So just be aware of that. But this is the one New Jersey engages in. Here, I'll even open it up for you, and I'll show it to you. Missing unclaimedproperty.nj.gov. I tell everybody from every class to search their name, their relatives' names. You may find that there's money due to you or your relatives that they're unaware of. Usually every class, I have at least one student that finds something for themselves or their relatives. So, and it's free. They should never, for these websites, you should never be asked for a credit card or anything. Otherwise, you went to the wrong place. Like I once had a student that went to Google, and then they typed in the website address in Google, and the first results are like paid advertisements, and they clicked on one of those, and then it asked for the credit card, and she gave a credit card, and they billed her $29 a month, and I'm like, oh no, you never give any credit cards or personal information or anything like that. Okay. That's just type in the website, go to it directly on itself. Okay. So this is the website that it'll forward you to. nj.gov/treasury/unclaimed-property, or from the actual link here. Let me copy it and share it with you. Here's the shorter link to it. It's unclaimedproperty.nj.gov. Here, I'll also give you that federal one too. Missingmoney.com. I'll put that in the chat window for you guys. Okay, so everybody sees the website, Missing Money, Unclaimed Property Administration.
Yes.
So in here, you could just go search for unclaimed property, put your name in there. Let's see, I'll click on it. You put your name in there, put as little information in there as possible, see what comes back. Put your last name in there, maybe put your first name, or you could just put the last name and then scroll through all the results that come back. Unless you got a common last name, then don't do so. Put in your last name and then maybe the first name of you or your relatives, and see what comes back. Okay. You don't need to put in city, zip code, or any of that, but if you want to narrow down the results a little bit, you can. But like I found information and property from uncles and such in here. And then if you do find information, it could tell you what it is off the bat and how much money is owed, or how much money is owed to you. That's you're entitled to claim, and you could file the claim here as well. Sometimes they tell you what it's for, sometimes they don't. Sometimes they tell you how much money it is in advance, sometimes they don't until you actually put in for more information to file the claim after you confirm, yeah, this was my relative. Okay, and let me know if you find anything there. Okay, I only charge a 10% finder's fee. Kidding. It's a joke. But do share it with the class anyway. Thank you. Do share it with the class if you do find something. I like to see when people find money that's due to them. Better than the state getting it, right? All right, now let's talk about land. Land refers to the Earth's surface, including the water and anything permanently attached to it by nature. Everything extending downward from the surface to the center of the Earth and upward to infinity. This includes the subsurface rights, air rights, and water rights. A parcel is a specific tract of land with legally defined boundaries. Okay, so it's a piece of land where the land has been measured out, the boundaries. You know, it's 50 foot wide by this direction, then you go that direction for so many feet, then this direction for so many feet. So basically, when a surveyor's measured out the land, it has legally defined boundaries because it's been surveyed. That we refer to that as a parcel. Real estate has the same definition of land, but it also adds in all man-made improvements. Okay, well, what is an improvement? Improvements include both buildings erected on the land, as well as streets, utilities, sewers, and other manufactured additions to the property. So let's highlight on page 94, and this is from 95, the definition of land and the definition of real estate. Even though this isn't the full definition of real estate here, they're just giving you the definition of land plus man-made improvements, and then they talk about what an improvement is. I got a better definition for both of these on another slide after you got these stuff highlighted. Let me know and I'll turn the slide.
Got it.
Okay, everybody good?
Got it.
Almost done. I'm done.
1 second. I'm good.
All right.
Yeah, I finished.
So on this slide, you can see my drawing skills. No, this is not somebody's bald head with a hand or arm growing out of it. This is the surface of the earth. It's supposed to be the planet. That's not a rocket ship, that's a house. So the term land and real estate are often used to describe the same thing, but they do have important differences in their meanings. Land is the surface of the earth, including water and anything permanently attached to it by nature, which does not require annual cultivation because you don't have to plant the seeds every year in order for it to come back, like grass, trees, and bushes, and everything below the surface to the center of the earth, and everything above it to infinity, and all the rights, interests, and benefits that go with it. In other words, the benefit of rights, the bundle of rights. So this is the definition of land: the surface of the earth, everything permanently attached to it by nature, like trees, bushes, and grass, everything from the surface to the center of the earth, and everything above it to infinity and beyond. Does that mean that you could prevent a plane from flying over your property? No, because the FAA has exclusive jurisdiction of everything over 500 feet above the highest point over your property. That's the Federal Aviation Administration. Now, real estate can be described as land, the same definition, land, plus man-made improvements, plus all the rights, interests, and benefits that go with it, the bundle of rights. Another way to say that is real estate can be described as land plus man-made improvements plus the bundle of rights. Okay, you guys need to be able to distinguish the two, land from real estate. Real estate is the same definition of land plus man-made improvements and the bundle of rights. They go with that ownership. A corporeal asset. You guys are familiar with the word tangible? You ever hear the word tangible in your lives? Something's tangible, intangible.
Yeah.
Yes.
Tangible is something you could touch. You could touch it, you could feel it. It's tangible. I could touch it. I could hold it in my hand. It's tangible. Intangible is something you cannot touch because it's more like it's related to your feelings or your rights. So another word for tangible is corporeal. So a corporeal asset is a tangible asset. It's something you could touch or feel, like buildings and trees. An incorporeal asset is another word for intangible, something you cannot touch or feel. It's like views, like a beautiful mountain view or ocean view or lake view. And it also describes your rights. So do these things have value even though you can't touch them?
Yeah.
Absolutely. Having a beautiful view could definitely increase the value of your property, even though you can't touch a view. Your rights, I hope you value your rights as well. You can't touch a right, but I hope you value them. We have plenty of former relatives probably that were in the military that died over the years in this country to fighting for your rights. And then we have a lease. Let's take a look at a lease for a second. A lease is considered to be personal property that is an intangible asset. Because you either own real estate or you don't. And when you're leasing property, you don't own real estate, so it's not considered real property. It's considered personal property that you have the rights to occupy someone else's real estate. Make sense? So a lease is considered a personal property asset that is an intangible asset. It symbolizes your rights to occupy someone else's property. So although you can touch the paper that the lease is printed on, the lease signifies the rights that a tenant has to occupy and possess someone else's property for a limited period of time as defined in the lease. So a lease is an incorporeal or intangible asset in that regard. It's personal property because you don't own the real estate. And it's an intangible asset because you can't touch a right. And that's not how you spell touch. You cannot touch a right. All right, I guess we'll leave that off right here. We're already over time, 4:35. So let me